We're just waiting on some other members to arrive. Traffic is a bit bad coming into town. So as soon as everyone is here, we'll start. Thank you.
Good morning. Good morning, honorable members. Good morning to our guests, all of them. We've got lots of guests today, so welcome to all of you. We won't ask you to each introduce yourselves in turn, because I'm assuming that a lot of the colleagues are here to support those who will be doing the talking. So thank you very much. We're going to do the proceedings in this way. Firstly, we're going to start with a presentation. I am going to provide some guidance on it because we're also trying to make efficient use of time. So we do need to get to the salient points as quickly as possible, so that we can get to questions from myself and from the members. But what I will do is that for those colleagues from the Road Accident Fund who have appeared before, your swearing in continues, so we're not going to do that. What I'm going to ask is for Ms. Ibrahim, a colleague from the legal department here in Parliament, to swear Ms. Gilmore and Ms. Isaacs in, explain the rules of Parliament and this inquiry and the indemnities and immunities and so on, and then we will get going. But I will provide guidance on the presentation then. Thanks very much. Over to you, Ms. Ibrahim.
Thank you, Chairperson, and good morning to yourself, to all the honourable members and everybody else present. Good morning, Ms. Gilmore and Ms. Isaacs. Before I start, we do note that your legal counsel is present with you today. To the extent that you need to confer with them, you may do so subject to the reasonable restrictions that the Chairperson may impose. Ladies, you've been invited subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, read together with National Assembly Rule 168, which affords certain privileges to witnesses, to appear before the Standing Committee on Public Accounts in connection with its inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be informed further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. Chairperson, the witnesses have both indicated that their preference is to take an oath. So I'm going to ask you, Ms. Gilmore and Ms. Isaacs, to please raise your right hand and repeat after me. And if you can kindly switch on your mic. Thank you. I swear that the evidence I shall give
I swear that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, ladies. You're now duly sworn in.
Thank you very much, Ms. Ibrahim, and thanks very much, colleagues. So the first thing I want to say is that this is not a trial, and it's also not an inquisition in the old sense. So nobody is being prosecuted here at all. You are here to assist the committee to make informed observations and conclusions about certain aspects of the Road Accident Fund, particularly where there is an expenditure implication. There's either actual expenditure already taken place or to take place, and the implications thereof on claimants and on sort of the finances of the Road Accident Fund. So just please relax. The second thing I want to say is that please mind the specialist language, the acronyms and those kind of things. So I may stop you to ask you to explain certain things. That's important because we also have members of the public, claimants, and all of these lovely people. And whenever there's been an interesting presentation here, all the members get an avalanche of either phone calls and WhatsApps and so on, and people asking a question or saying, they were lying. This is how it works, and so on. Particularly claimants, who obviously are anxious to see their matters progress. So let's just keep the language as simple as possible. I want to thank you for providing the presentation to the members ahead of time. I have gone through it a couple of times. So what I wouldn't want us to do is to spend an inordinately long amount of time on the presentation. On each slide, can we drill down to the essence? And I will provide guidance in this way. Firstly, how is the system conceived to work? What is the idea? What is it supposed to do? That's the first thing. The second thing is, what are the components of the system itself, and what are they supposed to do? Thirdly, what are the major milestones of the system, and where are you in that process? Fourth, give a sense of the capability of the system right now. And the last point is some of the project risks that in any project are there that have arisen, that you anticipate, and so on. Those 5 things are important. If we get through those, the rest of the minute detail in the presentation we can deal with in question and answers time. What I will do, once you've completed your presentation, I will ask some further questions just to pull out some of the critical questions I think are important, and then we will hand over to the members to assist us. But the first thing I'm going to ask you to get through the first couple of slides of the presentation is to just ask Ms. Gilmore and Ms. Isaacs to introduce yourselves in the context of the project. So we will accept your professional bona fides. So the long CVs are okay, but not necessary right now. We accept your professional bona fides. What we're interested in is basically just a bit about yourself, what you do in the project, etc., etc., and then we get into the presentation. Thank you very much.
Thank you, Chair. I'm Hanley Gilmore. I'm a partner within PwC's consulting division. And on this specific project, I was the engagement partner from the start of the project inception.
Good morning, Chair. Thank you. My name is Tanya Isaacs. I'm also a partner in the consulting division of PwC. I joined the project around about April last year, 2024. And my role now is the engagement delivery lead.
All right. Thank you very much. If we can then get into the presentation following the guidance that I gave. Thank you. That doesn't mean leave out something that's super critical. No. Yeah.
Chair, we noted your questions, but what we wanted to do with some of the presentation is just to provide some context, because it's quite rich in nature and quite technical to an extent. I take your note not to go too technical, and please stop me if I do. But the presentation is really in 3 sections to answer those questions. So we'll pause after each section for clarification, but happy to take questions as well throughout the presentation. So the first question we want to answer is around what role did PwC play on the project. But before we head in directly into that, we would like to just set some context and explain the solution that we've implemented, and therefore you'll be better understanding our role on the engagement. So when the RAS set out on this journey of the new claim solution, they conveyed some very critical pain points that they wanted to address in the RFP process to which we responded, and then also in the conversations after we were appointed. The current legacy system, as we understand it, is made up of a number of disparate modules and involves a high level of manual interventions and steps. so which also make the process vulnerable for the risk of fraud. They were also facing increasing legal costs, which they wanted to curb. Automating the claims process and building the controls to defer fraud and finding a solution to curb this legal cost was considered very important. Their vision was to ultimately pay claims within 120 days of registration. This is a very large and complex transformation program with significant change, especially if you take into account the lack of investment at the RAF and systems for a number of years. I want to go on to the solution overview briefly. This ICMS solution that we proposed sought to address some of these issues. Firstly is the Guidewire solution. This is an automated claims management solution and is aimed at automating the claims management process. It is also used by another state-owned enterprise in South Africa and insurers locally and internationally. There are different modules within the Guidewire solution that are being implemented. The core is the Claims Center, which automates the claims management process from the onboarding stage all the way through the payment preparation stage. Customer Engage is the portal that enables claimants, individuals or their legal representatives to submit their claims directly to the RAF. Vendor Engage is also a public portal. This is aimed at RAF's experts when they need to lend their expertise to evaluate a particular claim. With Vendor Engage, RAF can assign claims electronically for the panel to provide, or the provider to provide their input. And then lastly, on the Guidewire side, Guidewire Predict Analytics is a module that uses machine learning to analyze claims for future insights into the claims and potentially enable predictive capability. The second part of the solution is Updraft. Updraft is a legal claims resolution platform which analyzes the details of the claims from a legal perspective and apply the relevant case laws to determine the liability apportionment of the claim. This part of the solution incorporates relevant South African case law and precedents and has been developed over the last 7 years. It allows the user to input relevant details about the nature of the accident. The solution then uses artificial intelligence to extract and apply the right legal claims as it may be relevant to each of the claims and make a apportionment determination. The aim is to achieve early settlement with the claimant based on a fair and equitable approach and to determine the liability apportionment. And in doing so, it lowers the need for claims to be litigated. The Intelligent Digital Platform, or IDP, is the data or analytical platform where all data insights and reporting is done. So although these are 3 solutions, they are fully integrated, hence the name Integrated Claims Management System. To demonstrate very quickly how the system applies through a claims life cycle and at which part of the process the ICMS system handles this stage, I'll just walk through the claims life cycle. As a quick step, it starts at the onboarding stage. At this stage, the claim is received, assessed for compliance, captured, and then verified. Once it passes through the onboarding criteria, it heads to the merit stage. The merit stage is where the system uses embedded case law to determine the apportionment of liability. When you see a demonstration of the system a bit later, you will observe how the solution takes the merits consultant through a decision tree to determine the important facts of the claim and the nature of the accident. If the claim is an injury claim, it will then head to the medical review team. If it is a personal injury, the medical review team will confirm whether the injury is as a result of the accident. Alternatively, they will review the supplier invoices for supply claims as a result of the injury. After the medical review, it heads to the adjudication team. In this stage, the quantum of the claim is determined. The ICMS does not determine quantum. The RAV has established method for determining quantum, including actuarial valuations. Here, the team will use the ICMS to review the details of the claim for the quantum determination. They will input the results of their calculations into ICMS so that the claim can proceed to the offer stage. Once the offer stage, the ICMS collates the quantum, applies the apportionment determination, collates the relevant case laws, and drafts an offer letter to send to the claimant or their legal representative. And once agreement is reached, the claim is processed to payment request stage, from where it will move on to SAP, where the payment will happen. As we stand here, Chair, I just want to make note that the solution is configured based on the RAV1 claim form, which we understand the validity of which is currently subject to the legal dispute and currently before the Supreme Court of Appeal. When the project kicked off in November 2022, the RAV claim form came into effect on the 1st of July 2022. So therefore, it was the applicable form to use at this time. But before doing so, PwC seek independent legal advice on the matter as to whether it was appropriate for us to configure the solution using this form and the validity of it, given that it was currently contested in court. In summary, the advice we received was that the High Court's decision, which found the RAV1 claim form or parts of it to be invalid, are indeed suspended. The matter are currently before Supreme Court of Appeal for the determination. So to the extent that a claim form published by the Minister or further adjustments are required, we have discussed with the RAV what changes would be required to the solution. And in effect, the changes will only impact the onboarding stage. So therefore, not a full redesign of the system would be required.
All right, thank you very much. I just want to ask a question because this is a critical slide. So, and Ms. Manyasha, you are the project lead, right? Okay, thank you. So you'll be able to assist us here. I just want to be certain that, can you describe from your perspective, the requirements for the fulfillment of the onboarding process in two contexts? There are claims that predate the RAV1, the new RAV1 form. And if you have an idea of the number of those claims, please let us know. The second is and how those get onboarded onto this, if they get onboarded at all. The second question relates to the new RAV1 form, the one that's applicable. Well, it's not so new anymore, but the new RAV1 form. And just list the documentary requirements for successful onboarding. So there's the filling in of the form. I'd imagine there's like the drop downs where you upload a certain documentation. In fact, there's 3 respects. So that's the second thing. The third thing I'm interested in is the process, therefore, of digitizing the files, the paper files that you guys have had on record. So if you can explain that at this stage, and you are welcome to assist as well, but you're the project lead, so if you can do that, I think it will be of assistance.
Thank you, Chair. Good morning, Chair and honorable members. I am going to request my team behind me to assist me with some of the technicalities, because this is quite a technical project.
So, sorry, can I then stop you in that sense? So everyone who speaks has to be under oath. So you need to, if that person is to speak, so I'm not disallowing it. I'm just saying in terms of process, if that person is to speak, that person needs to be sworn in by Ms. Ibrahim. Your colleagues, when they came in the first week, they were just orientating us, so they were not sworn in at all. They were helping us with understanding. So please identify that person. I'm assuming it's our favorite friend. No, it's an inside joke between the committee and him, so he knows it. So, Ms. Ibrahim, that's correct, right? So I'm assuming that would be you, right? Okay, yeah, thank you. Let's just do that, and then so that we don't interrupt you while you speak.
Chair, I must just mention it's both Mr. Kubeka and Mr. Mkabela.
That's okay. No, that's okay. They just need to be sworn in. But if there are technicalities, sure, they can deal with them. But just a simple explanation, really.
Chair, so
no, sorry. Let me see, Prime, swear them in so that we don't interrupt you again when you guys are answering.
Thank you, Chair. If I can just ask the two gentlemen to state their full names and designations for the record, please.
Rodney Mkabela is my name, the Acting Strategy and Transformation Officer at the Road Accident Fund. Thank you.
Gcina Kubeka, Internal Control Specialist at the Road Accident Fund.
Gentlemen, am I correct that I don't need to read out the rules to you again, that you are sufficiently familiar and that we can proceed directly to the oath, or would you like me to repeat it? You're fine?
I'm good.
Okay. If I can then please ask both of you to raise your right hand and switch on your mics. You can repeat after me. I swear that the evidence I shall give
I swear that
the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you. You're now duly sworn in.
Thank you.
Thank you.
Now, Ms. Manyasha, you guys can carry on uninterrupted.
thank you, Chair. The first thing I must mention is that when we implemented the system, there was data migration that was done on claims that predated the implementation of the RAF1 form. On claims that came after the implementation of the RAF1 form. So those claims were migrated to the new system so that they can form part of the new process. With the new RAF1 form, there are requirements that are set out for each product. I think later when we do a presentation, we will show you the products. We've got a funeral benefit that requires a certain category of documents. You've got loss of support that requires different documents. You've got general damages that requires separate documents. And Chair, in terms of digitizing the paper that we already have in our offices. I think the previous SCOPA in the previous time they came to our offices saw a lot of papers. The intention is to digitize that. It's unfortunate that there's one member responsible for digital IT, I'll call it ICT. There's different names at the RAF. But there is a whole project that is meant to digitize all those papers to put them into an electronic version. Chair, I think that's an overview that I can give at this time. But if my colleagues at the back think that I've left something out, they can add.
No, thank you. You've been off assistance. There's just a small aspect. I do need to just get a sense, and it doesn't have to be you answering. It can be one of your colleagues. I do need to just, it's for the rest of our work as a committee, not necessarily for this, because we tried to canvass this point yesterday. I think the funeral part is simple, right? So what we want to know is the documents required for the quantification of the bigger amounts, the damages, the loss of future income, future medical expenses. I think those are the three big ones, right, in your universe. Am I missing another? Loss of support? Thanks, Ms. Potgieter. Loss of support, those four. So can you just, at a high level, list what documents are required for that?
Mainly, Chair, for loss of earnings, we will require a salary slip. We will require an actuarial report for us to be able to calculate quantum. For a death benefit, we require a death certificate, and accident report also is one of the main documents that we require. I think in the main, those are, and proof of, if people are claiming for loss of support, they need to prove that the person was my father or my mother that has passed away.
Okay, so I'm assuming, so your medical reports, your medical legal reports you'd need. So for the bones is your orthopedic specialist report. For your head is your neuro-related specialist, etc., etc. So you need to have all of that ready together with the accident reports, the hospital reports, all of that at stage 1 for a successful onboarding. Right, okay. Is that the point at which it's called it, at which then the person gets what is called a link number? So you will get a link number, okay? I'm just trying to cross-check our previous conversation. So if you don't have all of those, is a point of substantial compliance, or you have to be fully compliant in order to get to be onboarded at all? So in other words, if you're missing 1 or 2 medical reports, are you onboarded or not onboarded?
Yeah, good morning, Chair, and the members. Yeah, I think in terms of that substantial compliance thing, what we've done with the new solution is we want everything up front, Chair. So we want you to be fully compliant for the claim to really progress forward to the next stages.
Okay, no, thank you. That's very helpful. Okay, thanks very much. Members, you don't have any questions? You're happy? Okay, thank you. Oh, sorry. Honorable Nelme?
No, thank you, Chair. I just want to get my questions because as a layperson, there was some, okay, in the technical terminology that you mentioned earlier, it says here, does not determine quantum. Can you just explain to the public out there and ourselves, what do you mean by that, quantum? You talk about quantum, but as a layperson, we don't quite understand what that means. Because you're saying the quantum data. What actually does quantum mean? And then the rest of the questions I have will follow.
Quantum means it's the value of the claim. So after the apportionment has been determined, the quantum calculation actually happens outside the system as well. So the RAF is using various actuarial valuations, which is not a function within the ICMS. So once it gets to the position to actually say what is the offer, it happens the actuarial valuation will happen outside, given the information that comes through the ICMS system, and that actuarial valuation will then determine the value of the claim, which will then be put back into the system to say this is the offer or the value of the claim that needs to be put forward towards the next step.
What is the definition of quantum? Because I think that's what we want. Just tell me the definition of quantum.
Basically, the value of the claim. Thank you, Chair. Just 2 more points before I move on to the role of PwC versus the RAF. The AG has found, has identified in the medical review stage that they indicated that there's still a number of manual processes outside the system. This is correct. As you will see in the demo later, the ICMS system is only designed as a claims management system. Over the course of the project, we have had to clarify the scope of what this system is capable of and what it is designed for. And the medical review team determined a quantum with 2 areas, or medical review team and the determination of quantum, with 2 areas where this principle had to be applied. as I just explained on the quantum, but let me talk about the medical review. The medical review, the ICMS system can gather medical information, such as the ICD-10 codes, diagnostic codes, types of injuries, loss of earnings and information, and the details of medical personnel and the details of medical treatment. However, what it cannot do
with the system today. Now, I wanted to just ask for your help on the jargon. ICD-10 codes and a couple of things. Can you just say what those are?
Sure. Within a medical claim, an ICD-10 code is the treatment code or the condition code that will be used in terms of what is the injury. Okay. So, with working with the medical team, defining those requirements, we realized that the requirement is rather needing a clinical management system rather as part of the claims management system. So for this reason, the medical management process was de-scoped, and the RAF is rather considering the procurement of a separate clinical management system that can be integrated with the ICMS at a later stage.
Okay, you and I need to walk together through this part, right, with the terminology. Okay, so let's start again. Can you just so when you say clinical, you mean issues relating to medical treatment? Okay, describe what happens manually with these matters first, and then it will explain what the system is supposed to do. Otherwise, we all get, I think I get you. I don't want to think though, I want to get you. Okay, yeah, so can you just describe the actual process outside of the system, and then I think we'll get a sense of what the system then transforms and digitizes.
So, Chair, it is specifically the treatment protocols that is needed for that injury that is happening outside the system, which is typically coming in a clinical management system rather than in a claims management system. So although the information can be captured within the ICMS system in terms of the codes, the injuries, etc., the clinical management or the treatment protocols is what happens outside the ICMS system.
So these would be interventions, and please, colleagues, you are happy to. I just want us to be quite clear. And if you remember when you were here, we kept fighting with your colleague about using femur instead of leg. So this is super important. So let me tell you what my reading of it is. So this relates to the RAF covering medical treatment costs of a claimant. Depending on the injury, the treating doctor or specialist has to examine the person, make a professional judgment as to the type of interventions required in order to get that person to full recovery or to maximum recovery. And therefore the system is not able to make those judgments on behalf of a professional. And therefore the professional has to look at the patient, make the assessment, and then the outcome can then be recorded. And therefore, that's what you're saying. Okay, it's that language that I'm asking you to do.
Chair, you're better explaining than me. So, last point is just on the guidewire and updraft solution being configured to counter fraud. For example, one of the RAF's concerns were alleged relationships between the regional base teams and the claimant's legal teams. So to counter this, one of the controls that we built into the solution is a feature called national assignment. For example, let's assume the adjudication team has determined the quantum of the claim. The solution then gets assigned to that claim to an offer management team rotationally at a national level. A claim is thus not dealt with end-to-end by the same region, which prevents any collusion within claim, the processing of the claim. So now that I covered quite a lot of the context and the solution, I want to move on to the roles that we play. So this is an extract of the role definitions as per our contractual agreement with the RAV. We were responsible for compiling the business requirements, configuring the ICMS solution, providing training on a train-the-train basis, configuring the integration and endpoints for ICMS, assisting with the solution deployment, migrating the data, as well as the overall project and program management for our responsibilities. The RAF, on the other hand, is responsible for all management decisions and impacting relating to the ICMS, including people-related impact as a result of the ICMS implementation. You also ask about advice on stopgap measures. So whilst the ICMS is being implemented, if you refer to stopgap measures, if you were referring in terms of organizational, interim or transitional measures, this was the responsibility of the RAV and was not within the scope of our contract. Importantly also to note is that RAV are responsible for the user acceptance testing, which is a very important step to ensure that we are configuring the system in line with what they were asking. A few other important clarifications. For integration points, the PwC team configured the ICMS endpoints. The configuration of the system that needs to be integrated with the ICMS was the responsibility of a third party, where these were external systems, or the RAF, where these were internal RAF systems. For example, when we integrate with the Department of Home Affairs, the DHA team are responsible for configuring this, the integration point on their end. And for the SAP system, the RAF was responsible for configuring the SAP endpoint. So the actual configuration was done by the SAP service provider. Both the RAF and PwC carried responsibility for project and program management within the areas of which they were responsible for. The RAF PMO is our primary liaison point, and all meetings, communications, workshops, coordination is directed via them. They are also there to assist in driving the project forward, managing key milestones, and where there are dependencies on the RAF activities or personnel. Just to clarify the roles a little bit further, and that is the end of the section, we follow an iterative development process. What this means is that the project maintains a list of all the RAF high-level requirements, but rather than developing all the requirements to a detail level, the RAF then prioritize which of these requirements are needed first and prioritize these in the next iteration. These are developed and deployed so that the organization can benefit from these features sooner. It is what's called in industry an agile delivery methodology. The process starts with the prioritization of the user requirements, which is done by the RAF. We then initiate the elaboration phase, which is where we expand on the user requirements, working with the RAF identified subject matter experts. We document the requirements in what we call user stories, and these user stories are then approved by the RAF. Once the user stories are approved, our development team builds the requirements, whereafter we perform integration testing, and then RAF does the final user acceptance testing. Once the RAF approves this testing phase, the features are then deployed to the live environment. As an important call-out, we have only access to what is called the lower environments. So these are the development and the quality assurance or testing environments. We do not have access to the live systems where claims are processed. Chair, that concludes this part of the presentation in terms of our roles on the project, and I'm happy to pause here if there's any further questions.
Honourable Atkinson.
Good morning, Ms. Gilmore, and thank you very much for your presentation. I know you specified that this is a claims processing system. Obviously, one of the really important features for the Road Accident Fund is the ability to be able to quantify liability in their financial statements at the end of the year, to quantify overall liability. And that is problematic because it's obviously based on the dispute on the accounting procedure at the moment, whether it's a social insurance or social benefit fund. And the difference was pointed out to us yesterday. Under the old system, the liability was about 330 billion, and on the new system, it's about 28 billion. So I can see on your claim system, you can probably calculate the liability for a social benefit fund, because that's when the moment the claim gets implemented or gets entered onto the system. The other one, obviously, is when an accident happens. I'm not quite sure how that's exactly quantified, but I don't suppose there's any way that your system could capture that, could be able to provide if RAF is forced to go back to the accounting standard that it's meant to be on, would there be any way that you would be able to deal with that, the whole liability issue?
So, Honourable Atkinson, I must say, I think we might need to find a different way of expressing the problem, because my anxiety is the people who deal with the accounting issues came yesterday. And these are not the people. And I'm worried for the same reasons of simplification, that we need to identify the problem in a way that makes sense for them. I don't know if you get me. Yeah. So can you please just express yourself again? Yeah. Otherwise, you might have a long back and forth.
All right. So under the accounting system that RAF presently uses, that's getting qualified audits, it'd be quite simple in your system, because it's a moment that the claim is actually accepted onto the system, and then I would think it's quite an easy follow through to work out what liability is. On the system that they may be forced to use, apparently liability starts at the moment of the accident, so that's even before the claim arrives at RAF. So my thought is that you probably wouldn't be able to. I don't know. Yeah.
So can I make an intervention, please, Bishop? I think Ms. Potgieter wants to assist us, Honourable Atkinson. I think she would be, yeah.
Thank you, Chair. Chair, even in the previous system, we didn't have data relating to accidents. We relied on external data that we could find from the RTMC. I am told by the actuarial team that we currently have at the RAF that they don't necessarily keep data of all accidents, but rather only fatal accidents. So there's a lot of uncertainty in the calculation or assumptions being made in terms of the number of accidents when they have to calculate that IBNR portion. But I just wanted to state for the record, even previously, we have never captured accident data in our claim system. There was, however, a pilot project that we had with some of the ambulance services, where an application was developed with the intention was to share with us information from the accident scenes, where obviously our claimants would be picked up and taken to the various hospitals, and that was something that we had considered at some point to take further, so that we at least would have the information from the point of the accident, as opposed to waiting for 3 years later when the claim is registered with the RAF. But both systems, the new and the old claim system, doesn't capture accident information at a real point in time.
Question answered, thanks.
Thank you. No, thank you very much. Honourable Neil May, is your hand up, okay?
No, thank you very much. Looking at it from an ITC and artificial intelligence, it sounds fantastic, because when all the information is there, then obviously that gets to do the job. The challenge that I have is and this is from the RAF side is, you see, how user-friendly is the ICMS for ordinary members of the public, considering that RAF still requires claimants to complete printed forms and lodge them physically at regional offices. Is there any system that is going to be, you know, looking down the road? Will you be able to go onto your computer at home or your cell phone, smartphone, and take all this information on your smartphone? You would then scan the documents. I mean, obviously, this is the ITC side. This is not the person now going to the specialist and whatever. But once that person has got all the information, how easy is it going to be for me I'm not ICT specialist. I'm past that age group. It's my sons and everybody. This is the generational mix where you use your younger members of your family to assist you, which would help the older members of those that claim. So would somebody in the rural area be able to, should they have Wi-Fi, eventually be able to lodge a form, lodge a claim on the system from where they're sitting in their home?
Thanks. Through you, Chair, we will go in the next session through the full functionality of the system, where we will explain that. But just very quickly, in my initial slide of the solution, the customer engaged portion is both available for, is in development, and we'll take you through the status. It's actually in testing at the moment, and that is where either the customer or their legal representative can, from anywhere, log a claim directly online and submit their documentation. But we'll take you through the full functionality of the system and the status of that in the next session.
Honourable Blossom.
I don't know, just a quick one, Chair. If in this testing phase of this new system you're talking about, so the development, will customers then be able to go into the system and check the status of the claim? Is that going to be available, or is available already?
Once customer engaged is online and live, they will be able to go on to see where are the claim in the process. Thanks. I will hand over now to Ms. Isaacs to take us through the question, answer the question around whether the system is fully functional and the status of where we are in the life cycle of the program.
Thank you very much. If Ms. Gilmer, you can just go back a slide, to your last slide, please, another one. So before I start in getting into the status, I just want to come back to this slide, because I'm going to use the word iteration a lot. The term iteration refers to that process of prioritization through to deployment. So we refer to that as an iteration. Thanks. So just as we've done in the previous section, before we get into the heart of where the status of the project is, what we'd like to do is just again give some context. So in terms of the way, and right from the onset of the project, the plan was always to deploy the solution in what we call 2 releases, Release 1 and Release 2. Release 1, in this case, was defined as the ability to process and pay a claim. So any functionality that was required in order to achieve that objective was regarded as part of the scope for Release 1. So if we had to go back to the process slide that Ms. Gilmore had up earlier, from the time of onboarding all the way through to the payment phases, that would be regarded as phase 1 and was regarded as the minimum sensible product. When we then get to Release 2, Release 2 then focuses on what we call enhancements and changes. So again, to illustrate that, let me give you an example. In Release 1, we integrated ICMS with the SAP system. That was to enable the payment, and because the ability to pay was part of the minimum sensible product, we then had that was part of Release 1. In Release 2, we then added integrations. So integrations to the Department of Home Affairs to check mortality checks, with the banks to automate the verification of banking details. Though that is regarded as an additional functionality, an enhancement, and therefore part of the scope for Release 2. We also then deal in Release 2 with changes that the RAF may want, which is an important part of it, because when we go live with Release 1, which happened in the first instance on the 30th of September last year, users of the system then had the opportunity to feel the system for the first time, experience the system for the first time. In doing that each and every single day, they then realize what enhancements they want, what changes they want to make processing of the claims easier for them. So those changes get logged and get accumulated as part of the requirements and user requirements that they then want to move forward with. So in Release 2, we then deal with both enhancements and changes. What you'll see at the bottom are the deployment dates. So the Release 1 went live in 2 stages. First, it was Midland and Johannesburg, and the focus of that was to make sure that if there was any significant issues experienced with those go-live sites, that we would have the opportunity to address that before a broader go-live. So the rest of the regions then went live on the 24th of March 2025. If you then consider Release 2, I now start using the word iterations. So there were 4 iterations planned for Release 2. 2 has already gone live, one on the 13th of June this year, another on the 15th of June, and the third one is due to go live, initially planned for tomorrow, but now rescheduled to Monday. And then the 4th iteration I'll come back to in terms of when that will happen. So if you then take a look at it, you'll see that we've got 3 phases here. Release 1, minimum sensible product. Release 2, enhanced functionality. And then we have beyond the project this continuous evolution. Because a lot of the time when people look at projects like this, they see it as a finite process. You begin, you end, and after that everything's perfect. But actually, in the reality, with most systems like this, it actually continues to evolve. So if we can go to the next slide, just to again, in an attempt to simplify what I've said and put this into everyday terms, we use the analogy of building a dream home. And so if you're building a dream home and your desire is to move into that home and live in that home as soon as possible, you start with a list of requirements and designs. That could be how many bedrooms, how many bathrooms, your kitchen, etc., etc. In building the core, you get to a point where that is move-in ready. In other words, I've got my bathrooms, I've got my bedrooms, it's got electricity, it's got water, I can now live in it. That was the equivalent of our Release 1. When you then move on, you then say, hey, I'm now living in this building, in this home. I now want to add solar energy, automated irrigation. I don't like the house color any longer. I want to repaint it for a different color, so that's a change. That is the equivalent of our Release 2. I'm still living in the home, and I'm enjoying the benefits of the home. Future releases, that continuous evolution. The municipality comes along and says you now need to switch to smart meters, or you now have a different job that requires you to work from home. So you now convert your electricity to smart meters, you convert a room to a home office. That is what we term continuous evolution. So I'm really hoping that that then puts into perspective the way that we have approached the delivery of this project. So that gives us now a platform to explain where we are from a status perspective. And what we've done is we've looked at status through 3 different lenses to really help you understand where this project is at the moment. So earlier, Ms. Gilmore indicated the different components of the system: Guidewire, Updraft, and the Intelligence Data Platform, or IDP. In Guidewire, there are 4 components. As she explained, the Claim Center, Customer Engage, Vendor Engage, and Predictive Analytics. Now, in Claim Center, that is the core claims processing. So again, if you go back to that value chain that Ms. Gilmore explained a little bit earlier, the Claim Center covers from onboarding all the way through to the payment preparation. So in Release 1, we completed the minimum sensible product, and as I explained, we now in Release 2, those are enhancements and changes that are in progress. Customer Engage, again, just to reiterate, this is the module that would allow claimants and claimant lawyers to submit their claims electronically to the RAF. The development for that is complete, and that is now within Release 2, the RAF for what we call user acceptance testing. So they're checking to see that it's been developed in accordance with their requirements. Vendor Engage was not part of Release 1. It's considered an enhancement, the development of which is currently in progress. Guidewire Predict Analytics is a module. It's quite an advanced module. What it does is it uses machine learning. It looks at data. It learns from that data. It develops patterns around that data and then seeks to predict, based on the new claims that are coming in, what is the general, what could be the liability and outcome of a particular claim. That is designed as a proof of concept only, and the reason why it's done as a proof of concept is that it's very dependent on the quality and the volume of data. And so they first want us to understand whether it is of value to the RAF before they will do a much broader rollout. On Updraft, it only had a Release 1, so all the functionality has been built as part of Release 1. What we are now doing with Updraft is it is now in what we call support and maintenance. In the Intelligent Digital Platform, the minimum sensible product is complete. The first release is live and the RAF is using the IDP system. We are busy again with enhancements to the IDP at the moment. So that gives you a status of the solution from a component perspective. Then, if we then look at it from an iteration perspective, and remember, iteration is prioritization, elaboration, and so on and so on, until we get to deploying an iteration. So in Release 1, there were 6 iterations, all of which are complete. In Release 2, there are 4 iterations. 2 of them are complete. The third one is in progress and due for deployment on Monday. And then iteration 4, we have paused. And the reason why we have paused it in collaboration and agreement with the RAF is because of the change in the stakeholders that we have. We have to give them an opportunity to understand the system, the project, and the priorities so that they can help to guide what the next steps are and what are the priorities for that iteration. I want to pause there. If there's a lot of technical language, as I hope I've tried to translate, if there's any questions at this stage, Jay.
Yeah, so can I ask, because I do want us to move expeditiously through the presentation, right? That maybe we allow you to get to the end, because we've left at 10 p.m. here and we will leave at 10 p.m. again, and I don't want that to happen. So can we yes, let's allow you to work through, and then we'll ask the questions. We'll ask clarifying questions first, and then we'll get to the substantive issues.
Okay. So then the third perspective of looking at status is looking at through the system functionality and user requirements lens. So what I've put on this particular slide is I've listed, if you like, the user requirements that has been documented, that the RAF has indicated that they would like to consider for inclusion in the system, but that has not yet been developed, right? And so in that table, you'll see that we've tried to summarize it to not get into too much detail, but in essence, there's 4 themes around it. So one is the automation of existing processes that are currently manual. So customer engaged, vendor engaged falls into that category. Changes that the RAF would have asked for, so enhancement to supply claims, changes to the way that the authorizations are done within the regions, that would fall into that category. On the compliance matters, any changes that we may need to make, if the judgments go against the RAF on the RAF 1 form would fall into that category. And then there's a number of additional integrations and optimizations that would also come into that category. What is of absolute importance is that there's only one iteration left, which basically then means that all of these requirements will not be able to fit into that one iteration. And that's a really important point. It comes back to the house example. I have a list of requirements. I have a dream home, but I've only got a set budget. I have to choose between my solar system and my automatic irrigation system, because that's what my budget allows. We have the same scenario here, where we have a list of requirements that exceeds the available budget for release 2, and so the prioritization of what goes into that final iteration is going to be super important for the RAF in terms of how they want to move forward. That concludes the status of the project. Aligned to the status of the project, one of the things we were asked for is risks and challenges, and this is the next stage. If you want me to continue, Chair?
Yes, please.
Okay. So when looking at some of the risks and challenges associated with the project and the system in particular, we've highlighted 5 of them. Certainly not exhaustive, but it's the ones that we believe are extremely important at this stage. The first 2 go hand in hand and deal with adoption and the stricter controls that are now in the ICMS relative to the legacy environment that many of the RAF claim handlers would be used to. Adoption we list as one of the number 1 issues facing this particular project at this point in time. The change that we are talking about is extremely significant. We are moving the RAF from a highly intensive manual system, a legacy environment that was custom built, and we're moving them to an automated process end to end, where there's very little manual. In fact, we're now changing some of the functionality where people used to have judgment in a process before. They no longer can apply that judgment because it's now being determined by the system. So to give you an example of that, in the merits assessment phase, in the past that apportionment was done by claim merits consultants. Now the system takes that merit consultant through a series of questions, and in the system it then draws on case law, relevant case law based on the scenarios that are being inputted into the system, and that then decides the apportionment between the apportionment values between the RAF and the claimants. And so again, taking away the judgment means you're taking away control. The same thing applies to, as Gilmore referred to, the national assignment. A claim no longer, in the past, a claim would come in through the door, and that claim would be processed by that region through to the end of the process. That's no longer the case. If I'm sitting in the walk-in centre, I will receive that claim, say, in Menlyn. The moment that's captured and verified, it then can be assigned anywhere nationally, and no one can predict where it's going to go because the system does that selection on a rotational basis. And as Ms. Gilmore explained, that is one of the anti-collusion controls in the system. it's very different ways of working, and so it requires a significant mindset shift, which means that from a driving the solution in, it's going to take intensive leadership, sponsorship, and intensive and persistent change management. If I then move through to the throughput stats, we are aware that the throughput stats are low. And then from a project perspective, we have highlighted 3 elements which we believe has impacted on that. The first one I want to deal with is the low allocation of resources. And if I can just ask Ms. Gilmore to go to the next slide. So firstly, this is just some high-level stats that we've received from the RAF. It essentially shows the claims that have been handled from September last year, really October last year to October this year. That September spike indicates the data migration that happened, so the intake of data from the old system, and also indicates the go-live for Menlyn and Johannesburg. You then see that curve starting to curve up a little bit as the coastal and the rest of the regions go live in March of this year. So just some overall stats. The total number of claims in the system as at the end of October was just over 100,000, split between about 54,000 claims that are compliant and 47,000 claims which are non-compliant. And then if you look at it through a payment lens, how many have actually gone through the system, those numbers are relatively low. So 711 claims or 30 million is ready for payment but awaiting approval. Further 236 are sitting in an aging status. In other words, they're ready to be paid but they are not yet due for payment. And then a further 198 or 2.9 million is with request for where we requested for payments have been made. Now, if you then take what we've done is we were intrigued by this and we wanted to understand a little bit more about what is impacting on throughput from a user usage perspective. What we then did was we went down a level into the merits assessment phase. And we looked at the claims that were being processed on a month-to-month basis just through the merits phase in particular. This again shows you the trajectory of the claims being handled from October 2024 to October 2025. And you'll see the yellow portion there refers to conflict claims. The pink or salmon color refers to the ordinary claims, and the grey then represents the total number of claims per month. You'll see that in August there's this little peak that happens. And so what we've done is we then looked at the usage of the system at the time for the month of August. So in Bloemfontein you have 2 merits consultants, Cape Town you've got 4, Durban 4, etc., etc. Then we looked at the average number of logins for the month of August, and you'll see that that average number of logins is very low. So Bloemfontein, the average number of logins for the full month is 4.5 days. For East London, it's 5. Durban leads it with 12. And so what that is indicative of is the fact that RAF has had to do a ring fencing of users. So people are ring fenced to work on ICMS and others to work on the legacy and therefore clear the backlog. And even people that are ring fenced for ICMS also then sometimes have to do dual duties on the legacy environment. What this shows, though, is that with even that low usage, you see that peak in performance from a processing in August. So it shows you that if you then add users and resources to processing claims within ICMS, how it is possible to potentially take the processing on claims much higher throughputs. Just coming back again, to some of the other throughput challenges we've had. We had a very particular issue on the SAP integration side. And again, just as a reminder, Ms. Gilmore spoke about the fact that we've got differentiation in the roles and the responsibilities between who does what in the integration. And integration has got 2 endpoints. The one will be the ICMS endpoint, which would be what we are responsible for configuring. And then on the SAP side, in this instance, it would have been the service provider providing the support to the RAF for the SAP environment. In July this year, RAF alerted us that they actually could not make any payments for any claims coming through from the ICMS solution. And we were asked by them to please take a look at what was causing the issue. By that time, the SAP service provider, the contract had been terminated with the RAF, which is the reason why they asked us to take a closer look at it. In doing so, we discovered that the configuration was not done correctly, and we then assisted to resolve that matter. But what it meant then is that it held up payments in the system and then affected throughput quite significantly. Since then, because the payments are now flowing, the RAF has now been able to pick up that the remittance advices are not being populated correctly, and again, we are assisting the RAF to resolve that matter as well. So that's it really on the throughput stats. The next item I want to deal with is the fact that we still have a legacy system, and for good reason. The RAF still has to process the backlog claims. Not all the claims could be migrated, and that is because many of the claims are at different stages in the legacy environment, and because of the stricter controls within ICMS, we have data validations that exist that would not allow those claims to come through. So for the RAF to be able to migrate those claims through to the ICMS, they would have to go through a fairly comprehensive and extensive data quality exercise on the existing RAF claims that are sitting in that legacy environment. But what it does mean is that you have two different claims processing regimes, and it just makes it that harder for people to adopt the new ways of working and to sustain that new ways of working, because they have to toggle, if you like, between the two environments on a continuous basis. So having a very definitive sunset approach to the legacy environment is going to be important. And then lastly, Chair, the project delays. You will be aware that we had a number of project delays, and part of the question to us was what was the financial implications to the project on that. That one I will now defer back to Ms. Gilmore, who will deal with the financials of the project as well as the delays.
Thank you, Chair. We won't be long anymore. In terms of the costs of the project, the contract was for a 5-year contract, so from 2022 to 2027, and it was based on an all-inclusive fee, so which is basically a fixed fee for that period, and the total contract value was approximately 841 million. As you would see in the graph, the implementation fee is only approximately 28% of that fee. The other components is licensing, it is support cost, and it is also the claims risk management, ongoing processing of those claims. PwC is the main contractor, but you can also see the split between the various parties in terms of before variations and after variations. The variations the contract allow for 4 types of variations. Basically, approved changes, changes in law, additional deliverables or services as required, or exchange rate fluctuations. So the only variations with a cost implication to date is really around the guidewire licensing fee. At the start of the project, this was estimated at about $14 to the rand, whereas, as we know, it is quite different. So there's a big forex exposure or fluctuation that is part of the increase of the cost. And then some of the other areas is just in terms of the provisioning of the IT infrastructure and support services. This was part of the scope in the beginning, but not yet quantified at the contracting stage. So I'll expand on this a little bit later. as Ms. Isaac said about the project delays, and I think she touched on some of that already. So the original project was Release 1 was due to go live in September 2023. It was delayed with 12 months. And some of the key reasons for those delays were really initially in terms of the decision on and the contracting for the provisioning of the environments. Then also, it is quite a different way in which we deliver in, like I said, the agile methodology. So it was understanding and getting used to the ways of working and the governance surrounding the iterative way of delivering this project that took some time for the team to get all on board on the same way. Stakeholder and user availability was an issue initially, and also what is the definition of a minimum sensible project? There was changes requirements, and as I previously mentioned, we did have quite a few debates around the RAF1 form, the lawfulness of that, and also other issues that were put to us, like the bypass of funeral merits, which we all agreed then not to go because that is not lawful. So, as I said, as we indicated, the system do successfully go live, Release 1. But Release 2 was then also the start delayed because we initially planned for that to start immediately after Release 1. But we then agreed that the Release 1 system first had to be embedded in the business. Handover and post-go-live support was important. But also the RAF stakeholder availability and readiness to support the prioritization of what needs to go into Release 2. And then lastly, just the project finances. So a lot of numbers there. I'm not going to go through it all. I talked about the different budget items. But as you would see, the original contract has been signed at 841 million with the different components that I spoke about. The variations then gave rise to fee adjustments. But what is important as well of those fee adjustments is that some of that, due to the delay go live, some of the support cost did not kick in, and some of the the processing of some of the claims fees actually were not as high as possible, as high as needed. So some of those has been offset against the new changes that's been required. So there is a revised budget, which is 881 at the moment, but of that, only 589 has been invoiced to date. So to complete the project, there's still a balance of about 291. And Chair, with that, I'll conclude our presentation and I'll hand back to you for any further questions.
Thank you so much. May I ask you to go back to slide 6? Yes, please. Okay. It's just part of the further orientation. So there's guide wire, there's updraft, and then there's the PwC. So I understand guide wire is used by a lot. So it's an off-the-shelf, in inverted commas. Not quite, but it's off-the-shelf, as it were. Updraft.
Updraft is also being used by various other organizations.
Okay, are the two developed by the same company? No?
No. The GuideWire solution is a global, international solution. Updraft is being developed locally based on local case law.
Okay, and then you own the intelligent digital platform.
It's a solution that we developed on Microsoft Azure, so it's almost like a custom developed reporting solution.
Okay, no, thank you. So can you then explain your role in relation to the three? So how does the procurement of service work? Is it done by the RAF, or is it just a matter of purchasing licenses or recommending to the RAF? Can you just explain how the three integrate together under PwC? I don't want us to misunderstand anything, because it then defines your role.
Sure. So, as I mentioned, the PwC is the primary contractor, so everything does get invoiced via PwC. However, there's a GuideWire licensing agreement, annual licensing agreement, which is was part of the 5-year contract. Post the 5-year contract, that will continue being an annual license agreement. On the updraft solution, there was an initial licensing fee and an implementation fee. But now that we are in support, that is in a support and the claims processing component, which will be ongoing as well in terms of there's different pricing scales for either ordinary claims or conflict claims. And on the intelligent digital platform, it is now a solution that costs such as Azure, cloud environment will continue to be paid by the RAF, and there should not be any more development required post or licensing required post the completion of the contract, other than continuing paying the Azure assumption fees to Microsoft.
No, thank you very much. So I think Guidewire is fairly easy to understand for most of us. I just need a kind of more explanation on updraft in terms of how the technology works to produce an outcome. So let me share with you my understanding of it. That is able to aggregate all the court cases historically. I don't know how far back it goes. Historically, all the court cases, and it isolates the capital claim amount. I'll tell you why this is important. So in the judgment, so if it's reading a judgment, there'll be lots of numbers there. There'll be an order as to what the claimant should be paid. There'll be an order as to costs. You see all of those. So I just want to be certain that it then separates out the legal costs, as it were, or does it include the legal costs? So I just want to understand what it does there.
Chair, I'm going to give it a go, but just to point out that the original manufacturer is in the room in case you do want to have a direct conversation with him. So the updraft solution is not focused on the value of the claim. It's more focused on the apportionment of the liability. So the output is not a value. The output is you're 80%, I'm 20%. So it's using case law to work out the apportionment side of it.
Okay, so to make this easy for all of us, just take us through, I mean, whoever can, Miss Manyasha, Miss Potgieter, you really are free to participate in this conversation. I just want us to have a proper understanding, that's all. The way I would do it is maybe to say, usually a claimant, claims for the following, and that kind of thing. So just walk us through it in that way. Anybody who can. Ms. Manyasha wants to volunteer. I think this is more for the RAF.
Yes, remember, Chair, the RAF is a fault-based system. So if I'm involved in an accident and the fault was on my side, and as Ms. Isaacs has explained, there's questions that are asked. If I'm a pedestrian and I was crossing a four-way stop or something like that, then there's a determination of whether the robot was red or green. Did I cross at a pedestrian crossing, or did I cross in the middle of the road? Was I running? Was I drunk and all that? So all those questions are asked, and they are the ones that spill out an outcome to say the pedestrian was 50% on the wrong side of the law in terms of they crossed the robot when they crossed the road when the robot was red.
Okay, so it only works out the substantive legal issues as relating to a finding of fault. And so what it would do, it would aggregate historical judgments to say, we've looked at 15,000 of these things. In 14,500 of them, this has typically been the court outcome, and therefore you've got a reasonable estimation of what's going to happen in this case because you've analyzed all of that data. So that's how that works. It doesn't get involved itself in calculations and that kind of thing. Okay, so I get it. So members, you get it. You understand? Okay, just on this issue, Honorable Pila.
Thanks, Chairperson. One stupid question. Let's go to page 19. The project delays. The causes for these delays were primarily due to the last bullet there. How can the availability of relevant RAF personnel can make the project to be delayed?
Thank you for the question. During the process, as we explained through that iterative process, there's a number of stages in engagement where we are very dependent on working with the road accident subject matter experts. When we define the user requirements, we define the business rules that we need to apply. As we said, Guidewire is an off-the-shelf product, but you configure it based on any client-specific business circumstances and business rules. So the way we've done it, as Ms. Isaacs have explained, is through numerous workshops and with the Road Accident Fund specific and specified subject matter experts or SMEs to understand their requirements in detail. And then also through iterations of that, when we capture it in a user story, then we need to go and get it signed off. And that is a process that can be to and fro. And if individuals or the right individuals not involved in that process or not available, which was the case. So for example, what caused quite a large delay at one point is we were working with a certain number of subject matter experts. We then defined the user requirements and developed the system. After which a point it was identified that the individuals did not have all the business requirements, all the business rules. So we had to go through another iteration, go back to the drawing board, redefine those requirements and change that again. Again, delays in terms of availability of Road Accident Fund is through availability of doing user acceptance testing to make sure that that process is actually, we can plan it for 2 weeks, but if the users are not available and dedicated to that, it can take much longer. And there were a number of areas where we got delayed through signing off. We established a nice rhythm of how we will sign off user developments, also through learnings that we've learned not to go ahead with any of the development before it is physically signed off by the relevant stakeholders. And sometimes the sign-off process, due to availability, has also been caused delays. I hope that answers your questions.
Thank you. So it will be Honorable Nilmay, Honorable Isaac, and then Honorable Madlala. And then, just on this one.
It's actually a clarity to you.
Oh, okay.
In terms of the framework of our approach to this presentation, you spoke about clarification questions and then substantive questions, and I think we may not be economic with time. Rather, we just allocate, and as a proposal, the fixed amounts as we normally do. Then we'll ask clarifying questions, then all other questions, so that we don't bombard clarification questions, which will take an hour plus. And then after, say, let's go into the substantive questions as well. Thank you.
This is a very good suggestion. Okay, so so Honorable Nilmay, yeah.
Yes, no, sorry. While we just with the technical side here.
No. So no, hang on. So I'm going to give you a chance just now. Sure. So Honorable Madlala has just made a proposal, right? And that proposal is we go into the normal cycle of questions with time allocation, and then you ask all the questions that you want to ask, clarification and any other questions that you have on the system, right? I had started this way late yesterday, so I am now going to start with Honorable Beasley and work my way in this way, right? Sorry, Mzala. Sorry, Mzala. It will happen that your clarification question is answered along the way, in which case you get to the substantive issues. So can we then work on our normal allocation. I will then ask any questions that are left. Looking at the time, after Honorable Bila, we'll take a break. Looking at this, so we start with you, Honorable Beasley, Honorable Nelme, Honorable Bila, and then we'll take a 15-minute break and then come back and continue until lunch.
Thank you, Chair. So just to ask PwC, in terms of the new REF 1 form, you obviously got legal advice on it. Have you done an estimation what the cost and impact would be? I mean, the courts have ruled it to be illegal, so I don't know what more you're waiting for. Are you not just incurring further costs and when I say at taxpayers' expense, because taxpayers pay for it, but have you considered that? And what stage will your advice to REF actually be, listen, we're actually wasting taxpayers' money here? And then secondly, what would the cost estimate be and time delays to adapt that?
Thanks, Honourable. On the first question, the RAF 1 form is the current legal form. So we need to be instructed by the RAF to make the changes when the appeal go through or not in the High Supreme. So currently that is the law, and we need to follow that process. In terms of the cost of making the changes, like I said, it is not significant as it only affects the onboarding stage that some of those changes would be. So I cannot quantify that for you exactly in the value, but it is definitely, we've gone through that quite extensively, and actually that is one of the requirements, should that be the case in the request, that we can build into the next iteration 4.
And have you got an estimation of what that cost would be?
It depends on the outcome of the judgment, because also remember, it might not be the whole RAF 1 form. It could be components thereof. So in terms of what the outcome of the judgment would be, would determine how much changes would need to be done, and therefore the cost of it.
Yeah, I mean, it's a judgment call at the end of the day, but, you know, majority of the courts have ruled against it. Prudence would say that it is going to be deemed illegal and that we're wasting taxpayers' money at the moment.
Sorry, Chair, I can't comment on that.
Yeah, no, I was going to say the litigant is the RAF, I suppose.
No, I appreciate that. The other thing that just does concern me, and again, maybe PwC can't answer this, and maybe it's a RAF question, but for a normal person, and I often picture my mother who doesn't have access to doctors, doesn't have a big bank balance. I mean, how much does it actually cost for a normal person to actually complete this form? And maybe the RAF can answer that.
So can we, we'll wait for Ms. Manyasha. She's the project lead. She's gone to the bathroom. So let's just keep it. And when she comes back, I'll make sure she answers that one.
Okay.
Is that okay?
Thanks, Jane. Just the last question is just on page 17. There's the amount of claims that have gone through the system is incredibly low. Can you maybe just elaborate on that slide a bit more, that page?
I've been through the reasons why we felt that from a project point of view, why the throughput is low. Is there any specific area that you want me to hone in a bit more?
Yeah, but essentially it says to me the system is not working. And have you got concerns about that? And is it a management issue or is it a system issue?
Let's go to the next. So from our perspective, we've identified 3 areas. The one is the allocation of resources. And as I've explained, you can actually see that there's only a fraction of the manpower, if you like, that's been allocated to process claims. Claims have been processed all the way through to payment, which says that the system is working. It's now a case of driving throughput. I also mentioned earlier that we had the issue of the integration that caused issues with payment. That has now been resolved. So those are the two main areas from a project perspective. There may be others from a RAF perspective that they can create more clarity on that.
Chair, that's me.
All right, thank you. When Ms. Manyasha comes back, I'll make sure that your question is asked again. Honourable Nilme.
No, thank you, Chair. It was one's thought was when everybody was talking on the technical side. So your questions are based on that. I want to come back to the updraft software. Is that the Cape Town based company? It's the built by lawyers for lawyers. It's very interesting. I think, Chair, which was most interesting, I think it also assisted us. We did a lot of research overnight to look at the ICT side, which is something that we don't normally look at. And especially if you're not in the ICT environment, one then has to research and look at that. So in that line, I can understand it's a innovative system of going forward from a lawyer's point of view. And I think looking at the future, maybe that is something that one can look at. My question would be around vendor lock-in. How have you packaged your collaboration with Guideware Updraft and your own intellectual solution? So the licensing aspect, which is something we've noticed in some areas now, government was linked to IBM for years and years and years. Now one has to do the breakaway. The systems are embedded in it. Now we are moving into new updated AI environment now. What have you planned from PwC that is now that you've put on the table for RAF going forward with the three? It's like a three-legged pot here. You've got your Guideware, your Updraft, and your own intellectual solutions and yourselves. What system have you put in that will guarantee that in 5 years' time, when let's say the Updraft or something in that line, that it's the vendor lock-in? What is your way forward, and what is your advice going forward to RAF?
So, as with any implementation of this nature, Guidewire has been selected as the claims management solution. So RAF will have to replace it if they decided not to continue with that. But the ongoing cost for Guidewire is the licensing fee, as I mentioned. And as part of the handover, the RAF themselves can develop the skills to continue to do the ongoing development. They do not have to be dependent on a support party such as ourselves. For example, on managing the infrastructure provision support, they've already selected an alternative vendor to support the system from an infrastructure perspective, which is one of their other suppliers. So either you need to just get people in if you wanted to develop, or they can develop their own skills, which has been part of the project to do that. On the Updraft solution, that is a component. Again, it is based on an ongoing processing of the legal resolution platform. So they will continue having to pay. It's less of a licensing fee, but you can related to that. It's more the number of claims being processed, both ordinary and conflict claims, because they need to keep the system updated with the latest law, the latest applicable laws, make sure that the system works, etc. to that. That again is almost a subscription service, if you can see it like that actually will have to be done in the future. And yes, that will be dependent on this specific solution, which again can be replaced if there is another solution out there, which I haven't come across. That's why it is so unique. And on the IDP system, there is no need to continue with any vendor beyond that. They have already been working with us to have the right skills in-house to be able to maintain and further enhance the system post the end of the contract, period. I hope that answers the question.
Thank you very much. Coming back to on the RAF side, I just want to get all my questions here. From the RAF side, now you have a backlog. You have a backlog. You have all these cases. How are you going to be able to, have you got a plan to take your backlog and integrate it into the system that you have now developed? Because from real time, new claims coming in, I think it's going to be easier because it is obviously new. But you have, it's like moving to a new house, as you mentioned. It was a very interesting example that you used. So you still have your old house and your garage is full of boxes. You have to clear all that out. There's a lot of things you have to do. You still have to pay the rates and taxes and closing off before you move to the new system. Once you're in the new system, everything is go there because now you can carry on from a fresh start. But you still have the other aspect that you have to catch up on. How do you see yourselves catching up and integrating the system? I did ask ICT the last time they were here. They did say that you are able to change the system to talk to the old RAF form. I want clarity in that because I did check at that. So you have a system that is flexible, because the actual system going forward from an AI perspective, I can see the vision where that came from. The thing is the adapting now with the court case and the form which my colleague mentioned. So that is the one thing I would actually want you to state, that you will be able to go back and use the system on the old RAF form. And then how do you catch up from a RAF point of view? Thank you.
Okay. One of the things that we have looked into to deal with the backlog and old claims is projectizing that work with a ring-fenced team that is going to purely look at the backlog with resources allocated to those teams, because the backlog claims, as we have, I think, mentioned in the previous when the orientation was done, is that some of them do not have the required documents, and that's why we went on a backlog campaign to request people to bring those documents. And now we've got an outbound calls made to those people that we are seeing their claims on the systems, so if they can bring them the required documents so that we can assist them in fulfilling those. But the intention is not to bring old claims into the new system, because they're going to get stuck there without the relevant documents. Thanks.
The last question, Chair, is your storage on cloud. So I want to ask you about your cybersecurity on the one side, and where you're going to be storing all the information. Because quite frankly, right now, and I'm just going to say, I'm going to say an office. You have an office, you have one personnel, and you have 1,000 files on the floor, okay, which they are now dealing with, okay? That's the reality, okay? So those are the files that are not coming into the system. That is where you're going to have a team, a task team to clear the backlog, because you have one claims person working on 1,000 files, okay, if not more. So that is the old system. And I think going forward, not today, I think one of the areas that one would want to look at is the way forward on clearing that backlog, those courts, and I think that is for Mr. Modiba. I think, you know, how are you going to do that? We still have to see that plan, you know, really look at that area, because that is where the challenges lie. The way forward, ICT way, AI, is the way to go. I can see that, and I can see how it's going to make a huge difference going forward. I mean, before COVID, none of us did virtual, and now everybody can do virtual, and even WhatsApp virtual. You know, so Mama in the rural areas just presses WhatsApp and she can speak to all her family. So I can see the system going forward. So your storage, your cloud. Tell us a little bit more about that. Where's the data going to be stored? In China, in the US? Which way are we going? Thanks.
Okay, let me take that one. Okay, so as I said the last time I was here, so what we've done is the solution is built on top, or it's running on 3 environments, cloud environments, AWS, Azure environment, and obviously the Oracle environment. So in terms of storage, everything that we process from the AWS environment ends up in the Azure environment, which has obviously data centers in the country. Okay, I can't see no. Yeah, so which has data centers in the country. So obviously all the information is local. It's stored within the borders of our country. Both data centers have a replication method, so meaning one goes down, the other one picks up. I mean, it's part of the architecture and the design of, the cloud environment and how it operates. So from a safety and from a regionalization perspective, all of those things are sorted. I think the crux is to get the information into that digital format to ensure that it's there and it's readily available.
Through you, Chair, I just wanted to add. So we currently are busy evaluating a tender for digital document management services. So it would include 3 parts. Firstly, the offsite storage of physical records, but prior to that, the digitization and storage also of, enterprise content management, if you will, of the documents, at least for the backlog. The new documents in the new system are scanned in at a point in time and it is loaded into the integrated claims management system. But we are also busy finalizing a tender for document management services that would digitize all of our documents so we wouldn't have all those files piling up on the floor. Yes.
Thank you very much, Honorable Beasley. Ms. Manyasha is back.
Sorry. Yeah, I just wanted to know if REF have done an estimation of what it would cost a person to complete the REF form. So I'm just picturing my mother in a rural area who has an accident. She doesn't have access to much money. Have you done an estimate what it would require for majority of South Africans to complete the REF form?
No, I have not done that exercise. I'm not aware of that. Obviously, one of the things that I personally saw a claimant struggling with was getting an actuarial form. And that is something that we did look at to say some claimants will not have money to get an actuarial to get an actuary to do their calculation. And some of the claimants that are injured will not have money to go to the doctors to get those reports. And I think in one of the engagements that we've had, that's where we were trying to motivate for changes in legislation so that it can be easier. Because as it is now, it is, Chairperson, you did mention the other day that it is quite difficult for people to fill in the form. And it does require a lot of work and a lot of money. So yeah, it is a bit difficult, but that will require the relevant regulation, the regulators to help us in simplifying the process. Thanks.
If I can add, Chair, I think yesterday I talked about the actuarial calculator, which is meant to be an online tool. It's for free, wherein South Africans are able to give input to their injuries from an accident onto a system for purposes of having an estimate, the quantification part that we talked about. Now, the issue of reach has become a huge thing that we thought about. Obviously, the system needs to cater for official languages. And bare minimum, those who are able to have connectivity on their mobile phones are able to go online and then access these sorts of services. As part of Honorable Beasley, the issue of trying to address the gaps that have emanated demographically. Thanks.
Do you have a follow-up, Honorable Beasley?
No, it's just a comment. So my understanding is a majority of South Africans are excluded from the system because unless you have money, you cannot get all to do all of this to complete the forms. Thank you, Chair.
Yeah, we had a witness here last week. He itemized what the various documents cost. It can be north of 100,000 rand before you comply with stage 1 of the process. Honorable Bila.
Thanks, Chair, and good morning to everyone. And thanks to the presentation by the two ladies, the partners of PwC Consulting. They have indicated that there are 2 claims process regimes that are still used in the road accident funds. And one of the reasons why we are here today, Chairperson, is because of the backlogs that the road accident fund have. So I just want to check, when can we expect one process which will be left to be used there, so that maybe this backlog can be reduced?
Yeah, I'm going to attempt to respond to this one, Honorable Pila. I think if we look at really the evolution from a project perspective, it's not a straightforward answer that one can give you to say in the next 18 months. I mean, if you look at the things that need to happen, the finishing of the backlog in the old system, which is the legacy system, I mean, we're talking around 200 to 250,000 claims, if not more, in there. But the value, I think, where we're sitting now, it's about 250,000 claims. To finish that off will take us anything from 18 to 36 months. I mean, to be able to shut off. But now what we're trying to do, I mean, as Ms. Potgieter has said, is that we digitize the old files. We make sure that we migrate the ones that are able to be moved across into the new system, so that one, we aid in fast tracking, you know, that finishing off of the old claims, just to make sure that we cut the timeline to a shorter timeline. So for where we're sitting right now, it's still work in progress. But I think, you know, once we finish with the implementation, then to crystallize that plan to provide you a solid answer that you know, that you can take with you to say the RAF came here and said in the next 24 months, you know, we will shut off the old system. We need a little bit more time to actually have a definite answer on that one. Thank you.
Maybe I should have said according to your assessment, because you are the one who are seeing those files that are lying in your offices there.
Thanks, Chair. You know, it appears the issue of backlog is a key one, because it is for all of us. Honorable members and Chair, I think the backlog is not going to disappear anytime soon. I did indicate last time when we were here that we're busy with an outbound campaign to call every claimant on our book for us to give them the status of their claims. We called approximately 79,000 of those. Out of those, Chair and members, we still have a significant portion of people that we cannot trace. And I did indicate last time that it's for various reasons. In some instances, those claimants' contacts have changed. In fact, 4 out of 10 we're not able to reach. So up until we have reached all of them, it's only then we'll be in a better position to say, we will kill this backlog in 2 weeks' time, for instance. In addition, for as long as we are not getting all those outstanding documents, those claims will remain non-compliant. We cannot proceed with those. If we do that, we will be, of course, breaching other laws, the PFMA, amongst others. So the backlog, together with a new system, they're going to be run in parallel. But at some stage, we'll have to decide as to, are we going to continue having those claims in our books where we cannot trace them? And I think that time is not far from where we are. Thank you very much.
Thanks. We have ascertained that rough litigious environment is the heart of its challenges. With that said, the 3 rough biggest pain points then becomes merits determination, the ascertaining of the quantum, which is the value of the claim, and its litigation management with the ultimate settling of a claim within 120 days. I find it difficult, Chairperson, to understand why the Commission draft new system only caters to only one of the 3 given the price tag of the system. I also find it difficult to understand how it's feasible to meet the 120 deadline if the quantum is worked out of manual system. Can an explanation given to this committee in that regard? The second question, can you confirm that indeed the system is now integrated with Home Affairs at this stage, and also the SARS? Thank you.
Yeah, which one of you will go first? Ms. Potgieter was also chomping at the bits. She was chomping at the bits. She was nearly jumping out of her chair.
She can start.
No, you can go. You can go, sir. You're the guy on these matters. Thank you.
Yeah, I think I didn't quite get the first question clearly, Honorable Pilar, but I'm going to attempt with what I think I got. I think your question says, why is the system only catering for one out of the three? What was the first two? Sorry, just for clarity. Medical and okay, all right. So if you look at, as the colleagues have said, in terms of the thought process, the merits, the quantification of liability from a merits perspective, that bit is taken care of. Agreed, right? So if we go to the quantum, the way quantum is calculated and the way it's really driven in the organization, we've got something called the Book of Quantum. That Book of Quantum is a database of, quantifications that may exist, which is annually updated. That Book of Quantum is managed and maintained by a separate company. So during our development of the solution, when we wanted to integrate that Book of Quantum, the owners and the people that actually drive that solution, one, were not ready and they were not willing to get us to do an integration touch point for us to be able to then, bring in the quantum quantification process, and also for us to build it into the current guide wire, and would have really cost even much more because of the actual volume and knowledge that consists, within that quantum quantification modular side of it. So what we do now is we have access to that Book of Quantum that the claim handlers refer to and deal with. When we say manual, it's because it's not part of the integrated claims management system. But in terms of how it's used, the guys access it online, and then they refer whatever quantification done from that and then bring it back into the solution. Litigation, which is the last part. The litigation module, the colleagues spoke to it to say we've still got one more sprint left in the project, and part of the requirements that sit in that sprint include the litigation part of the solution, where we will be bringing in how then we drive and manage components of managing litigation through the ICMS. Okay, that was the first question. Yes, integration with Home Affairs, yes, I can confirm. That is done. We do check mortality and the name, and it's just that in terms of, we would have loved to show you here from a demo perspective, but I'm not so sure if we'll be, from a popular perspective, allowed to do so. Because you have to use, live data. You input somebody's ID number on the thing, and then it gives you the details of that person. So yes, that integration is the integration with SARS, not yet. It's in the backlog. In terms of where we at, as a fund, from a prioritization perspective, just SARS was sitting further down. What was critical for us was Home Affairs and the banking systems. Thank you, Chair, and Robert.
Ms. Potgieter and Ms. Manyashe, you are laughing so seriously when the gentleman there is answering questions. And it gives me the impression that maybe you are lying to us, or Yes, because when your colleagues are laughing while you are answering questions, the person who asks question, what is it that I can think they are laughing from? So can we please be in the meeting, even if you can see that we are being fooled here, it's fine. One of the delays in the completion of the project, according to the two ladies there, is the change in relevant RAF personnel. Do we agree on that one? Let me leave this one of the manager where there are allegations that she or he is selling positions in your institution. I said allegations. But regarding the initial placement process under Section 189, employees were required to possess the relevant qualifications to be considered for replacement. Is that correct? Is it correct? Okay. Those who did not meet the qualification criteria were placed in a pool, and some were subsequently offered voluntary severance packages. Is it correct?
Sorry, you'll have to switch on the mic so that the transcription can capture it, yeah.
Then with the withdrawal of Section 189 and the relaxation of the terms of reference, specifically the removal of qualifications requirements for placement, can I please be allowed to ask the following questions? What will happen to the employees who exited the organization because they did not have the required qualifications for the available positions at time? 2, what will happen to the employees whose positions were filled by external candidates during the restructuring process because they did not meet the qualification requirements? Why were the terms of reference amended to remove the qualifications criteria for placement? Was this change implemented to benefit certain employees who were affected by the initial process? Would the previous approach not have better served the organization by ensuring that adequate qualified individuals were placed in the appropriate positions? Furthermore, who was responsible for determining the original terms of reference? And were these officials involved in the initial placement decisions? Who has now determined the revised terms of reference? And if it is the same officials, do they now qualify for placement under the new criteria? Thank you, Chairperson.
Thank you. So I just want to be certain, because I actually, this may provide better context to this. And Honorable Bila is asking her questions independently. I was going to ask about the Section 189 that has been at the RAF, because in one of the judgments pertaining to an employee of the RAF, the reason given was that RAF now has a new system, this one, for the Section 189. Now, the person who deposed to that affidavit leading to the judgment, which then basically set aside, in respect of that employee, the consultation and, set aside the process, basically, in respect of that employee. The court was under the impression that this system is now in place. And therefore, the Section 189 became necessary. So one of the questions I was going to ask was actually about that, because it leads to those questions that Honorable Bill. In fact, my first question was going to be whether the Section 189 was premised on this system, because that was a justification given in court. I'm actually just looking for the judgment. I'll produce it. So I just want to know, the Section 189, was it premised on ICMS? Because it then leads us to Honorable Bila's questions. You guys remember the Section 189, right? I need to know, and I need you to think very carefully about your answer in respect of the fact that you've been sworn in, because we need to find out who lied where. Either we will be told the truth here or the court was lied to. So whoever is going to answer now needs to think very carefully. If you guys need to fetch the notice and so on, I'm going to find the judgment. It's very important, because this system is still not at the point where you run a Section 189. I think we can all agree. And then those questions that the member is asking have a context. Thank you. So who's going to take the question? Over to you, Mr. Mkabel.
Thanks, Chair. I will attempt to answer part of it. I'm sure my colleagues will also come in here. As part of our 2020-2025 strategy, we had quite a number of projects or initiatives which we plan to deliver. One was called Organizational Structure Review, OSR in short, which was running independently. And its purpose was to come up with a fit-for-purpose RAF structure to deliver in terms of our mandate. We had the ICMS on the technology front as another. We also had other operational initiatives, the 120 claim settlement, the product-based approach, and all of those. So all of these were running independently, but we were mindful that the impact was going to be huge organizationally. That's why I find it difficult now to even to think that the ICMS has a direct link to the Section 189 when you have these programs running separately. Of course, they were all aimed at making sure that we address quite a number of issues that we're dealing with as the fund. But I will leave the content to also come from Ms. Manyasha. Thank you.
Chair, my simple answer to the question of whether the Section 189 was premised on the ICMS, it's no. And I think that's the context Mr. Mkabela is giving. It was not premised on the ICMS.
Okay. So can we then nonetheless answer, Honorable, because there was a Section 189, right? I'll locate the judgment. We need to find the person who lied to the court.
Some of the questions was the placement process, which had a requirement for qualifications, and therefore there are employees that were placed in the pool. Honorable members, I would like to confirm that at the time the Section 189 process was halted, no one had been placed in the pool. So at the moment, there's no employee of the RAF that has a letter that tells them that you are in the pool, because that process was for bargaining employees in the bargaining unit. And at the time that the 189 was halted, we were not yet dealing with the placement for bargaining unit employees. So no one has been placed in a pool. Are there people that exited because of qualifications? There was a VSP process that was undertaken. I cannot confirm if that those people that applied for VSP were exiting because of the requirement for qualification. I cannot confirm that. In terms of the terms of reference to allow for relaxation of qualifications. That is a discussion that we had recently at EXCO, because, and I think it's after consultation with the labor union, where they came back to us and said, can you please consider relaxing the qualification, because there's a lot of employees that have got a lot of experience, but they entered the road accident fund without those qualifications. So that discussion is still happening between the labor union and the management representatives, and then they will come to a conclusion. But that is being considered currently. It has been presented to REMCO, I think, as a proposal. The original terms of reference were agreed to between EXCO and the labor union at the time. Thank you.
Thank you, Honorable Bila. Are all your questions answered? Because you were in injury time. But are you happy? Is there any question that wasn't answered of your list?
No, they tried.
Okay. Yeah, please do. Please go ahead.
Mr. Mkabele, if my memory serves me well, in our previous discussions, you indicated that you are calling all the people who claimed at the RAF from 2014. Do you remember?
Through you, Chair, I said we initiated a backlog campaign to call every employee in our books, irrespective of the period.
I think you mean claimant.
Yes,
Yeah,
yes,
yeah.
yes. Absolutely. Yeah, sorry about that. Yes. So we wanted to make sure that we have a name and a face to the number that we had in our books, and that is why we initiated that campaign. I hope that clarifies that.
How far are you with that initiative?
We are 95% on that one. We are about to look at how we age this and look at where are we exactly going to be able to get through to those claimants that we haven't been able to reach, as I've indicated. The challenge we have is that every claimant in our book is a liability that we need to take care of. We do have instances where we have plenty of attorneys who have abandoned the claimants. They still remain with us. We cannot write those off. But in terms of the campaign itself, as I'm saying to you, Honorable, we are 95% done.
Thanks, Chair.
Thank you very much. Mr. Mkabela, when you say 95%, just give us the numbers. How many have you quantified as falling within that category, and how many have you reached?
We have reached approximately, I would say, 68,000, which is a mix of represented as well as direct. We left with under 6,000 that we still need to call, which on a daily basis we're calling no less than 500, which means that in the next weeks already we should be closing out on that number. Thanks, Chair.
Okay, so numbers change. So when you say you're calling them, don't you have instances where people have simply changed their number?
It's true, Chair. They change their numbers, but we don't only use the telephone numbers to reach them. We look at the emails. We also are looking at acquiring a tool that will help us to trace them. So the tool that is used by your agencies like your ITC, TransUnion and all of those. Because we want to make sure that we call all of them. So that is our approach, Chair, that we have adopted.
Okay, now we can have a further discussion about it later. I just want to talk to the PwC colleagues about the legal advice that you got. Ms. Gilmore or Ms. Isaacs, did you get anything in writing?
Chair, yes, we did.
Okay. I was hoping you would say that. I'm going to ask Lwazi, can you give her this? I'll tell you what this document is. I'll give you the history to save us time, and then I will ask some questions. You don't need to answer them if you don't know. Oh, Is that the judgment or is it the opinion? Is it the memorandum? It's a memorandum, right? Correct. No, the memorandum is fine. Give it a memo. But no, this one, Denzel. Yeah. Thank you. So let me give you context before you start reading. We'll read together. We will read together later. If your colleagues need another one, I'm quite happy to provide it so that you don't all huddle around that one. Denzel, please pass it on. Okay, so there was a case that predates RAF 1 form, this latest one. The case goes all the way to the Constitutional Court. So it's called the Busuku judgment. I'm sure you colleagues from the RAF know it. You know it, I'm hoping. Can I get Ms. Manyasha? It's particularly important for you in your current role and the design of the system. You know about the Busuku judgment, do you? You really ought to know, I must tell you. It is seminal in this context. It absolutely is. But we're going to go through it just now. So let me give a context so that you don't waste your time. So what you've got in front of you, I've got the judgment. I can ask for it to be printed. And this is why this is so important. We had a conversation earlier, and I've kept asking every witness I could how much it costs to successfully lodge a claim. Because our constitution, the values of our constitution that bring us here, make access to government services a necessity. It's a right. It's not an option. Okay? It's not an option. When it becomes necessary for any person to expend up to 100,000 rand in order to successfully get through the door, it brings to light questions of access. Undeniably so. I don't know how many people here at a drop of a hat can cobble together 100,000 rand for the purposes of filing a claim. So this is why I'm so passionate about this, and I'm sorry if I look it. The judgment is about the amount of information that the RAF expects initially. It is based on an interpretation of the Act itself. The RAF had a form it was utilizing then, and there was a management directive and so on. Right? So the Constitutional Court interprets how the relevant section of the legislation must be applied in practice. That's what it does. Okay? And then the Road Accident Fund approaches senior counsel subsequent to that. Advocate Ishmael Semenya, to assist them in understanding what the judgment actually is asking them to do. I read the judgment. It actually is quite written in a straightforward manner, but that's a discussion for another day. So everything else that the Road Accident Fund does subsequently follows this seminal Constitutional Court judgment as to how the relevant section of the Constitution is to be applied, of the Act should be applied. So I want us to then read together, because these sections are particularly important. And this is why I keep going back and forth on this. Sorry, I think I'm going to need one of those because I think I made my highlights on. My apologies, sir. And I'm saying this not because I want to blame you. I want you to go back and get further legal opinion. So can we go together to paragraph of this legal opinion? Let's go to paragraph 16 first. Okay, in fact, let's go to, paragraph 18, page 9. Okay, so it begins Regulation 7.1 of the regulations promulgated under the RAF Act, and then it reads it. Then we go to paragraph 19, where the court, because it's at constitutional court stage, is now quoting the Supreme Court of Appeal, where the Road Accident Fund actually lost. So can we go to then paragraph 16 in italics of the SCA judgment? Can you see that? Okay. And I'm going to read it because it's I'm the one making the point. It says, the RAF 1 form does not call for detailed information. It is not intended of itself to enable the fund to assess the quantum of the plaintiff's claim. It seeks to enable it to investigate the impact of the injury sustained. In order to do so, the RAF 1 form requires a disclosure of information to guide and facilitate the investigation. On the first page of the medical report section of the form, it seeks particulars of any emergency transport which has been required, whether the plaintiff has been hospitalized, and if so, whether he was in ICU. All of this was contained in the hospital records of the applicant, of the litigant, Mr. Busuku. The third page of the report requires a provision of particulars of the medical facilities where treatment was received and the identity of practitioners who treated the plaintiff. This too was recorded in the hospital records. So they go on. So I'm not going to bore you with the rest of it. Let's go to paragraph 21. Are we together on page 12? The fund issued a directive dated 8 March 2021 with effect from 1 April 2021, which prescribed requirements over and above those stipulated in section 24 of the Act and Regulation 7.1. The fund is not entitled to set such additional requirements for the lodging of a claim. It has no power to do so by way of management directive. By the same token, the fund also has no right to refuse to accept delivery of claim forms. Paragraph 22. It is not surprising that on 15 June 2021, an interim order was granted in the Pretoria High Court, which interdicted the fund from enforcing the directive dated 8 March 2021, pending review. So I diligently went and looked at the review application, which has also made its way, I believe, to the SCA, where the Road Accident Fund is lost. In the absence of legislative amendment, I'm on paragraph 24. In the absence, and this is absolutely critical, because I am going to ask the colleagues from the Road Accident Fund when the Act was amended. In the absence of legislative amendment, Section 24.5 is the only mechanism in the RAF Act that the fund can utilize to object to the validity of the RAF 1 claim, failing which the claim is deemed to be valid, as according to the SCA judgment, non-compliant claims to which the fund has not objected in terms of Section 24 are enforceable. So let me ask my colleagues from the RAF, when last was the RAF Act amended? Put differently, has it been amended since 2021?
No, Chair.
So, we have a constitutional court judgment which interprets Section 24.1 of the RAF Act. It defines what it must say. The Road Accident Fund, correctly in my view, goes to senior counsel for further guidance, and senior counsel writes this. And today we sit with a presentation where you're doing the same thing the Constitutional Court said must not be done. And one of the reasons we are here holding this inquiry is the amount of money that gets spent on litigation, spurious litigation. So we are asking South Africans to spend 100,000 rand, up to 100,000 rand. This is not just about the complexity of a form. It's about access to government services. So I'd like to advise you, colleagues, to go and seek senior counsel's opinion on this and reconsider your position relative to the application of the legislation in this case. There is another judgment. There is another judgment on the latest litigation, which has also said the RAF's own appeal to the SCA does not nullify the court order. The RAF says they've since joined the two. I don't know where it is going. Mr. Mkabelo, can I ask? What happens to prescription? In fact, no, any of you can answer this question. So, the matters, the RAF 1 form, let's accept it's in litigation. You are rejecting the claims that do not have all of these medical reports that cost up to 100,000 rand. Do you keep record of those? In anticipation of a court order that might say you need to onboard them differently to what you are planning to do. Do you keep record of those?
Yes, Chair.
What happens to prescription in the case of a hit and run, for instance, 2 years? How are you dealing with that? A hit and run prescribes after 2 years, correct? The litigation is taking however amount of time that it is going to take. I want to know, how are you dealing with the claims that will prescribe or that have prescribed? Now, I think Ms. Manyasha is a project lead. This is a baby. I need you to answer, ma'am. This is a critical risk to the project in terms of cost, in terms of project scope, in terms of expense, in other ways. Hit and runs prescribe after 2 years. How are you dealing with prescription?
May I request Mr. Kubeka to answer this one?
Okay, Mr. Kubeka.
So, Chair, systematically, hit and run, if that hit and run has not been cured in the 2 years, it will be deemed as prescribed.
That's why I'm asking the question. How are you dealing with it? Because you will have a court order. You will have it. It's not if you will have it. That says that claim that you refused to accept has now prescribed, but you must have it back. So how are you going to cure the prescription?
If there is a court order in this litigation on it, then we are able to cure it, I mean, via the system. So we are able to register it.
So you will interrupt the prescription yourselves? Yes. You've got legal opinion on that?
Remember, Chair, the litigation interrupts that prescription. It's catered for, I think, in the Act, Chair, to say once that claim becomes litigious, then that prescription is interrupted, Chair.
Yes, I know. This is a different type of thing, and I'll tell you why. When an attorney knows that the 2 years is going to prescribe, they go to court. They issue a letter of demand or something. You have Honorable Beasley's mother, who has attempted to lodge a claim on her own. You guys have said no. The 2 years is now gone. How does that get interrupted? Do you notify those people? Have you got a system at the RAF where you know how many? Because that's my next question, because you guys are obviously tracking it. Have you got a system, in this system or elsewhere, where you know that we've got X number of hit and runs and X number of other accidents which are not hit and runs which prescribe a year later? Have you got that system that tells you?
So in this system, remember, Chair, when you come in, we tell you immediately what is wrong with your claim and what you need to fix with the claim for it to progress forward. So we give you documentation or a printed objection letter which will show you when we go through the solution.
You're not answering my question. I am asking because remember, Honorable Beasley's mother has attempted to lodge a claim. You've told her, via letter or verbally or whatever, go away, find an actuary, find an orthopedic specialist, find a neurosurgeon, find all of these people, pay for them yourself, and then come back here. Right? That's what you've done by your own admission. This is what happens. In fact, that person is not able to do so. They're just not able to do so. They don't even know where to go. Right? So the 2 years comes and goes. What happens? Do you guys get back to that person and say your claim is about to prescribe, but we're giving you grace until such time in the future, whenever you can then come back and lodge your claim? Is that what you guys do?
If I can give it a short, Chair, I think it's a question our acting chief claims officer and our legal head would be able to answer. So with respect, we can jot it down and come back to the committee for a response. Thanks.
No, this can't be jotted down. It needs an answer in this meeting because so we all want this system to work. If you were watching, the members were eating out of your colleagues' hands because we want a frictionless process that is going to enable claimants. But we have a duty to also care about the people who've been left out in the cold. I'm asking this deliberately because the Johannesburg High Court instructed the Road Accident Fund to onboard those people that it has rejected as a result of this new form. When the Road Accident Fund applied for leave to appeal, they expressed themselves on it, and I can read that paragraph in that judgment, LPIIF 2. What did the Road Accident Fund do? It tried to set aside that part of the order which says the Road Accident Fund must stay in touch with those people and onboard them. It's a critical factor that affects this project and its capability. That's why I'm looking at Ms. Manyash. It's something you are supposed to know because it's supposed to be part of the project conversations with PwC and anyone else. So, is it part of your conversations?
Chair, I can confirm that the issue of the RAF 1 form and the judgments became a big part of our conversations in the steering committee meeting that we had with PwC. And it was not on one occasion, I think it was more than once, that the executive management that sits in the steering committee, our legal team, as well as the PwC, and I think at the time PwC consulted with their legal team also to make sure that we understand each other in terms of this. So definitely, Chair, it did become part of our discussions in the project steering committee meeting.
So do you have a system by which you can do the following? 1, you keep track of which claims are about to prescribe. So you've got a database of all the claims that you've rejected with contact numbers and everything. Number 2, you know which ones are expiring within the 2-year period. Those are hit and runs. As I understand, you've got another year to report another type of accident, right? So my question is, since it was part of your conversation and you can't take the court process for granted, right? Is my assumption therefore correct that you've got all of those on a list with prescription, with anticipated date of prescription? Because when the court order comes back, you are going to need to call those people. So I'm asking, does that exist?
Mr. Kubeka can confirm, but as he has stated, we do have the records of people that have tried to lodge claims and we have rejected. So we will have a name, ID number, and contact details of that person. We will keep it in the system even though we have rejected it.
Sure. I've asked, my question is fundamentally about prescription.
In terms of tracking the prescription, Chair, no, I don't think we have that system.
So you've got claims that will prescribe or that have already prescribed, that the court will tell you that you actually should have entertained them and you don't even know which of those claims are. That's the bottom line.
So, yeah. So if maybe I can assist Chair. So, I mean, Ms. Manyasha is correct to say from a data perspective, we are keeping all of that data. So we've got the data that will tell us, I mean, hence the colleagues could present the non-compliant claims that we're keeping in the solution. I think where we are not, okay, now I can't see your face.
Okay, just talk.
Yeah, so where we are not keeping, where we are not, it's more on the actioning side to say, we've got the data, have we built those early warning triggers that will enable us, you know, to ensure that where required, we then call the people and we inform them in terms of that prescription that we are not doing, Chair. But in terms of us being able to do that, we can, because the data exists.
Okay, you just have chosen not to do it. Yes, you've chosen not to do it. You've chosen not to do it. Can I ask, before we go on break, as a final question, what are the values of the Road Accident Fund? Ms. Manyash.
It's integrity, it is compassion, it is accountability, it is respect, it is empathy, the last one is empathy, excellence.
Well done. In my experience, employees of companies usually don't remember the values when challenged to say them. What do you understand about compassion?
Chair, I must say, when we crafted these values, we really thought about them. And if you can see, at first it was just I care. And I think a year ago, we added the second E, which is empathy. Because the discussion that we were having at EXCO is that what we are seeing in our system, Chair.
No, I'm just asking, yeah, what's your personal understanding of what compassion is?
Compassion, Chair, means having deep care, if I can put it, deep care for the person that you are dealing with. And that's why I want to explain, Chair, that these I care values that we came up with really took into consideration the claimant. They are for the claimant and not for us, because we thought the claimant, really we understand the pain of the claimant where we are sitting, and that's why this I care squared, and the last E was for the empathy.
Don't try and work out where I'm going. What do you understand about what empathy is?
Empathy, Chair, is putting yourself in the shoes of the other person and understanding their pain deeply.
Can you put yourself in the shoes of Honorable Beasley's mother?
Definitely, Chair.
If Honorable Beasley's mother needs up to 100,000 rand to even be considered, would you say that's compassionate and empathetic? And Honorable Beasley's mother has 2 broken legs, comes from a village, and doesn't know what an actuary is. Is it your contention that the way you guys are doing things and designing this system, that all of us want it to work, it's compassionate and is empathetic to the most vulnerable members of society?
In that aspect, Chair, it is not, and we can admit that it is not. It is not considerate.
Thank you. We can adjourn until 12:30. Thank you. Okay, honorable members, welcome back. Colleagues, I just want to be sure we're not missing anyone who's speaking. No, we're not. Okay. Honorable Madlal, I'm going to skip you because it's your turn. If you are busy, I'll skip both of you. Because it... Sorry? Oh, yeah. Okay, thank you.
Chair, before we continue, I just wanted to raise something, specifically with regards to the cost for medical experts. So in our regulation 6, which talks about further provision for procedural matters contemplated in section 24, 6.3 specifically says, the fund or an agent may, at its cost, at the written request of the third party, pay directly to the medical practitioner or hospital concerned the reasonable necessary cost associated with the completion of the medical report contemplated in section 24(2)(a) of the Act, if the fund decides that the third party lacks sufficient funds to obtain the medical report and the fund foresees a reasonable prospect that the third party could succeed with the merits of the claim. Then 4 says the fund or an agent must determine the request by the third party in terms of sub-regulation 3 within 60 days from the date on which the written request was sent by registered post or delivered by hand to the fund. And then 5, a request by a third party in terms of sub-regulation 3 shall not interrupt prescription. So there is an option for the third party, being the claimant, to then request the fund to provide or to at least pay for the medical practitioner or the hospital the cost associated with the medical report.
Okay, thank you. Let's have that conversation. Thank you very much. That's very helpful. You guys used to have claims originators, didn't you?
Yes, we did.
What was their job?
They would go out on various roadshows and register claims, essentially.
Was consumer education part of their job in terms of how the whole system works and what's supposed to happen, etc.?
I would say so. I'm not exactly completely familiar with their roles at the time, but I would say so, yes.
Okay, I need your colleagues because the road shows was just a portion of their work. They did something else more substantive. Ms. Manyasha, do you know?
It is definitely before my time, but my understanding is that they would do consumer education or claimant education.
Yes, and what else did they used to do?
They would assist the claimants to fill in the forms.
Yes, and what else? Let me make this easier. So the claims originators would do what you're saying, but fundamentally they were stationed in hospitals in particularly in outlying areas of the country, and they would have some facility at the hospital, either a mobile one or in some cases such as Sunshine, they would have an office, right? But they were able to assist road accident victims there. Some of what they used to do was to also assist people with undertaking letters. Your colleague, Mr. Kubega, was here, and you, sir, were here, Mr. Mkabel, right? When you guys were describing the kind of assistance that used to be given to claimants. In fact, to do what you are reading, Ms. Potgieter, right? Okay. Does the Road Accident Fund still have claims originators now?
Chair, recently we have, through the medical department, established, we call them hospital case managers. So we have now, I think we are back in 5 provinces. We have put people back in hospitals as case managers to assist with some of the things that we are talking about. We have implemented that recently. I'm not sure if it's starting this year or late last year.
Okay, so what happened to the original claims originators. This has been canvassed under oath here in this inquiry. Do you remember what happened to them?
The people that came here, they indicated that those people were put back to the customer experience centers, customer service centers, and some regional offices.
Yes, so they were pulled back.
Yes.
Can you recall what happened to the marketing and educational material they used to get?
I have no idea what happened to that. I heard somebody here saying that they had to destroy it, but I don't have an idea of what happened to it.
Yeah, so that campaign was stopped. So one of the things we looked at as the committee was the marketing spend on that process. It fell from 12 million to 0, right? So the Road Accident Fund stopped, pulled back the people that it had to physically assist the people. It stopped telling them about the process, zeroed out the budget so that you couldn't spend any money on it. We were told under oath by the manager responsible that even ads that had already been booked and paid for were pulled. And the Road Accident Fund spent the money anyway. Are you aware of that?
I am not aware, Chair.
Okay. That's a version that the committee has, and it hasn't been contradicted. That's why we went to look on the marketing side, and it was not. Right? So, to your point, Ms. Potgieter, because we do need to get to this. So the people, the actual physical warm bodies get pulled back. Why? Because the board has decided that it is not in its interest, it's being the Road Accident Fund, for people to be able to do direct claims. You want to reduce that number because the RAF Act sees a conflictual process where you must establish fault. Right? There was even terminology that was used here 2 days ago, which is touting. So the claims originators were seen as touts, which is the other unethical practice that lawyers get involved with. I observed that language, and I made a note here on my laptop because it betrays an attitude. They were touting. Right. Let me ask this question. When the person attempts to lodge a claim and they are told that they are not successful because they need certain documents, what conversation is had with that person by way of trying to explain the way forward? No, Ms. Potgieter, you've got to answer that because you came up with you read us the document. I'm assuming there's a conversation that takes place.
Chair, I am too far removed from those individuals that are responsible for the pre-assessment and registration.
So let me ask the question this way. Does the person who speaks to the claimant who is in distress, injured, with all sorts of challenges, say to them, you may not be compliant, but don't worry, we will help you, in line with what you've just said? Does that process take place? Does anybody here know?
Chair, you would expect them to say so because it is contained in a regulation to the RAF Act, but I'm not sure if it does happen.
Okay, I certainly wouldn't know because I don't work at the RAF and none of the members would know whether that takes place. So it's all very well, Ms. Potgieter, to read for us what you've got in front of you there. But what matters is the actual claimant experience, and you actually have no idea whether it works like that or not. Do you? No, please, we need to put it in the transcript.
Chair, no, I'm not there when the claims are registered, so I wouldn't know.
Okay, so does anybody, Mr. Mkabala, you work with the call center, correct? Do you have responsibility for the call center?
Yes, I do. Fortunately, the engagements with our claimants are recorded. We do have that, but also we do have quality assurance to listen to all the, the conversations for coaching purposes. Because to your point, Chair, about our values, it's not about having them on a piece of paper, it's about living those. So that's part of those interventions that we have undertaken to make sure that we are seen to be living by those values. So indeed, we encourage our agents to show or to display their values as we have them. Thank you, Chair.
Now, the statement is broad, so I'm asking about a specific thing. So, in the event, by the way, that someone, because I think the rough act is also archaic in the sense that you either mail the thing or you deliver it. I don't know. Yeah, it really shouldn't be saying that in 2025, but that's a discussion for another day. I just want the assurance that what you guys are saying here is that when someone attempts to lodge a claim, whether represented or not, you then say to them, we can see that you are struggling in obtaining these medical reports and all of these things. Can we help you and we will pay for them? Can you assure us that that's what you do? Because then we will ask you to draw the report and we want to see.
Chair, I think from an observation perspective, while we're implementing the solution, where there is an instance that somebody is battling, the consultants, the pre-assessment consultants do actually, Chair, explain the actual possibilities and things that could be done to whoever is sitting, in front of them. Both in our, what do we call these walk-in centers and the regional offices. That does happen, Chair. Whether we can draw a report in terms of how, remember these are verbal conversations, Chair. So we wouldn't have, data that would support or that we can report on that, Chair.
Now, in order for what you're saying to be meaningful, I'm gonna need the following on behalf of the committee. We can move on because Honorable Matlala has been waiting. This is what the committee will need. We need the total number per annum of claims rejected since RAF 1 form. We need the number of follow-ups where you guys have assisted, the number of claims where you've assisted, in other words, to rehabilitate the claim, as it were, and then we will need how many of those were subsequently rehabilitated. Okay, can we please have that by close of business tomorrow? Honorable Madla.
Chair, Honorable Plosa has made a plea to go first, and I've allowed it, so I'll come after you.
Are you chairing now? But it's okay. Since he's our old colleague, it's fine.
No, it was a mutual agreement, Chair. It doesn't need a lawyer. We've settled amongst ourselves. No, greetings, colleagues. So I've requested you just to go first so that I can step out for some other engagement. Greetings, colleagues. Are you well? Are you well? Yeah. No, it will be okay. Look, Mr. Modiba, yesterday I asked you a question to say, is there anything that the Road Accident Fund has tried to do to try and reform the entity and to make it better? And you guys have actually received support for. And without paraphrasing you, but your response to me was no. And it's coming across again today, for me. Now, I'm failing to understand that I see a very difficult position for the Road Accident Fund. I don't know whether you guys need to be compliant with the law or you don't need to be compliant with the law. when you guys are appealing cases in court because you believe strongly that you've got a point, we accuse you of wasting money on lawyers. We deem those issues to be illegal, as if it's not the Constitution that allows appeals. It's allowed by the law. If you guys were not allowed to appeal in the Supreme Court of Appeal, to appeal to the Constitutional Court, it's lawful. Why are we creating an impression that it's unlawful to appeal a case that we have lost? If the Ref 1 form is in contention and you guys are in court, PwC is saying that their understanding as well is that this Ref 1 form is legal in its standing currently up until it's set aside by a court of law. No matter how many cases you've lost, but if there's still grounds to appeal, it still stands. So I just want to say that for me, again, I'm struggling really. And I'm not in any way saying that, I keep making this point, that I'm not saying things are lovely-dovely at the Road Accident Fund. But everything that comes across, it just seems as if you guys are just doing bad in that institution. There's nothing right that is going on there. And I don't believe that is a correct analysis. I truly don't. Now, I'm a member of the EFF, colleagues. And I think I can speak with authority in terms of representation of black people and the marginalized and the poor. But law always have unintended consequences. We've got children, my hometown is in Nkandla, that's where I come from. We have people there who give birth at home without having access to medical care. And the unintended consequences of the collapse of the system for medical care is that those children then struggle to get IDs or birth certificates because they've been born in an era that is not recognized. By the time they try to register that child, there are no documents, there are no medical reports, there's nothing. And the unintended consequences of that is that children then don't get access to social services, can't get child grants, they can't get NSFAS. Now, when that person who is non-compliant because they don't have a birth certificate, we can't blame social services for not giving the child grant and say that social services or whichever department is responsible to give a child grant is non-compassionate because they are not giving this black child social grant because she doesn't have a birth certificate. Home Affairs must find a way to deal with that. So my understanding of the RAF 1 form, now that's where I'm coming, I need you, Ms. Manyasha, and Ms. Potgieter to come to this. My understanding of the RAF 1 form was that it was trying to mitigate against, what did you call it, Mr. Modiba, yesterday? You called it the unidentified claims, fraudulent claims.
Yes, yes.
Whereby if people are able to register claims without the relevant documentation, it opens up RAF to a possibility whereby RAF becomes liable to a claim that is non-compliant, that doesn't have documents, that has a blank file, but you still need to pay for that form anyway. And I think that's what the RAF 1 form is trying to achieve. Obviously, there will be unintended consequence to that, but to then want to vilify this form as if it's the most illegal thing that has happened in history, I don't think that is correct. I think the battle here is the cry for these lawyers who are unable to access these funds now because of this RAF 1 form. Because now, even with PwC coming with this system, it means you can't enter a system without the relevant documentation. There can't be duplicates. So who are losing out are the people who are exploiting the system. What's the actual intention of this RAF 1 form? Can you just clarify that for me?
I'll start with my comments, Honorable Blosse. When we looked at the RAF 1 form, as Mr. Modiba and other colleagues have explained, it was for us to be able to collect information that is helpful for us to be able to process a claim and finalize it, with the aim of complying to the law of processing and finalizing a claims within 120 days. If we receive a form that does not have all the relevant information, it will sit in our system for more than 120 days, 5 years, up until, there's claims that are sitting with us for more than 5 years. And what we are referring to as the previous project that the RAF did at the time, it was the previous management that decided to go that route. And they went out to communities, educated the communities and said, if you've ever been in an accident, bring us a form. And there would be communities, people in the community that would say, Mr. Blosse, I was in an accident, and then you were not, but come, let's fill in a form. So we would have a lot of fraudulent forms in our system. And that's why we are sitting with the backlog that we are sitting with. So the RAF 1 form was to assist us. And I think maybe my colleagues should maybe assist in terms of the percentage of people that actually come directly to claim with the RAF and the percentage of people that claim via lawyers. Some of these documents that we are missing are from law firms and not necessarily from individuals. So the law firms have the ability to assist people to bring all those documents, but they still choose to bring documents that are incomplete, which is causing a problem for us. And once they do that, then they attract legal fees, because once the 120 days passes, then we start accumulating legal fees. I think there's a conversation, I'm not sure if it was here or it was in the portfolio committee, where we raised the fact that the RAF Act is cruel, especially to the poor, because the RAF Act actually does not give the poor the opportunity and the easy access that it should give them. So this act, and that's why we were proposing what we were proposing in terms of that, and I'm happy that we are allowed to also put those inputs into the upcoming RAPS bill. But the RAF Act, if you look at it, was not meant to help the poor. And that is the problem. And our plea, I think, that's why I'm saying, I'm not sure if it was in the portfolio committee or here. We need Parliament to please assist us so that we can reform the legislation to allow people to come directly. And I remember someone made an example to say, as I'm sitting here, if a family member of mine is in an accident, I can't help them because of the money that we're talking about in certain instances. We need to be able to simplify this thing to make it as simple as possible that any person sitting wherever they are sitting will be able to do this. And that is what Custom Engage is also going to do. We're going to go out as soon as we finalize with this system to make sure that we engage people, we educate people, we do videos to show people how to go about claiming in this system. However, the legislation really needs to assist us. Thank you.
It's an act that is not pro poor, but it needs to be beneficiary to those who are poor, and that's a problem with the Road Accident Fund in its current form. That it's designed to benefit those who've got means, and when you try to reform that, because now you are taking away money from people who've got money, then you are fault for that. Because even this issue of quantum, I don't understand that. Why would an entity of government have an approach that it should benefit more a person who's already got money than a person who doesn't? Because it means me now sitting here, if I were to get in an accident and break my leg is more expensive because I've got a pay slip than a friend of mine from Kandla who is sitting at home. So it's not a system for the poor. So when we are fighting not to transform or to reform RAF, we are not fighting for the poor. In majority, which is our people, our black people. So that's why I'm saying that from time to time, we need to clear the storm. Ms. Potgieter, there is something you were... There's something you were reading for us. Can you just read that again and just tell me what is it that you are trying to express?
So it's in the RAF regulations, Regulation 6.3. The fund or an agent may, at its cost, at the written request of the third party, then this third party being the claimant or its representative, I suppose, pay directly to the medical practitioner or hospital concerned the reasonable necessary costs associated with the completion of the medical report contemplated in section 24(2)(a) of the Act, if the fund decides that the third party lacks sufficient funds to obtain the medical report and the fund foresees a reasonable prospect that the third party could succeed with the merits of the claim.
Okay, so it's the RAF Act that envisions that claimants must be able to provide these documents and pay for them themselves or through their lawyers.
It does, but then it makes provision for the fact that if you lack sufficient financial means to pay for these, you can approach the RAF in a written correspondence to request for these to be paid on their behalf.
And then you guys will make the determination at that point and then try to assist. Okay, no, that's fine. I'm really against the involvement of lawyers in this whole thing. And we need to find a way to get rid of lawyers at RAF. I don't know how, because, again, the way RAF is structured is that it deals with litigations. I've got a case sitting with a case, and I've submitted some of these cases whereby, you'll know, you guys, we are on a campaign as the EFF to say people who have been affected by RAF, they must come to us. I'm sitting I don't know why people are laughing when I'm talking, Chair.
Honorable Atkinson, the member has the floor, so let's not interrupt.
Yeah, it's very disrespectful. Because we can return the favor. They are still laughing.
Colleagues, please, can we just manage ourselves, please?
So, I've got a case of a young girl who's from Limpopo. Her name is Tato. This is Tato Masetsebe. She's from Limpopo. She got in an accident. She used lawyers. The claim was successful and paid to the lawyers. And the lawyers came back to her because she was young at the time. She was 14. The lawyer said that they've been ordered by the court to open a trust account for her, and she cannot have access to the money until she's 21. She's 22 now. She still haven't received the money. The lawyers have gone AWOL. It's being suspected that they've even closed the law firm. She doesn't know how much was paid. She just knows that the money was paid because the lawyers confirmed to her and her mother. And they made a claim that she cannot have access to this money until she's 21. Do you guys have a comment on that? Or how can we assist them?
I mean, I think these are obviously...
Sorry, Chair.
Yes. Honorable Maduna.
Chair, in the interest of time, is it possible that you provide Honorable Bloss with transcript of the meeting when we met either the LPC or the LPP, the other ones? Is it possible?
I think also allow Honorable Bloss to complete his point, Honorable Maduna, and then we'll make the
What gives him the impression that I wasn't watching?
No. I'm protecting you, Honorable Bloss. Honorable Maduna, allow Honorable Bloss to complete his point without interruption.
Yeah, people must not point.
To your point about time, Honorable Bloss, please complete.
No, but why is he even complaining about my time? In interest of whose time? It's my time. You are timing me. So in interest of whose time?
Okay, Honorable Bloss, I'm with you.
Yeah.
This is why I'm asking him to stand down on this.
Yeah, in the interest of what time?
Okay, please continue, Honorable Member.
Yeah, so I mean, if they are interested at least in the detail of the value that has been paid out, they can certainly phone the call center, and the call center should be able to provide them with that level of detail. But I would also suggest that they go to the LPC and lay a formal complaint in terms of this particular lawyer. Certainly, once they have been given the evidence that when was the claim paid and the value of the claim, then they must go to the LPC and lay a formal complaint with the LPC against this lawyer.
Yeah, I think we have submitted a lot of these cases. And part of the problem with the LPC itself is that some of these lawyers, when they get access to these monies, it's either they change law companies, they change everything else. So there's a whole lot of problem even there, even with the LPC itself. That's why I'm saying we don't deal with things just on the textbook. We are practically on the ground dealing with this. I'm receiving cases directly on a daily basis on issues of RAF, and we've been submitting to you guys some of these cases, and some of them we've not received responses. So that's why I'm dealing with this specific case. So I don't know why other members are just jumping up and down here when I'm the one on the floor. Now, PwC, this then links to the question of the engage, right? To say that, yes, there's the call center, but sometimes there are also some difficulties there in terms of our people then getting access to this thing. So I want you to talk to me about the engage, customer engage that you call it, to say when can we expect that to be up and running, and how is that going to assist in this particular case that I'm giving reference to? Because I want to know that the claims that have already been paid, leave the ones that might be in process on their way, but what about the claims that have already been paid that we might want to check? Because there are a lot of people who are saying, I don't know what happened with my claim. You find that the lawyers have been, because some of the lawyers, what they do, when they get a claim, they become as if they are saviors of these people. They say, no, listen, I'll give you 10,000 rand every month up until your claim is paid. Khana, he's already gotten 1 million. He pays 10,000 to this person for 12 months. After that, it disappears. So, and again, it is the law that is a hindrance, because the law says that the law firm must open a trust account on behalf of the claimant, and the claimant never knows whether this thing is done or not. So how can customer engage assist our people, and when can we expect it to be live?
Thank you, Honourable Member, through you, Chair. So first of all, in terms of the when we can expect it, that I will have to defer to the RAF, because it is in their hands as to when they will go live with Customer Engage. In terms of the functionality of it, for all claims that are in ICMS as of the go live date, so as long as it's been captured and processed within ICMS, once Customer Engage goes live, you will be able to see the full history and status of a claim. So then it would be easier for claimants to be able to understand exactly what's being paid.
So the cases that would have been there before you guys took place, we won't be able to because there won't be no data for that.
That's exactly right.
Okay, no, that's fine. Maybe just as a final point to the guys at Road Accident Fund, for me, I think we need to have a different conversation, which is correct to say then those people who might be disadvantaged because of the RAF 1 form, the new RAF 1 form, what then becomes the mitigating factor? But not for us to be seen as if we are fighting for the Road Accident Fund to process uncompliant claims. I don't think that's a conversation should be, whereby we are saying, no, this person doesn't have an ID, this person doesn't have these documents, therefore process them. What we should be saying, especially as lawmakers, is to say, we see the effort, we see what you are trying to do, but listen, there might be loopholes here. There are our people who might be disadvantaged because of this thing. What then becomes the mitigating factor for that? But not that we seem as if we are pushing back to say, drop this RAF 1 form, it's illegal, it's unconstitutional, there are people who are being disadvantaged, whereas we are not even fighting for those people. We're not even speaking for the people who are being disadvantaged about this thing. What we are fighting for here is the lawyers who are failing to loot the system anymore. So for me, I'm saying the conversation should be different. To say, how then do we capacitate RAF, or what then becomes the possible solutions to these challenges that you might be facing with this RAF 1 form. But to say that it is unconstitutional and unlawful to fight in the courts for anything, I don't agree with those sentiments. Thank you very much.
Thank you, Honorable Blosse. Do you colleagues want to comment? I understood that to be a comment by the Honorable Member, but I'm giving you an opportunity. Are you taking up that opportunity? Okay, I saw a thumbs up. Honorable Madlala.
Thank you, Chair. And greetings to the delegation, to the honorable members, and to the public more especially. I want to start by a comment. I will try not to make it too long because I've got limited time. To say that the last national elections presented a new dynamic and an opportunity to this country, an opportunity to turn things around. So we are taking a very sharp turn to the left. And it's strictly to the left because we need to prioritize our people. We are vehemently opposed to big corporates looting funds from state coffers. At the center of our operation should be the people at home, the marginalized, unemployed people who are mostly occupying the stairs of RAF as claimants. And some of us are not really excited by a rhetoric of transformation because we at least understand from a political conscious point of view what transformation means. And it must be live, it must be experienced. So a suggestion that we are transforming a system while depriving our people access and subjecting them to big corporate law firms who can afford to pay for their medicals at 100,000 and be able to be paid by RAF in the next 300 years, because also RAF takes forever to pay these law firms. Because a small law firm cannot technically afford to even pay for those medicals and claim and get the money in time from RAF. Does not seem to suggest a picture of an institution being transformed. If anything, transformation should mean easy direct access for the claimants and an elimination of a middleman who takes exorbitant funds from the money that is supposed to go to the claimant. And if we wanted to be more technical, we'd also comment on your contracted PwC in terms of their outlook, in terms of even delegation here, in terms of transformation, if we wanted to go that route. But we have limited time to deal with that. Now, I want to first ask the question on the feasibility study. You've got a project that seems to be having hiccups. I want to know if there was a feasibility study done to ascertain the possible cost escalations, the possible required interventions in terms of data integration, and all the other issues that we seem to see today, if that was done before the commencement of the project, so that we can be able to say what is the possibility of its success and what amounts is going to be required, what interventions and what other projects within it are going to be required to be put in place to ensure that it is successful. I just want to check if that kind of a feasibility study was conducted at the beginning before the implementation. Thank you.
Thank you, Honorable Madlala. Yes, there was a benchmarking study that was conducted early 2020 with institutions that are doing similar work, both locally and internationally. One of the organizations we benchmarked with is Discovery Health and the Compensation Fund to see what systems they are using.
Sorry to interrupt you. Maybe you're still coming there, but I'm trying to be economic about my own time. Not a benchmarking study, a feasibility. You know, before you start a project, you sit down, you look at the complexities, the micro and the macro environmental factors, the likely cost escalation, because we know that the price of rent today will not be the same as in 3 years or 5 years' time. So we must project for cost escalations, make a budget and be able to say between this financial year and that one, these are the possible cost escalations. There's going to be data migration that's going to be needed. What kind of team and plan do we need to put in place? Do we have the capacity to do that? And all of those kinds of nitty-gritties that you deal with when you are making an assessment of whether we're even ready to get into the project and start implementing it. That is the kind of a study I'm asking about.
To my knowledge, Honorable Madlala, that was included in the benchmarking study that I'm talking about. The feasibility of this project being conducted and being finalized with what resources. So all those aspects that you're talking about were looked into.
Thank you. Was it able to pick up some of the issues we're seeing now in the report as impediments or as causing delays, and what were the mitigating strategies that were then deployed as part of an intervention to resolve them, so that we can see if they are being implemented now or if for some reason we are not able to then put them into effect, but we had already planned for them at a strategic management point of view?
Yes, the possible challenges were picked up at the time and were planned for. For example, the challenge that PwC spoke about of adoption is one of the things that were picked up, and plans were made to mitigate those.
Then why are we having a delay now? If they were planned for, picked up, projected for, and interventions, deduced into writing in terms of how they're going to be mitigated, why are we having a delay today?
Honorable Madlala, projects will have challenges, and the people that we were benchmarking with obviously gave us tips in terms of how to deal with them. However, the mitigation plans, they do work to a certain extent, and we continue to make sure that we improve if something is not working. However, it's not something that came as a shock that we are having this adoption problem. However, and that's why at the beginning, change management processes and a change management strategy was developed to make sure that we deal with that problem.
All right, I'm going to proceed with my line of questioning, but this is what I want to say as well, Ms. Manyasha, and I think to some degree, you are one of the people who have tried to help us because you were honest about certain admissions. Some of us were even, we had a heated discussion in the committee about the necessity of investing so much of weeks and time on RAF. We know there are many issues, water issues, there are many crisis issues in the country. But we only came to an agreement that it is necessary because we said this is going to be our benchmarking exercise. This is what we are going to use to ensure that we generalize across the state-owned entities in terms of governance systems, financial control systems, and legislative reviews, and all of those kinds of sorts. So we're not only dealing with RAF here. So for executives, what helps us is when they are honest. And when they are not honest, they deprive us and the entire nation of an opportunity to turn around all these SOEs, which are all dysfunctional. And when we're saying they're dysfunctional, I'm not saying you are incompetent. So at your level, you should understand the emotional intelligence of separating yourself from the entity and understanding that there are systematic issues which may be even above yourself. So what I need you to be honest about is whether those projected issues and interventions deployed were adequate or they were inadequate. And I need your honest answer on that, then I'll move from it. Because if you are saying that we had foreseen these kind of challenges as likely to be coming up, and we had deployed the necessary adequate interventions to mitigate for when the time arises, then we shouldn't be having a delay. So I want, and it's for everyone who may answer, for us not to try to be smart about it, to just be honest and say, we did not see this part, or we saw it, but we thought that the intervention would be adequate. We came to realize that it was not properly planned for, or whatever the case is. You may respond, and then I'll move on from this. Thank you.
Thank you, Honorable Madlala, and thank you for that comment. We do put mitigations in place, but as we move along the project, as a big project that many people in the RAF have not been involved in, we must admit some of the mitigation that we put are not adequate. For example, the resourcing of the project itself, and especially from the technical side, the ICT side, was not adequate as we would have expected it to be, as a project leader, I would have wanted it to be. Secondly, the adoption part, as much as we've put change management strategies in place, we did not foresee the resistance at the level at which it came. Because, I mean, it's a big organization, it's a big project. People are used to be doing things in a certain way for many years. And, you know, especially a technology project, some of us are born before technology. We still prefer those boxes and papers that are sitting in front of us. So those were identified. However, I think our mitigating factors, our mitigations were not adequate. As you said, let's be honest about it. Mitigations were not adequate in terms of resourcing. For example, that's the first thing that I'm much aggrieved about. The resourcing was not adequate for the project.
Thank you. Moving on to the next set of questions. Some of the project objectives spoke to reducing legal costs, ensuring that timeous payment within the set days, and promoting direct claims. In terms of your own assessment, have we achieved any of those project objectives? And this given the information that has been presented to this committee about the cost per claim and its escalation over the years, are we now able to pay in time for particularly where there are submissions? Because there's a huge allegation that even where documents are fully submitted, the payments are still not made in time. And this brings me to one of the slide, which is slide 17, which speaks about 711 claims in ready. Okay, I think the English, I don't know how it's written here. 711 claims ready for payment, awaiting approval. 236 claims in aging, ready for payment but not yet due. In the context of that slide, are we paying on time where documents are all now fully submitted? Let me not go into the promotion of direct claims, which is in contradiction with what the RAP forms actually does. Can you answer that? Thank you.
Okay, let me take that one, Honorable Majala. So where we do have everything complete, from a process perspective, we are, hitting our targets. But I think what we probably do want to say, our PwC colleagues mentioned it a little bit earlier, that we did have a bit of a hiccup in terms of the integration, one of the integrations with SAP. So that did create a bit of a backlog in terms of the payment side from a claims perspective. However, the solution does work, it does pay, so we're just now pushing that backlog to make sure that those payments, we can clear them out.
And the legal costs, have we reduced them? The legal costs per claim, that was part of the objectives, I think, of the system.
Legal cost per claims, not yet. We are unable to measure that yet. I think that measurement we will then start to track once we bring online the litigation component of the solution.
Statistically, if we are saying that we do make payments where all documents are in, and saying this under oath, what would we say out of 10? So when full documents are submitted, in any case, you don't accept a claim if there's no full documents. So where full documents are submitted, how many out of 10 do you pay within the 120 days? An average, you estimate 7, 9, 6, 5.
In the last, I'd say in the last probably 6 to 7 months, I'd say we're probably sitting at about 4 because of that SAP integration, issue I spoke about.
All right, I may run out of time soon, so let me move on to the next question. Let me ask a quick question. How effective is the RAF call center? I've heard that there's no response. People, when they are calling, when they're writing emails, they've got challenges. We're now adding a systematic component, which I think if someone has got a problem in the system, they need to call somewhere. Will it be the same call center that's going to be called to provide technical support if someone cannot, and are we capacitating it in terms of both the skills and training for the system, but as well as the effectiveness. And you can say it if people are lying, if they are saying that. So if I can take my number now and dial it, it would be picked up by someone who's going to ensure that they address the concern that I raise. How effective is it in line of both its substantive duties, but also the future, extended responsibilities?
Okay. Honorable Madlala, thanks for that question. The fortunate part about having a contact center is that you've got matrix that you can rely on to assess yourself, both inbound and outbound. Our average handling time for inbound is 4 minutes and 25 seconds. For outbound, it's about 2 minutes and 35 seconds, there and about. In terms of its effectiveness, I can tell you now that each time the claimant calls us, we're able to assist them. Our first contact resolution rate, it's sitting at 97%. So in terms of the pure numbers, which they say numbers don't lie, and it's true. That's where we are. What we also do as well, Honorable Madlala, is to make sure that we constantly are making sure that our agents are effective to the extent that almost every day there are coaching sessions, so that we're able to offer the right level of service to our claimants. And something that we're not used to, which we're getting, by the way, are compliments. Which is a bit strange, but nevertheless, we're not used to that, but we'll take it.
Yeah, thank you. You've supported your answer with some statistical fact. We'd like to have those, Chair, so that when people are trying to make a claim, we can defend you. Because we're not here to attack. We can say, no, RAF is doing exceptionally well when it comes to their call center. We'd like to have those on record.
Can I also have stopped your clock, Honorable Madlala, even though you're in injury time, but I've stopped it anyway. So can you also assist us with the following, some historical volume, historical information as well. So call volume handled, and also, so you said, so you've got your average waiting time, right? You've got all of those things?
Yeah. I've got a very comprehensive report. Which covers
average waiting time, calls dropped.
Yes.
And also matters close. I mean the closure of the matter. Would the resolution rate. Resolution rate. Thank you.
Yes.
Thank you.
All right. On injury time. Yeah. So the next questions are going to be close-ended. One, in terms of the backlog, have you guys considered a tracing company? Finding a tracing company, those companies exist, and I think that there will be cases logged with you, so you'll have an ID. Those companies have got agents who even go to the ground and try to find people. Before you cut off, have you considered such interventions?
Through you, Chair, the answer is yes. Honorable Madlala, as I'm speaking to you, we are busy trying to onboard a company that could assist us to trace where those claimants are. What we know is that the TransUnion as it stands is very limited in capacity. So there is a solution out there in the market. I'm not going to mention the name, but quite comprehensive, and we're comfortable that it will assist us to trace those claimants, because you don't want to close a claim until you have spoken to a person who lost it in the first place.
No problem. As long as you're saying that you're doing it, because I'm aware that there's quite a number of companies that do that tracing job. But if you're saying that you are doing it, we'll follow it up on some other time. I was just concerned because there seemed to be a feeling that we're not moving anywhere, and we may end up having to cut without having reached the people. But thank you for that response. Second, last question speaks to the... no, let me just make it the last question. The comment you made, Mr. Potgieter, about a provision in the Act for a claimant to request for payment from RAF. I heard you correct. Is that so?
It's a request for RAF to pay for the medical, or to the medical practitioner or the hospital that is required to provide the medical report for the purposes of submitting a claim.
Right. that is currently applicable.
It's in the regulation, yes, it's in the current regulation.
Is it applicable under the RAF 1 form? Because this is the context within which I understand the RAF 1 form, is that you may incur expenses of someone's claim that may not even be considered. Because you speak about someone here whose claim has not been accepted by RAF, who wants payment for a medical report.
Yeah.
So the RAF 1 form wants you to submit the full documentation for it to be even accepted and processed and all of that. So is that not in contradiction? I just the clarity, and that will be the last question, Chair. Thank you.
No, this would have to be prior to the submission of the RAF 1 form, but it does, however, say that the fund should foresee a reasonable prospect that the third party could succeed with the merits of the claim. And it also states further that the request does not interrupt prescription. So I think this would be a process that is initiated prior to the submission of the form and the registration of the claim.
Definitely, we share the same understanding. My only question is, how will then the fund arrive at that when it does not accept anything unless it's complete? Because you are saying the fund must make a reasonable assessment of the probability that this claim may go through. How would it do that? Because it does not accept any documents before, because you need documents to be able to arrive at that conclusion. Logically, I would think that is the case. But the fund does not take anything. It wants a bulk of everything combined. Part of that bulk include documents that the provision says someone may request the fund to pay for. But for the fund to pay for that, the fund must make an assessment of whether there is a probability of getting that. That is why I'm saying, is there no contradiction between how the RAF 1 form is applied and that particular provision? That is definitely the last question. Thank you.
Ms. Potgieter, you look like you wanted to address something. I don't want to deny you the opportunity.
No, it's fine, Chair. I take the point.
I am interested, though, in because you know, notwithstanding any passions that get inflamed here during our interactions, we still want to get to a solution. This question is actually important. I think it deserves a comment from the Road Accident Fund. It really does.
Chair, so it does say that it must be made in writing. It doesn't necessarily stipulate the form, or at least the template in which it needs to be submitted on. So that it must be a written request, and then we, being the fund, must make a determination in terms of the request from 60 days from the date on which the written request was sent by registered post or delivered to the fund. So I don't think it requires the submission of the form. I suppose the details that would be contained in the written request would certainly have to be related to the, I suppose, accident report, which is one, certainly for the purposes of merits determination. And then secondly, it would obviously have to provide a bit of detail in terms of why the third party is believed to lack sufficient funds. Those would be my submissions, Chair, but I don't think it requires the entire submission of the RAF 1 form. It doesn't say so.
Okay, no, thank you very much. We're going to break for lunch, but I don't want us to come back to this topic again. I want us to just address it. Okay, so somebody attempts to submit a claim. They need all manner of things. Funeral, they might have some pain, and so they need medical assistance, or whatever the case might be, right? So I need someone to now walk us through the experience of the claimant so that we can get a proper answer for Honorable Madlala, which is very important. So I've got the basics, the ID and all of these kind of things. So let's not hang too much on that example as a problem. Most people have IDs. You've got your IDs, you've got everything, right? By everything is by way of basic information. You might not have your pay slip and this kind of thing because you do a piece job, so you don't actually get a pay slip, etc. What is that person told? They are non-compliant substantively in terms of the procedure right now. What are they told? Does anyone know? I mean, Mr. Mkabela, you work with the call center, so I would imagine that your people can answer any question that they get. So what is that person told?
Or maybe before that, Chair, if I may, we've just finalized a process through which you're trying to capture the real experience of a claimant.
No, sure. But let's talk about 5 months ago.
Okay.
Yes.
What we are doing is through our agents to convey the message in a manner that assists the claimant. Not just a code, not just a language, and not just a piece of paper that is given to a claimant to say you are not compliant. Also a commitment from our side to say, should you provide these documents by week 2, week 3, it will assist us to settle the claim. That is the manner in which we approach this, but we appreciate that it's not as easy as it could be, because you're dealing with someone here who needs that support and who wishes for the process to be concluded as speedily as possible.
Okay, so what is that term again? You assisted me. Maximum medical what? Your maximum recovery. What is it called? Maximum medical improvement, which is we know you will not be able to recover any more than you have, right? Is that report required at the beginning? It is. How long on the medical recovery journey? Let's take somebody, leg broken in 3 places, crushed arm, crushed clavicle, and so on, right? Badly injured. They want to lodge a claim with the Road Accident Fund. Can that determination be made after a month? No, I need somebody to answer on the microphone.
No, Chair, I'm not a medical doctor, but I wouldn't say so, no.
Okay, but that report is needed, right?
Correct.
Am I correct to say the manner in which this is applied forces the most seriously injured person to wait until that determination can be made? Is it true?
Yes, Chair. I believe so, yes.
Okay, I want to make sure we get no contradiction here, because if that is required at the beginning, it means you must go through ICU, you come back to critical care, you go on to a general ward, you go on to rehabilitation, and so on. And then only at that point can you submit a claim with all the documents that comply, right? That's a system that you guys have designed. Is that so? If that is not so, I need to know on behalf of the committee and the public how that is then interrupted earlier on. Yes, sir.
I'm going to give it a shot, Chair. I am not very close to it as well, but what I have observed is you will walk in, you don't have everything you need. If you require medical attention at that point in time, then first point of contact, the guys would want to try and establish if they can. Once they have proven that, yes, it was, you were involved in an accident, is to try and get you an undertaking. This undertaking will make sure that it facilitates your rehabilitation up until a point where, what's that term we were talking about? MMI can be reached. Then upon, reaching that MMI process, then your claim is able to then to be progressed further.
Do you need a link number to access those undertakings? So I need to be certain, Nipi, that this is what you do, right? No speculation. When you've attempted to submit, you don't have everything, but you're complaining of headaches and dizzy spells and all of these things, but your documents are not complete. Do you get a link number?
No, that one, Chair, I don't think you do. But I think if you go through the process that Mrs. Potgieter was referring to, because you have, you would have
I do expect you to know, as the guy who works with this system that has brought us here today, it can't be you, not of everybody in this room. You are the one guy who is supposed to know. Does the claimant get a link number? Because I believe the link number is the holy grail that gives you access to a whole bunch of things, including the tracking of your claim where it is. Do you get a link number? If a person, and the guys from PwC can tell us, if your claim is rejected, do you get a link number?
No, you don't get a link number, Chair.
What do you get?
Claim is rejected.
What do you get?
What you get when your claim is rejected, you get an objection letter.
Right. So you're telling us that on the basis of an objection letter and no link number, which is the digital fingerprint that identifies this person as falling within that definition, you guys give people access to medical treatment and that kind of thing. Is that your statement?
No, Chair. What I am saying is that you come in, you bring in, you get objected. Once you've been objected, you then go through that regulation or that dispensation that exists in terms of the Act to say, I'm unable to provide you with further information. Right? Me being unable to provide you with further information, I need assistance to be able to get that medical report, be able to do this and that and that. Then the fund assesses that, gives you a response in terms of being able to give you that assistance so that you are able to then get those documents and then progress your claim forward.
Thank you. I think you've answered me. So here is the answer that you're giving me in substance. Until the person's maximum medical recovery, I keep calling it recovery, okay, has been determined, you offer no other assistance to them. You can't. You've rejected the claim. You've just given them a rejection letter. The person is suffering from dizzy spells, broken leg, pains, and so on. You offer them nothing. That's the effect. Because if you need all the documents, the reason I was asking about this MMI at the beginning is because it takes time. The more seriously injured you are, the longer it takes to be able to produce that document, because you are in treatment and rehabilitation for an extended period of time. You can't get it after a month from ICU. You can't even file a claim successfully. You can't even sign for it. Your ID might have even been lost in the accident. These are the realities of being in an accident, right? So what you guys are telling us is that you don't offer any assistance at that stage until every scrap of paper that is available is there on file. And unless every scrap of paper is available, including being able to get another ID because you are so broken up, you don't know where your wallet is. That's what you guys are telling us. We don't need to belabor this point any further. And I just want to say again, to the extent that in this whole process there are wild conspiracy theories, where I come from, and my understanding of compassion and empathy and the constitutional right to access, you guys are failing. Thank you. We can break for lunch. We'll be back at 2:30. Sorry.
For the record, correct one thing. The MMI is only for general damages. Sorry, I I confused it, but it's only for, because general damages is linked to serious injuries, and you needed to have reached your maximum medical improvement for the general damages to be calculated. But for other post medicals or future medicals, loss of support and loss of earnings, those can be done even before MMI has been reached. I just wanted to set the record straight. Thank you.
Okay, thank you. That tiny detail is important, but it's immaterial in the bigger scheme of things. You know why? Because ultimately, you still need. So the reason, I'll tell you now, the reason MMI is important, you know why? It helps you with your calculation of loss of future earnings. Doesn't it? Doesn't it? You need that report to determine whether Honorable Atkinson actually will play for Chiefs one day or not. Right? Yes. So thanks for telling us, but it means nothing. So can we come back at 2:30? Thank you. There is a canteen downstairs for our guests. You welcome there and you don't pay. Welcome back, colleagues, honorable members, welcome back. I just want us to get to the end of the ICMS conversation, and then we will deal with matters relating to the financial side, costs and all that. Some of the matters outstanding from yesterday. If we don't tell long stories, we should be able to get home before sunset, I'm hoping. So let's try and get out of here before sunset, because I'm not keen to be at night. Honorable Maduna, I don't know if you have any questions on the ICMS system. So Honorable Atkinson has left. Honorable Isaac is not here. I will simply return to him when he walks in. I just want to ask Honorable Bila if you had any outstanding matters. I just have a few, but I want to give the members the opportunity first, and then do you have anything that you wanted to address that relates to the ICMS system?
I think I do have one or two, Chair.
Yes, Honorable Member, let's deal with them.
Yes. It's a follow-up questions to Ms. Manyasha and Mr. Mkabele. I find it disheartening that you both said that new structure, which involved the 189 section decisions were made separately from the ICMS system. Does REF have a chief strategy officer? What is their role? Or were they sleeping on the job, since their sole responsibility is to ensure that there is strategic alignment in that all strategic decisions made in the organization to ensure that you achieve the mandate? This is really shocking that decisions were made in compartments. Can I get clarity on how these things were done separately? Thank you.
If I may, Chair. Honorable Bila, what I was trying to say was that as part of the strategy that we had since 2020, 2025, we were deliberate in terms of what kind of programs we wanted to initiate and run to turn around the fund. So we had clearly defined initiatives. As I've indicated, we had the organizational structure review, which looked at the structure, but we also had 6 others which were focused on other different parts of the organization. All of those were run independently in the sense that there is just no way we could have linked the 189, for instance, with the ICMS implementation. Those are completely separate. That's what I was trying to say. If I may move to the next question. You asking to have a strategy office? Yes, we do. It's a role that I'm acting in since August this year. But what we're talking about here is something of the past, but it doesn't take away the fact that this portfolio has a key role to play in delivering these many programs across the RAF. Through you, Chair, I hope I have responded to Honourable Blair's questions.
No, Honourable Member, still up to you.
Okay. Hey, Ms. Manyash, I also gather that the ICMS system has the CRM capability, which is the customer engaged, right?
Not at the moment. There are 2 separate systems.
Okay, so that being said, why did you outsource the call center and spend 500 million from the initial value contract, which was 200 million? This sounds like a huge wasteful expenditure. Can that decision be justified, please?
Through you, Chair. Once again, as part of that strategy that I'm referring to, we did an analysis of what's working and what was not working. We had some kind of a makeshift call center which has been in operation for many years in RAF, manned by a total of about 34 employees. Now, if you look at our database of claimants vis-a-vis the number that we had, 34 colleagues who were using an outdated system, a system in which we could not tell that we had repeat calls. That's how archaic the system was. So the decision was looked at holistically to say what kind of a system do we need that will enable the fund to be data-led to support the decisions as we needed. Now, we participated in the contact center contract with our sister entity being the Department of Labor. I can tell you now that we're sitting with data that is so insightful, data that we're able to apply across the RAF. If you look at where we were, really, it was just not working. It was not working. We could not respond in time. When we did respond, it will be perhaps after months, and all of that. So all I'm saying is that yes, we still have those challenges. We cannot shy away from them. But where we are today, I think we are best placed to see how we can take the customer experience journey going forward. But of course, we do need the ICMS system to be fully implemented, because both these systems will be complementary. One is, well, claimant facing. The one will be the backbone in terms of how we run our claims processes. Those combined will definitely assist the fund to move forward. Thank you, Chair.
Last one, Chair. The chairperson spoke about the record keeping of the rejected claims, if I'm not mistaken. One can assume that RAF only registered claim when the summons are served using the documents that are attached on the summons. If you do not have or you do not serve the summons, your claim can be put in the dustbin. Let me say it like that. Are you keeping records of the rejected claims, or you are just registering only those who are attached with the summons from there? Thank you.
If I may, Chair. Honorable Pila, yes, as I previously said earlier on, we are keeping track of the rejected claims.
If that is the case, let us have the number of the rejected case that are not yet paid. And then we check what is it that is missing on those claims, so that our claimants can be assisted to submit all the necessary documents that are needed. Thank you.
All right, thank you very much. So, colleagues, I'm just going to, before we leave this topic, I'm just going to ask some questions of understanding, and I'll try and segment my questions so that I understand what the system is able to do and what it's not able to do. And that is, I just want for my reminder that it's built specifically for the new RAF1 form process. Is that correct? So the old claims that were in terms of the initial for the previous RAF1 form are not to be found here. There's a separate process for that. I just want to be clear.
Thanks, Chair. So we have we have a subset of old claims. If you remember, we spoke of migration that we did as part of the project. So that data migration process took a subset of the open claims that qualified via our, data. So when we did that migration, we looked at the validity and the quality of the claims that we could then migrate into the new solution, so that we don't take non-migratable claims across.
Yeah, thank you for putting it that way, because I need to understand what non-migratable is. So in terms of the old RAF 1 form, you had a set of criteria, that you had to meet.
Yes, Chair.
So that it can then progress through the system, right, as it's expected. That's in terms of the current process. In terms of the old one, you won't, for instance, necessarily have the same list of documents and information that you now need. You understand? So remember, and I worry that I may misstate the issue. So the RAF 1 form, as we have it now, requires additional information that was not required initially at the gate, right? Yes, you get that. That means when you migrate the old information onto the new system, it's almost much of it is automatically non-compliant, because it's missing certain documentation, which previously would have been obtained over time. You remember that? Now, I need therefore to understand what is the process of pushing the old claims to completion versus the new process. And here's why they've got to be separate. Rules and laws cannot be retrospectively applied. You adjudicate me on the same set of rules that were applicable when I began the process. You understand? That's what I'm trying to get to here. I'm simply asking for an assurance that you are not having claims that were lodged under the old rules being delayed on account of being non-compliant with the new rules. You understand that? And the basis for my question is the number of unresolved claims, which is stubbornly over 430,000. So that's why I'm asking. I need to understand how then they all travel through the system on separate channels. If they're separate, if they're not, then we might have a legal problem.
Yeah, if I can respond to that one, Chair. So you are correct, Jay. Those claims are traveling on separate systems. So the different dispensations that would exist in terms of the mandates attached to the claims as they progress through the life cycle, through the value chain. We are following that. Hence, the challenge that the PwC colleagues were talking about, to say we're running two systems, and because of wanting to close out the number of claims that are captured in the legacy system that relate to the old RAF form, we need to make sure that we get to a sunset place for that system. Whereas we progress the new ones, in the new system.
Okay, so that's fine. And then what we've discussed about the claims that are sitting outside, and when you guys are done, we will discuss with the finance colleagues the accounting treatment that should be applied to to those that are sitting outside, whether they're ready then to revise their quantification of liabilities accordingly. Because they're sitting outside as unknowns at the moment or as rejected. So what I also would like to understand is what the throughput rate is relative to total claims. The throughput rate is of under ICMS, right? Or the throughput rate, so from beginning to end, I want to know length of time, if you've got that, length of time, as well as a ratio of total claims. Is it, so I've seen the numbers that you've put in the presentation, but it could be 700 out of 15,000, in which case then it gives us a number that, yeah, that's too low. Do any of you know that?
No, not offhand, Chair. I mean, that's an exercise that we'll probably have to undertake just to be able to give you that. We probably can put a calculation around it just to provide.
Okay, so you do understand. I mean, I don't expect all of you to have this to hand, but you do understand that this actually should be regular management information, management reporting information, because what you want to see over time is that the throughput rate as a percentage of total claims that you're processing keeps climbing, not just as a volume on its own, right? Because if you express it as a volume on its own, it might look damn impressive. But when you show how big the container is, it's a drop in the ocean, right? Yes, and I think after R500 million, we're chasing 600 million now, right, in terms of the October presentation. You should be able to produce that, I think.
We can, Chair.
No, I know.
Yes.
I'm just saying. I mean, I'm looking at senior EU not one, but Mr. Mkabela here, Ms. Potgieter, Ms. Manyasha, and so on are senior executives in the company. This is the kind of thing that should serve before Exco. I mean, that's what I've seen before. Okay, so that information should be available. I also want to ask about, there was this thing that is meant to prevent collusion between staff about the allocation of cases. When did it start working effectively, if I may ask? No, you don't need to monopolize. I mean, you guys are all here, so please don't feel pressured. If you feel the colleagues from PwC can help us, please, you can say that.
Chair, that is built into the new system. So as the first rollout, that was how claims get allocated, or the process of claims get allocated as when the new system went live.
Okay, so, but I just need, there's a reason why I want to know the when. I don't know it offhand. There's a reason why I want to know the when. Was it available from inception or not?
Yes, on September 24.
Okay, so we had the colleagues from the Auditor General here at the beginning in October, and they shared with us that they actually tried to, and I'm going to consult my notes here just to be certain, and I'll give you an opportunity to respond to it. So I just need to go to my notes. Okay, so as I understand, the user is not supposed to have the ability to reroute the claim. So in other words, I don't know if the claims handler or claims administrator, that person is not supposed to have the ability to reroute the claim. Is that so? That's the whole point, that if it gets allocated to me by the system, I don't have the authority to send it to my colleague here, myself.
It can be rerouted by the team leader, Chair. So the user won't be able to do it, but the team leader will be able to reallocate.
Okay, so what we were informed by the Auditor General is that I might not be able to do it myself. Let us, for the purposes of this conversation, say Honorable, my colleague here, Sis Ndombi, is the team lead. Honorable Maduna over there is my peer. Honorable Maduna can reroute me. Okay, so... Okay, so that was not accurate.
That should not be the case, Chair. The only time that would happen is if somebody is defined as a team leader. But no, in other circumstances, they wouldn't be able to do that.
Okay, let me just get this clearly. And there might be an issue of also the job grading system. Okay, so is there somebody who's called, I'm asking the colleagues from the RAF, is there somebody who's called a team? Is there a level, a grade, job grading associated with team lead? So you can't be team lead if you are below.
Chair, unless you are delegated. So if you are below and you have been delegated to be a team lead, but then that role will be assigned to you. But no, you won't be able to be a team lead if you're not either appointed as a team lead or delegated to be a team lead.
Okay, I just need to understand the delegation. I'm also trying to solve the same problem, by the way, so I'm not trying to catch anybody out. I'm trying to solve the same problem. So what I'm trying to say is, so what the AG says to us, and it might be in the delegation, because I suppose what you're trying to prevent, and we'd had a conversation, if you recall, you are not here, it was a chief governance officer, about whether people with delegated powers can then on-delegate to others, right? Because a potential weakness in the system is if I know that Honorable Maduna there has been delegated as a team lead and therefore can do this for me, if we know each other, we can then do the reassignment. You get me? You do understand, right? Because if you've got people at a particular level, so my understanding is that you're trying to prevent people at the level where the collusion happens. And if some of that population has got on the system the designation above them, we might be sitting next to each other and we reassign a claim because we know each other. And I know that the person next to me has been delegated as a team lead, even though they're below that level. Right? Can I, yeah, please help.
So Chair, even if I do reassign the claim, the system chooses who it goes to on a national basis. So I can say that I'm reassigning the claim, but the system will choose where it goes. You have no control over where it goes.
Over where it goes?
Yeah.
Okay. Okay. I will consult the transcript from that day because I just have the notes here. I will consult the transcript from that day just to be certain. But anyway, it's not to say the system doesn't work. It's just to say there are sometimes unforeseen anomalies in the normal course of doing business where loopholes then appear, right? You wanted to say something, Mr. Gubek?
Yes, I do want to say something, Chair. So you get two scenarios where you can reassign to a group or to a user. Because remember, this reassignment also we use to actually manage the workload where there is issues. For instance, Gcina is on leave today, and Gcina is sitting with so many claims under his profile. So those claims, for them not to be able to sit with Gcina, who is on leave for 3 or 4 weeks, can be reassigned to a group or to another person to work on them. All of this is managed via, obviously, audit trails and associated securities that go with it.
All right, thank you very much. So, I've asked my colleagues if they've got any further questions on this. I'll close in this way on this, and that organizations are supposed to work in a wholesome, integrated way because they're supposed to have a character. That's what creates a brand. And the reason I was asking the question about values, particularly for a state entity, is that the values flow from our constitution onto legislation, onto entities, onto how we build systems, how we apply systems, and so on. And I know this is parliament and there's politicking, right? But we always have to balance several imperatives in conducting our work, especially in the public sector. But I think I've worked for private companies all my life, except now. But you always have to create a balance between the values of the organization, in this case the country, in this case it's the constitution, it's the RAF, it's the same with PwC, and so on. And that in order for there to be a good working relationship, you need to have a general alignment of values. All of us here in the committee, all of these hearings, the one thing that the committee members get really excited about is this system. They really do. I was battling to contain them that day. They were imagining all sorts of things with smartphones, and your colleagues were here. So we're all excited about it. And all of these questions that we're asking are not because we want the system to fail. But there is a system anyway where there needs to be an alignment of values and so on. And as Parliament, which has got a responsibility to enhance what is in the Constitution, it is no joke to speak about access. It really is no joke. And what we were saying earlier about building a system that is premised on rules that are exclusionary in their nature, and we traversed that here, is a problem. It is also problematic to do that with a significant risk of reversal through litigation. Right? Because you then have other problems. For instance, Mr. Mkabela here might have to then hire an additional 100 people in the call center to go and look for people who were told that you don't qualify. It's a number that we've asked for, right? We don't know what that number is. It's got implications for finance in terms of the requantification of the liability and what the financials look like and that kind of thing. And I know that for people that come here, it might feel like this is a circus. But at the end of the day, all of us have to write a report that when citizens look at it, it does look at a variety of things that really, at the end of the day, give meaning to being represented by people that sit on this side of the room. I would appreciate that all of us have an appreciation of the importance of that balance. And that the language that says we want to know which product you are claiming for, I totally get it. I get it. I get it. I used to work for a bank. Fraud is a massive thing in the banks. So I get it. But we always must try and do these things in a way that does not catch people who are deserving in the wrong net. And when a system swings innocent people onto the gallery of rogues, then the system does not accord with the values expected of organizations and all of us. And I know that I'm making a values-based statement, but I do want all of us here to reflect on that. Because I know coming here can be scary, members can shout at people and so on. There is a reason why the passions get inflamed to that level. So that's the only thing I would like to ask. We want the system to work. I think when you were here, Mr. Gupega, if we could have given you bags of money to walk out of here with, we would have given them to you. You know that. So none of us here want you to fail. I don't know a single member. People are imagining people sitting at home and doing everything on the phone. Like literally, those are the pictures that people have. But I would like to ask those who still have an influence over this process to go and reflect on what I'm saying. Because I think it then reflects the type of country we say we want to be. And the final thing I will say to the PwC colleagues, so I had a difficult job in all my previous jobs, which was sometimes to advise the organization on whether we should do business with certain people or not, or on certain projects or not. I was responsible for reputation in the organization. There were many instances when we forgo a commercial opportunity for that reason. I'm not saying that do the same here, because we want this. I don't want the interruption. Okay, so I'm not saying walk away from this, but mature commercial relationships enable this kind of conversation to take place so that everybody may do the right thing. And then when you guys come here, you don't need the colleagues from Weber Wenzel to come with you. You understand? We all here, we have a conversation, we give you ideas, those little ideas that we have, and you walk away and we end up with an improved system. And similarly, the conversation with the auditors is not a testy conversation. It's a conversation that's trying to solve the same problem. So I'll end it there with the speech. And thank at least a bit. I know we're supposed to do a demonstration, but I'm mindful of you desperately want to do it. You can do it, by the way. Our friend is disappointed, and sorry, would like to say, cool. Can we give you 10 minutes? Please give him a.
Jay, he can stay with you. The two of you can stay.
So anyway, please. In fact, the members want to say. Honorable Maduna wants to see it. So please. This is fine. We can do it because ultimately...
No, Chair, I think the rest of my other colleagues will kill me, Chair. From a time perspective, I don't want to keep people here. We can forgo the demo, Chair.
Okay, Honorable Maduna, do you insist? Okay, no. I think I forget. By the one of the reasons the members had wanted to see, some of them have logged in virtually. So if it's possible to do a quick demonstration, I think that may be able. The members really are excited about this. Those colleagues who were here will know. That's why we were laughing when he came in, because they would see him even on the street. So can we do that quickly, and then we can release and then be left to discuss the money matters. Yeah, you can only do it here. Yeah.
So while you're getting plugged in, on a lighter note, Mr. Mkabela, let me put you on the spot here. Some people might want to close their ears. So you said you're engaging like tracking. Cause somebody asked you about tracking companies. I think it was Honorable Madlala. He said, you're thinking of engaging tracking companies to find some of these claimants who are hard to find because they've changed their numbers and the lawyer doesn't want them anymore, etc.
Okay. Okay. Tracing companies. Of course, we want to know if this claimant exists.
No, it's not a serious question.
Yes, I know. I just want to provide clarity there.
Yeah.
To say, in our attempt to make sure that we clear all the claims on our books, we want to know where you are. We also want to know if you're still alive, but also if you're still active. If you are getting grant from SASSA, we need to know, because we want to make sure that we want to get through to you to assist you. So I think that is the intention, because you don't want to be sitting with claimants on the system who have
since passed on.
Yes, it's a combination of factors, but I think the purpose is just to make sure that we close that backlog, because it's been spoken about so many times. So that's the intention, Chair.
No, and I know in the spirit of Project Bukamo, so you also are customizing, picking some things from the insurance industry, from compensation fund and so on. Do you think that that company may assist the committee to trace some witnesses that we are looking for? May we talk to you, Mr. Mkabela, about maybe you should talk it offline.
I'm not even sure about that, Chair.
Offline, Mr. Mkabela. So you can send the answer in writing to the committee.
Okay. Chair, if I may, once the colleagues are setting up here, I think it's important to understand the entity we're dealing with, the RAF. Since 1946, we do know that RAF has been a troubled entity. But also know that RAF has gone through 6 commissions, out of which recommendations were made, but were never implemented. So what our colleagues will be presenting here, it's an attempt to say, how do we make sure that for an entity which for almost 20 years there was never any investment in technology, how do we fix that? Mindful of the fact that we have a restrictive, law that is not assisting us, because you can only claim in 2 ways, as you know, walk in and through. So this system, in my view, Chair, it's ahead of time. If you look at the RAF, we've been a manual-based system from the onset. What we have here, it's a system that is so far ahead to the extent that we have to play catch-up. I think that's how powerful it is. I'm not trying to market it. Hence the issue.
Your colleague did that enough last time.
Chair, I think we have a system that we believe will assist us going forward.
No, thank you. Okay. I see Mr. Jeremiah Jacobs exists or may not, is up on the screen, so please take us through.
Thanks, Chair. I think maybe just quick by way of introduction. I'm going to let my 2 colleagues here, Teresa Masters and Adela, to actually take us through the solution. I would love to actually do a voiceover, but I think we will stay here for a long time. So
we know you.
So I'm going to let them just run it through quickly, so at least we get to see the features and what this thing can do.
Please go ahead.
Thanks, Chair.
Honorable Matuna, put your phone down. This is your show.
I hope I'm audible. All right, thank you, Chair. So the first stage, as described by Haneli earlier today, is with regards to the pre-assessment of the claim. So this is where someone, if I paint the picture, they walk into the walk-in centre. So they bring in their claim form with their supporting documents, and the pre-assessment consultant is going to start capturing the minimum amount of information onto the system so that they don't keep the claimant in front of them forever. They've obviously got a long queue of people in front of them, so they're capturing this minimum information that I'm showing. Used a real person, so I couldn't use an ID number here, so I've used a passport number, which is a fake passport number, of course, and all their information has been captured into the system. So you can see their full contact details as well as their next of kin details are captured into the system so that we can contact them should we need to. The basic information with regards to the actual claim itself, so what they're claiming for. In this circumstance, we're going to be claiming for general damages on an injury claim. We also have a represented situation because I want to show you how that looks in the system itself. So the attorney's details have also been captured. And in this circumstance, Jeremiah Jacobs is claiming in his own capacity as self. And the system has then indicated his details in there that the type of injured we've captured as being a pedestrian in this scenario. Just based on this information, we can start identifying, and I've already clicked on the search claim information. We've already identified this person doesn't exist in the system on any other claim. So we already know that this is not a duplicate. It's starting to identify that for us. It's also starting to identify if this particular person has been involved in any other claims on the system so that we can start generating more insights because they may have pre-existing conditions. So this information is all now becoming a picture that the RAF can use for determining how they settled this claim. I'm going to move on to the next step, and yes, I know that this is the area that causes the most concern. Which
we'll
is
pretend it doesn't for the purposes of this exercise. That's all forgotten.
All right. So this is the required documents for a general damages claim, but in the system, this is actually driven through a setting table. The system is able to adapt these forms as it adapts with the legislation. So this is why the RAF 1 contentious issue of it needing to be then adjusted based on outcomes of court hearings and such. It's very simple for the RAF to make these adjustments. The adjustments that they do need to make is if later on in the process they need to request additional information. That's where the system needs to be changed to allow for them to do that. But at pre-assessment, very simple for them to change it. So I'm going to indicate that these documents have all been received. Sorry, I'm looking from the top. Let's just indicate I've received all of those documents. I'm now moving on to the next screen. So the system in the background has determined this claim has not prescribed. It's done the calculation for the user themselves already. It's also already determined this is not a duplicate. So if it was, it would display on this particular screen. So for now, it is a summary screen. I'm going to move to the next stage. The system's also now determined the outcome of this particular claim. It's not duplicate. The claimant mortality is living because it's been able to go and confirm that with Home Affairs, and the injured being the same person is obviously living as well. So therefore, it is a compliant claim. Because it's a compliant claim, we're now going to scan and upload the required documents. So this is where it digitizes this particular claim so that the next step, it can go anywhere in the country. The record already contains all of the claim forms. Okay, so I'm going to attach that. So I could either drag and drop this or just browse and attach like I'm doing now at the moment. Please bear with me while I just attach these.
So maybe just while she's doing that, Chair, let me just add a little bit. So what we've done here is, obviously, while the pre-assessment consultant is sitting with the person there, we take that set of documents once they've done that initial run through on it, before they capture it into the system. We take it through to the process of it being scanned, so that by the time we get to this point, we are then able to have that digital copy for us to be able to attach.
Right. I'm now going to finish the pre-assessment, and the system is now going to be doing a few things for us. It's generated the link number, as it's known, or as the system refers to it as a claim number. It's also generating in the background a pre-assessment checklist as well as an outcome letter. The outcome letter in this circumstance, because it's a compliant claim, is expected to be an acknowledgement letter. So the person walks away with a letter saying, here's my number, it's been accepted. Right, I'm going to go into the claim. Sorry, I just want to write down the claim number for future because I'm going to need it. All right, so let's go into the claim. Now, the first thing you'll see on this page is a very, very big bar, which is showing that we have 120 days to settle this claim. So this is highlighted to the user every time they enter this claim to see what are the targets. The system is also generating a work plan of activities of what do I need to do in what time so that I can make this target. Right, so if I show you the rest of the screen here, we can see that the general damages product that's being claimed for is currently in capturing. We can see that the registration administrator who is tasked with the capturing has been given 2 activities to perform. We can also see the parties that are involved and any notes that have been added to the system already. So I'm now going to, as it says, I need to capture the full claim form, so let me go through and do that. Right, so we're capturing the time of the accident. Right, and we're going to populate where the accident occurred. Capturing the police report, which is attached on the claim. Okay, the system already contains all of the SAPS offices and branches in the country, so that's all available immediately for them. So we're just putting in a, sorry, why am I putting in a number? Okay, and an accident report number. Right, the system's also asking, was blood alcohol tested? So I'm just going to say in this circumstance, no, it was not. And then I'm going to add in an accident scenario, which will later become apparent. So crossing the road at a robot-controlled intersection. The vehicles involved, because that part was captured earlier, we can already see that that's now been indicated that there was another party involved, there was another vehicle in this accident, and that it was a pedestrian that is now claiming for this. So I'm going to update that. And because I've now completed the work that I need to do, I can then indicate that my activities are complete. Sorry, I'm not logged in as the right person. That's why it's not allowing me to do anything. Apologies. I was meant to log in as the registration consultant there. Right. Okay, so as I said, we're logged in as the registration consultant, 1, and now I can go and complete my activities. All right, now it's allowing me to do it. Right, and because I've now completed the registration, I can then go and update this, that I've completed the registration and it can move on to the next processing stage. So I'm updating that. Right, if we have a look here, we can see that it's now been assigned to the V&V consultant. Let me log in as the V&V consultant so I can show you the work that they do. Apologies. Bear with me while we log in and log out, but obviously this process is done by a number of different people, and I'm changing my hats as I go along. Right. Right, so the registration consultant, the V&V consultant, their job is to verify and validate this claim. So they will look at the documents that are attached onto the claim. They're going to ensure that the events of what's been happening on this particular claim, what they described in the accident, is actually the information that's captured into the system. They're also going to perform a level of investigation into this to ensure that the documentation that's been provided is in fact the documentation that belongs to this claimant. Further to that, they're going to make sure that everything is captured correctly, that they didn't make any mistakes, like, for example, with the accident dates, because that can make a difference to something like prescription. So once they've confirmed and satisfied that this claim has been captured correctly, all the documents belong to this particular claimant, they're then going to complete their work plan, which is the activities they were asked to do. They're going to complete that, and they're then going to choose that they accept for this claim to continue in the process. Right. The claim is now moved to the determining merits stage. This is a fully integrated system, so this is where it hands over all the information that's been captured and it hands it over to Updraft. Now, Updraft is then going to take that information and the consultant will be able to walk through the process further. So this is where I hand over to Ardula, so it's Merits Consultant 1.
Thank you, Teresa, and good afternoon, Chair and members. I just need to steal the screen from you, Teresa.
Apologies.
Thanks for that, Teresa. So I will be demonstrating the Updraft system. And as Teresa mentioned, both her and I are putting on various different hats throughout this process. The RAF users who would be users of the Updraft system are the merits team as well as the offer team, which come in a little bit later. And as a merits consultant, so I'm wearing my merits consultant hat right now, I would have full access to Claim Center. So all of the work that has been done by my colleagues in onboarding or V&V, to see all the claim documentation and the full claim history. From within that system, I would be able to click on a button that will open up the Updraft system in order to give the merits consultant the specialized functionality that exists in Updraft, which was touched on earlier regarding the case law and the matching of collision scenarios. So at the top of the screen, you can see there is a claim that has come through, and it is the claim of Jeremiah Jacobs, which Teresa has just captured on Claim Center, which is passed into Updraft through those integrations. And if I were to click, for example, on this claim details item and open up the log, I would be able to see that all of that data, which Teresa just captured, all of the claim details appear here on Updraft, as well as that link number, which is quite important. It is consistent across both the systems. Okay. The core functionality of Updraft is the ability to match collision scenarios to directly on-point case law. There are a few checks and balances and procedural steps I'll go through before I can get to that, so if you'll just bear with me. But in my task to do, you can see that the first task for the merits consultant to do is to upload their merit summary. And this was a check and balance that was requested by the RAF to ensure that the merits consultants actually apply their mind to the evidence, the accident report, the witness statements, etc. So this is a step where the merits consultant will go through all of the available evidence regarding the collision, and they will draft sort of a summary of what they think the most plausible task. Okay, and once I've done that, the system has then prompted me for my next task, which is what we call the statutory repudiation assessment. So as we all know, there are various grounds under the Road Accident Fund Act that would allow the Road Accident Fund to repudiate or reject a claim. The updraft system doesn't deal with all of them. It deals with those that are closely related to merits, or the ones that are most important at the merit stage. There are, of course, other repudiation grounds that are checked throughout the process, including, for example, prescription, which Teresa showed us is checked on the Guidewire system. The repudiation grounds we check for here are whether it was a motor vehicle as defined under the Act. I'm going to go ahead and show us that it wasn't, I'm going to go ahead and show a happy path where it was an ordinary motor vehicle. But if, for example, it was a forklift, a tractor, something that isn't considered for propulsion or haulage on a road, there might be different case law that applies to it, or the RAF might be able to repudiate on the grounds that it's not a motor vehicle under the Act. However, I'm going to go ahead and say it was an ordinary motor car, truck, or motorcycle. Okay. The next question is trying to determine whether this claim should actually be fall within the remit of the Compensation Commission. So if all of these factors apply, the Road Accident Fund would be able to refer the claim to COIDA. I'm going to go ahead and say no, doesn't apply in this case. And at the end of that process, the system, by way of all the audit trails, will draft a report. So if there were any repudiation grounds, it would be documented within this report, which the claims handler would have for their information and for the Road Accident Fund's record. And in addition, a repudiation letter would have been drafted to the claimant or the attorney to explain what grounds their claim was rejected on. But as mentioned, I've gone with the happy path, so I will be able to show you the next step. Okay, and the next step is the core offering of the updraft system. So this is the merit assessment for pedestrian. There are different categories of merit assessment. So there's a different case law that applies for passengers or drivers or motorcyclists or cyclists. And in this case, the system has determined that this is a pedestrian case. So it's popped up the specific decision tree that will pertain to pedestrians. Okay, you'll see the first question we're asking is whether the pedestrian was a minor or an adult. Minors are dealt with very specially in terms of the law, so there's different case law that applies there, and it's a bit more lenient. I'm going to go ahead and say it was an adult in this case, so I can show you the full suite of options. Because we tend to see in the case law and that repository of case law that the courts do deal with hit and run collisions quite differently than identified driver collisions. I'm going to go ahead and say no, this was not a hit and run scenario. I'm then presented with the first list of sort of high level descriptions of possible collisions that could involve a pedestrian. For example, were they standing, walking or running next to the road, crossing the road, running in the road, were they in a parking lot, etc. I'm going to go ahead and say crossing the road, which aligns with the scenario Teresa captured earlier. Was a pedestrian hit by a vehicle while crossing? I'm going to say they were crossing at a pedestrian crossing. And I will say they crossed at a robot-controlled intersection against a red pedestrian light. So there's potential fault on the part of the pedestrian as well. Also an important question, was the insured driver driving under the influence of alcohol? Because that tends to inflate the insured driver's negligence or fault if they were driving under the influence of alcohol. I'm going to say no. Okay, and the end of this process is a summary page. Just allows the user to check their answers and amend their answers if they needed to. But I'll go ahead and hit save. Okay, this event that has popped up on screen is just an indicator when the system's going to send out an alert to someone. So the system sends out emails or alert reminders for different events. Okay, and you'll see at the top of my screen, the system has already populated a percentage. It says RAF partially liable 40%. And if I open up this PDF document that is generated, this is what we call a negligence summary, and it's akin to a merit summary or advice that one would get from an attorney or an advocate drafting a summary on the fault determination in this scenario. All of the claim details are pulled in at the top, and you'll see the heading is specific to that scenario that I as the user selected. This is a negligence summary for a pedestrian who was crossing at a pedestrian crossing at a robot-controlled intersection against a red light. The system has then pulled in a lot of case law, as we can see, and I'll spend a little bit of time going through it because I think it's important. But the system has first set out the general principles for fault determination when a pedestrian is crossing the road. And we can see the general rule is that usually a driver is 100% negligent if they hit a pedestrian. However, there are exceptions, and these general principles are not applied without qualification. A degree of negligence can be apportioned to a pedestrian when he or she crosses against a red light. And the system has then drawn various cases that are showing our merits handler that they can actually apportion up to 50, in some cases up to 100%, but on aggregate between 50 and 60% fault can be apportioned to the pedestrian, meaning that the Road Accident Fund can reduce its liability by 60%. And this is quite important because these merits apportionments and fault determinations, and we've seen this because we've got thousands of cases in the system, this is what the attorneys usually go to court about, in addition to quantum. So yeah, the hope is that in time this will reduce the disputes with the attorneys and reduce litigation costs and ensure that merits are backed up by directly on point case law, so that the RAF is protected in that regard. Okay. Okay, the next step would be a team lead approval. So once the system has determined an apportionment, it still needs to go to team lead approval for QA and to make sure there's quality assurance. You'll see that I'm not able to do this because I'm not a team lead. So that question came up earlier about the roles in the system. So I'm going to sign out quickly and then put on my team lead hat and sign back in. Okay, and now that I am logged in as a team lead, I have the correct rights and the correct profile on the system. I will be able to launch this. You'll see here at the bottom there's a little title that says Merits Team Lead. This would be the name of the team lead, so if it would be my name, if I was a team lead, it would say it's allocated to Adila Sheikh. And this allocation of approval happens on a round-robin basis across the country, across all of the team leads, and only a merits manager can reallocate this, but they can't pick a specific person. They can choose to reallocate, and the system will then allocate it to another team lead. Okay, I'm going to launch that. As a team lead, I can then see what scenario was selected by my merits consultant, what apportionments the system generated. There are some scenarios where there are joint wrongdoers. There isn't one in this case. And I'm then able to either approve or reject. I'll just give you a peek of the rejection path. If I were to reject as a team lead, I would need to give reasons for why I'm rejecting the system apportionments, which are backed by case law. If I reject it, the claim would be routed back to my merits consultant to run through the merits again with the feedback I've given them. I'm going to go ahead and approve it. And then again, there's just the audit trails. There's always a report or document that is drafted. So this is the approval report. It's more so important when it is a rejection report because the rejection reasons would also be documented here. Okay, and then you will see that a next step has populated. This is a step for my merits consultant or the merits consultant to communicate the merits outcome to the attorney if they so wish to do so. In some cases, it's only communicated once the quantum is available. But on that note, at the moment that I as a team lead hit that accept outcome, that outcome was passed back to Claim Centre so that those apportionments, the 40-60 apportionment, can be applied going forward to the exposures and the RAF's liability for quantum determination. And on that note, I'll hand back to Teresa.
Thank you, Chair. So, as Ardula said, this information has now been handed back to Claims Centre. So a few things have happened. We can see that the claim has moved on to a processing stage of medical review, and it's been assigned to the medical management consultant. Other than that, it is also created under the plan of action an actual evaluation of this particular claim. So we're starting to build the picture of what it is we're going to settle on this claim. So the apportionment of the 40/60 has been handed over. That was created systematically in the system. And then, of course, the next step, just to show you that the system actually chose the outcome, which was documented here as partially liable. Right. So I'm going to log in now as the medical management consultant so that I can then perform my injury assessment. Apologies, right. Just going back into the claim here. So as a medical management consultant, we did describe the fact that their injury assessment will contain a bit of the clinical protocols to understand the seriousness of the particular injury and the treatment that should be applied. So this is done outside of the system, and once that is done, a report is uploaded into the system. That's attached under the documents section. Just for the purpose of this demonstration and speed, I'm going to skip over that part. And I'm going to then confirm that I have completed my medical assessment. Apologies, I think my signal is slowed down. Right. At this stage, the claim is again reassigned. So as you can see, there's a lot of hands that are on this particular claim as it goes through to through the process. It is now going to be assigned to an adjudication consultant, and in this instance, it's a general damages adjudication consultant 2. So as you can see, adjudication is done by a consultant who specializes in the product itself, and again, assigned in a way that cannot be predicted. Right, so I need to log in as the General Damages Consultant 2.
So, Chair, you will see she keeps flipping through the different roles that, exist in the system. So you can imagine that in real life, this now is all the different areas within, different people within the processing stages of how the claim would traverse within the value chain.
Again, I know that it looks rather simple, but the system is creating certain activities automatically so that it can drive the work that's been done. So you can see here, like, for example, step 1 is to perform checks. So there's basic checks that they need to perform. This is, first of all, a mortality check to ensure that the person is still living to receive this payment. They need to check that the claim is still compliant, that there hasn't been a question raised of fraud, etc. So they'd need to perform those checks as they go through the process. I'm going to complete that activity. Then step 2 is to review the medical recommendation, which was attached. So we're going to say we've completed that. Step 3, that they need to determine the general damages amount. So as Mr. Kubeko indicated earlier, they'll use the Book of Quantum then to see what is the amount they actually are then going to pay for this particular general damages incident. And I'm going to populate that onto the evaluation. Now, the reason I do that is because now the system can calculate, based on the value that's been entered and the apportionment that was determined earlier by updraft, what the RAF liability amount is. So in this circumstance, the RAF liability amount is 28,000 rand. Right. I'm going to update that. And now the most important part of this claim system starts opening up to us. It's the financial part of it where we start creating provisions for what this claim needs to be paid for. So I'm going to then be creating an estimate, which is a provision, basically. Sorry, let me just make sure I'm on the right screen. There we go. Right, so for general damages, there's only one cost type and cost category, which is personal injury. For the other products, there are more cost types and cost categories. And I'm going to now populate the 28,000 Rand that was determined on the earlier calculation. You'll see as soon as I create this transaction, immediately it goes to pending approval. Because of the value of this particular amount, it's been assigned to another general damages consultant to do the first approval with regards to the estimate itself. So I'm going to again be logging out and logging in as the general damages consultant too.
So these approvals are also driven by the delegation of authority levels. So we have different levels attached to who can approve what.
Sorry, Honorable Isaac, you wouldn't be able to approve anything here. This is for high-level people, this Honorable Isaac. You accept it? Okay.
Right. So the estimate will detail out what the amount is that's being provisioned, and if I'm satisfied with that, sorry, I should have logged in as the consultant too. Apologies. That's why it's not giving me a approval button. But I think, if anything, it shows the delegation of authority is working very well. Right, so if I'm satisfied, once I've reviewed all the evidence on the claim itself, I'm then going to click on approve. Right, and then the rest of the activities can be completed by the general damages consultant, which I'll do in the background here. So what we can see is we now just need to select our outcome, which is here under the exposures, that I am now accepting that adjudication has been completed. And we can then move on to the offer stage. Right, at this stage, the quantum amount as well as the RAF liability has been handed over to Updraft to then perform the next steps in the process.
We're close to the end, right? I'm not asking in a bad way.
We are close to the end.
Okay.
Offer consultant 2. Offer consultant 2.
Offer consultant 2.
Okay, I promise I'll be quick. But I am now wearing my offer consultant hat, so I'm no longer in the merits team, and you'll see that I've logged in as offer consultant 2 because this claim was, the offer was allocated to offer consultant 2 by the claim center system. And if I open up my claim, I can see there's a new item that says receive quantum general damages, which means that the quantum that Teresa just showed us on Claim Center has passed into the Updraft system. And if I open up the log, I can see those amounts. So the total quantum and the apportioned quantum, which Teresa showed us as well, have now been pulled into Updraft. And you'll see there's a new task here for the offer consultant to draft a combined offer for general damages. Okay, and I'll just click proceed. There's not much work they have to do to draft the letter. The system will automatically pull in all the information. And all the offer letters have been configured in PDF only because it was requested by the Road Accident Fund that people don't have access to the Word version, so they can't go in and amend amounts, etc. So there are very strict controls around being able to amend apportionments or amend quantum amounts, and that can't just be done unilaterally. So you'll see the system has drafted a letter, and this is a letter that could go out either to a law firm or to a claimant if they are a direct claimant. And you'll see that all of the claim details have pulled in automatically. So the law firm's details have pulled into the letter, the link number, the specific benefit or product that is being claimed, those apportionments which the system generated earlier, the quantum amount which Teresa showed us a few minutes ago, and the rest of this is a letter making an offer to the claimant or to their attorney for the general damages benefit. The rest of the content of this letter was created in conjunction with the Road Accident Fund's legal team, and all of the content was vetted by them. And you'll see as well there is an Annexure A that is attached to this letter. And if I scroll down, that is an actual settlement agreement or settlement offer that is capable of signature by the claimant or the attorney, which once signed and accepted will prompt the next steps to the payment request, which I'll show you in a second. In terms of getting this offer actually signed and accepted, we do have digital signature options in Updraft. Okay, so I, in the interest of time, I will show you the manual signature option, but if I were to click on this little button here, I could start a new electronic signing process and send that digitally to the claimant or the attorney to sign, and it works on a cell phone or a laptop. As long as you have internet and a web browser, you'll be able to sign that. But I'm going to go ahead and do the manual version. So if this document was signed physically, then the offer consultant can come and upload a new or signed version. Okay, and on that note, as soon as that signed version was uploaded to the Updraft system, in the background it triggered an acceptance outcome that would automatically pass to Claim Center so that the payment request can proceed. And on that note, I'll hand back to Teresa.
Last handover, Chair. That's it.
Right, so the offer consultant is now capturing again in the claim center system. They've completed their offer process, so now they're going to be loading the payment request itself. So I'm going to go to the financials of the claim, and we can see there's the provision that we made earlier. Just to show you, there are certain documents that enable the ability to pay to ensure that the correct banking details, etc., have been uploaded. I just want to show you what happens when the system checks that these documents are not in place. So it's already going to be telling us it needs a stamped passport with the entry-exit stamps, mortality affidavit, and the mortality check print from Home Affairs. So I'm going to upload those documents quickly so that we can then proceed with the payment itself. Right, so just going to upload that. Mr. Kubeka, feel free to add in any any additionals. Right, so that was the stamp.
Look, I think the only addition I can have here is that in the event that we actually have an ID, this would have gone automatically now into Home Affairs just to check that mortality, so that you don't have to, manually do it like we're doing now in affidavit. And it also would have, later on do the bank verification in terms of the bank account that you will be paying into.
Our mortality affidavit and our mortality print. Sorry. Right, so those have now been uploaded, so I can go back to the financials, and now the system will be happy for me to create the payment. Now, earlier on, I did say that this was a represented claim, so this is why the law firm has automatically been populated here. So I can confirm that we are going to be paying the law firm in this particular circumstance. Had it have been a unrepresented claim, it would be paying directly through to the claimant itself. We then would choose the payment category necessary. I'm just going to choose, any for now, just so that we can get this payment processed. And I'm going to populate my invoice date as being the date of the document that it was signed, the settlement agreement. This is not as a result of a writ or a court order. So I'm going to proceed to the next step, where it's just confirming that I want to pay 28,000 Rand, which is the provision amount. And when we go to the next step, we can again confirm the settlement date. If this had been a past medical expenses claim or something along those lines, we would have used their invoice number here, but because it's a settlement agreement for general damages, we're just going to use the claim number as being our reference number. The settlement date we indicate, and that will then calculate the payment aging. Now you can see in this payment category that I selected, it says the aging is 0. So had it have been anything higher, the payment date would have then been, whatever, let's say, the 7 days or whatever the amount is. But in this circumstance, because the aging is 0, it's going to hand over to SAP immediately. Now, we've done that specifically for this demonstration so that you don't need to wait with that. So I'm going to finish the payment there. Sorry, I forgot to select the cost center. So finish the payment. All right, and we can see it goes into pending approval. Now, there are 3 stages of approval with regards to payments itself. So it will first, in the offer management team, depending on the delegation of authority, it'll then go to the regional finance team, and from there it'll go to Treasury for the actual provision of the payment from the SAP system. All right, so I want to just open up again the work plan so we can see review and approve new payment. Right, and it indicates that it's been assigned. Let me just quickly check to test offer consultant 1. So sorry, I do need to sign out and sign back in again as test offer consultant 1. I do hope that this is an account that's working. Apologies, we just realized there was one account that wasn't working this morning. No, it's not. Sorry, this is where we're going to get a problem then, because that account's not working. Apologies.
Look, I think.
But I think we get how it works. I think it also shows the labor intensive nature of the manual process, which is where I would be interested in knowing what the 120-day window, what the thought was in the 120-day window. I mean, I'm not saying it should be longer, but at the same time, you have to match your time obligations to what is doable. Given the administrative process that has got to happen, but that's Parliament's job in how it rethinks the legislation. My hope is that because the whole conversation has been contaminated by the lawyers thing, and I think there is reason to consider a whole range of things. I mean, there are the obligations to claimants in terms of being able to give access and finality quickly, but at the same time, there is the reality of trying to put everything together and sometimes having to go to court and that kind of thing, that it actually is an arduous administrative process to get to the end of the whole thing. And I think the reason the members are excited about the possibility of a digital solution that works is that it assists with getting to the end for claimants in a way that is fair, and also provides that quick access to claimants. So yeah, no, thank you. I don't know if you members have got questions. Honorable Madun.
I just want to check, Chair, is there an interface between that system and their financial system? Okay.
Yeah, there is.
Yeah. All right. I think for the purposes of what we are doing, thank you very much for that demonstration. Actually, is quite useful. Thank you very much for doing it. I won't extend my closing remarks anymore. I will just say thank you. We're just going to have a short session with the finance colleagues on other matters, and then we will release them as well. So thank you very much to the colleagues from the RAF, those who don't have to be here, and the colleagues from PwC, and their colleagues from also the guys from Updraft. You here, right? Who else is here? Thank you very much, and thanks very much for coming to support this process. Much appreciated.
Thanks, Chair.
Sorry, somebody's saying chair. Oh, you're saying thank you. Oh, okay. Colleagues, the thing is we can walk in and out here, and you guys can't. So if you need a body break, I would suggest that you do, unless you're okay, because I just want us to have one sitting and then be done, and not break and extend things. quickly between ourselves and Ms. Mabusela, because we had a conversation yesterday about the whole grab thing, Honorable Maduna, if you recall, and I did at yesterday's session just ask Ms. Mabusela to just go and read certain things and consult her own experience, etc., and then reflect on our conversation, and then see if we can conclude that conversation in the right way. And she has indicated to me that she has indeed gone and had a look and would like us to conclude that conversation in the right way. And I said I would give her that opportunity to do so. I think at the heart of it, Ms. Mabusela, was just a common understanding of what GRAP means, specifically in the context of the PFMA and the Treasury's responsibilities and so on. I think that is where the divergence began yesterday. So I'll just give you an opportunity to, upon reflection, to speak to what your thoughts are in respect of that. In short.
No, thank you, Chairperson. So just for clarity, Chairperson, I think from where I'm sitting as an expert in the space, in accounting, my understanding is that we've got international accounting standard board, which is the overarching setter of the standards. So with a GRAP, then taps into those standards to obviously then bring them to be utilized locally. So I think I got confused when we were indicating that ASB sets the standards, because I know that there's the International Accounting Standard Board, that sets the standard, IFRS, which then the ASB would then utilize. On most cases, there's very minor adjustments that would then be made by the ASB. So I think that's where the confusion was. But I do understand that for a person who deals with the public sector, the engagement with the standards would then start at ASB. But for someone like myself, who's from the private sector and an expert in the space, if you ask me who sets the standard, I will start with the parent of the standards. Thank you.
No, thank you very much. I think we were not too far apart in the sense that all accounts have to be able to be utilized internationally. For example, credit rating agencies, creditors overseas on a consolidated basis, which is what the Treasury does. But at the same time, and for that reason, the compliance with international standards is important. So you're correct in your thinking that there are international standards. What we do here cannot be completely parallel to international standards, right? I think that is where the confusion came. And so am I correct then to say that we are now at one in fact in that we agree that you've got international standards, and then in South Africa there is a body tasked with standardizing and setting for the public sector, so that entities that formulate accounting policies flow into that system all the way to the international standard. So we are now on the same page. I just want to be sure that we're on the same page with that.
Correct, Chairperson.
Okay.
Thank you.
All right. No, thank you very much. I think we will leave it there then. So members, I really don't want us to, so I'm not going to ask leading questions. I will just ask questions that remain, because the matters that arise from our previous conversations with Mr. Modiba and Ms. Potgieter. Some matters may relate to Ms. Manyasha, but I think she will have less to say in this segment, and where necessary, Ms. Mabusela will be of assistance. And of course, the matters, we kind of cover a range of areas, including other people who've testified about procurement matters, about issues with the financial implications. So I had explained yesterday, I will not make that implication again. So I will just give the members an opportunity to ask further questions. I will then ask the closing questions, and then we will be done. And then we will release everybody. Honorable Bila, I don't know if you want to go first, or you want me to start with Mzala this time. Yeah, because he's gonna say I don't like him if I don't. Honorable Isaac.
Thank you for the opportunity, Chair. I'm covered. Thank you.
Covered. Okay, no, great. Honorable Madlala.
Thank you, Chair. I'm also not going to ask much of the questions, particularly technical and detailed questions. But Ms. Potgieter, because we are probably, unless if a need arises, engaging for the last time, I need to ask you to assist us in this manner. As a CFO, all forms of financial controls, financial mismanagement or irregularities would have happened under your authority. And I said in the last time that I spoke, we are concerned about systems and processes. And I want you to help us and remove yourself from the situation. But from a control environment perspective, a financial control environment perspective, I want you to help this committee draw lessons from the experiences at RAF in terms of what could be done better, to put in place systems that ensures that there's efficiency and there's proper utilization of finances. We've seen many invoices here. We've spoken to issues of cost escalations, where you see golf t-shirts costing exorbitant prices, bottles of waters. I don't want to go into the details of each issue, but I want to say, from your experience, what do you think could be done better to ensure that the financial environment at RAF, which can be generalized across all other state entities, can be better managed to ensure that the end user or the people at the end of the day get the maximized service that they deserve? That is the question to you. Thank you.
Thank you. So, I mean, unfortunately, a lot of these things sits in various business units. Obviously, if the entity at least was smaller, it would have been easier to control costs within the finance department. But you have to, unfortunately, in some instances, have relevant delegations that goes to business units and business unit executives. And there is obviously a certain level of expectation of those individuals to apply their mind to costs associated with the various things that you mentioned earlier. And it is concerning. It's concerning for me as well. I mean, I think Mr. Pulela did sort of clarify the issues of the quantities, and I think I also at that time spoke to the team within finance to say, you know, there must be a certain level of verification, at least of invoices, that it makes sense to you. But I think for me, and to be frank and open with you, the PFMA and the Treasury regulation sometimes doesn't always assist public entities with getting the best product at the best possible price. We do find ourselves, and I can just speak from my recent experience, at least in the procurement space, where we overcomplicate things. We have protracted procurement processes that require various submissions of documents, and it doesn't always necessarily result in the appointment of, firstly, we struggle to get service providers that meet with all the various requirements. Secondly, if we do manage to appoint, it doesn't always necessarily mean that you're appointing the service provider that has the best skills at the best price. And in some instances, I mean, I do know that it was a question that came up at some point about when you see a price and something, it doesn't look right to you, you have no option but to award to that particular service provider. And I think the Chief Procurement Office in their presentation mentioned it as well. So you are left to or being forced to appoint service providers based, once they meet your criteria and they meet the minimum threshold in terms of your evaluation process, you are left to have to go with the best price and obviously preference points. But I mean, sometimes you would rather pay a few rand extra to get to get the best quality price or product at least. So I think it's something that certainly myself and the team within procurement and finance have discussed. We are still struggling to find the balance, but I do get your point, and I do think it's something that is worth considering, at least moving forward, because there is certainly, from a quality perspective, firstly quality and secondly price, we do not always get it right.
Okay, just two issues that for me, I would think that could be within your own control or within your own regulation. For example, you've got contracts, I think it's in Zeng, I don't know which other, the second one. And from what I gathered is that these contracts are open contracts, and departments individually would approach the companies, and it didn't seem like there was a coordinated or a monitored, or it's in the control environment. If you've got a company and HR wants to do a function, or whoever wants to do whatever with this company, someone has to be there to ensure that it is in line with whatever they agreed price list or terms of reference or whatever contractual issues at a central coordinating level, so that you as a CFO, you don't see with an invoice as an aftermath that this is what has been procured by this company or from this company, and this is the price. And these invoices come signed, and there doesn't seem to be clarity. We have to ask, was this one item, or was this, there has to be a standardization. This is an internal control measure, a standardization of what an invoice that is accepted by RAF looks like. And I think there's a template, that's developing one template to say, you need to mention if it's 100 t-shirts at 35 rands or 800 rands. You can't just put 35,000 rand and one in terms of the quantity of t-shirts. And these are the things that we're seeing in the kind of invoices that you guys are approving. I'm just making an example of trying to create a controlled environment where you can then standardize issues. Another issue spoke to the delegations of authority, where it came up that the board does not seem to have sight to get a view of the delegation of authority. When it goes to the third person, the board has no clue who else has been delegated from the delegated authority. And I think that's also a governance issue, maybe that you may want to comment on, and maybe Ms. Manyasha, I see that you want to say something to that. But those are just some of the examples of the things that I'm saying. From as a learning organization, you guys take us through what are your views about some of these issues, and try and remove yourself from the situation. It's not a blame to you. It's we're looking at the systems and controls, and we want your guidance as people who are in the roles. And that is the last part, but you guys can just expand on it and say what do you think are the things that could be done to improve the situation. Thank you. Thank you, Chair.
So I think just to clarify the issue of the delegation, so there's an overarching delegation framework that is approved by the board. Then there are, in that particular framework, there are certain delegations that cannot be sub-delegated. So the board is clear in terms of, for instance, if I can just make an example, the approval of accounting policies cannot be sub-delegated, or whatever the case might be. So there are those delegations that can be sub-delegated by either the CEO or the relevant executive, and then there are those delegations that is fixed to a certain level or a role. So if then obviously the board would not necessarily be able to know that Mpo is on leave and she's delegated her role for 2 weeks to a subordinate or whatever the case might be, but there are at least firm delegations that may not be sub-delegated.
All right, I get that. My specific concern on the issue relates to signing of monies, to be specific. So if you have got an authority to sign up to 300 million, if you are off for 2 weeks and you delegate your subordinate to sign up to that amount, I think there's an issue there. Unless if it's vertical, if there's another person at your level, but I think someone has to be aware of that, because if that other person also falls sick in the next 2 days, ultimately a clerk can sign something for 300 million because this one delegated to that one, and doesn't clear to be a framework, a clear framework of how this sub-delegation happens. I'm not saying that. I'm just saying it's something that may need to be looked into, and something that some recommendations may have to be worked around to ensure that there's control. Otherwise, I can simply take a week leave when I want something done that I don't want to put my signature on, and I can delegate someone to do it, and they can come back and say, I did not know, and it could just create chaos in the environment that no one can be able to account for. I can see other duties, but when it comes to financial issues, because that's the main interest of also the SCOPA, the Standing Committee on Public Accounts, where there's public purse involved, at least there must be a clear framework of accountability, delegations of authority, and so forth. Yeah, thank you.
Chair, I want to comment on this issue and want to thank SCOPA, this committee. For the past few weeks, I think you have highlighted some of the control and governance failures that we may have not seen. And I want to say that when it comes to procurement, definitely I think one of the recommendations should be relooking at the control environment in the space. And maybe we should go back and have engagements and workshops with employees about procurement and financial management, because I feel that sometimes there is neglect of duty at a management level, at a lower management level, because at times, and I must say, Chair, I think in August I wrote a very long email. I'm not a person to write very long emails to the people that were working under me, and I was saying to them, you guys are so careless and you are neglecting a lot of things because you know you will never have to account. And I was telling them the day these things go to SCOPA, I'm going to have to be answering for them. And I'm here today answering for those things. So I think there is neglect of duty, and I think we've let it pass for a while. Maybe we need to go back and emphasize those controls and have those engagements with people, because I just feel that there is sometimes neglect of duty, and because people know Bernice is the CFO, she's ultimately accountable. And I'm not saying that as an executive, I must not exercise care. On my side, I have that duty. I was explaining on Monday the control I brought in the environment of marketing and comms. If there's one area that will give you nightmares, it's marketing and comms, because they've got a lot of things that they do. And if you don't look at, the invoice that we're looking at is a very long invoice. And as an executive, sometimes I can't get involved in every little detail. So that's why I'm saying we need to go back and make sure that we must come here and account, but we must also be able to go back and make people account also, and not be seen as punishing people, because some of the things people make, yes, we are human beings, we are going to make mistakes. There are points where I'm going to make a mistake, miss a certain detail. And I rely on the people that report to me, on my subordinates and my colleagues, to also exercise the same level of care. And I also expect them to make a mistake at points. But I think there are certain things that people are really neglecting, and maybe we have not emphasized enough, we have not engaged enough in terms of finances and other business controls, to make sure that people also know that they have to account, that they're sitting at home now watching us on TV, on YouTube, and they're saying, yeah, but if you look at the quotation, there's a senior manager that looked at that quotation, requested for those line items. They request for those line items. When it comes to me, and I said on Monday, usually they would only give me the invoice. I insisted that give me a quotation that you signed. You see, so I think lesson learned for me is that we need to emphasize on controls, but we need to go back so that everybody knows what their responsibilities are, what they are accountable for. Thank you.
Thank you very much. I'll come to Honorable Maduna. This is very important because I don't want to return substantively to this point, but I'll just give you an example from an employer I used to work for. It's a German company. So what they would do is, if there is a manager who's away from office, everybody's out of office is standard. It says, I am out of office between this date and that date. Honorable Madlala will act on my behalf on all matters relating to whatever, right? However, somebody at a similar level with similar signing powers then becomes responsible for signing on the financial matters. In other words, the levels of delegation in terms of what you sign for remain at the same level. They don't do this, right? It's a systems issue. It's not even about, shouting at people. Just don't give people responsibilities they are not ready for. Because, as Honorable Madlala says, someone is conveniently out of the office on a particular date. And this is what occasions this, because the higher you go, the more relevant it becomes. So I asked the other day about what the chief executive can sign for. I think it's 40 million, right? The contract for Zinge and Media Mix 360, the CEO is delegated to sign, right, on behalf of the board on those specific contracts, because they went to the board. So far, so good. However, the chief executive, for whatever reason, I don't know why, on both occasions is not there. He then takes the board's delegation, which is not his. It remains the board's power, and he hands it over to Ms. Mampe Kumalo to sign. The board, I haven't seen anywhere where the board now has to concur, because I don't know, is Ms. Mampe Kumalo the acting chief executive or is she not? You know what I mean? It's these kind of things which, depending on how well you know the institution, you'll think, and this is the public sector, you think something fishy is going on here, right? That's one possibility. The other possibility is the organization has not thought carefully enough about its governance systems and the use of its delegations of authority and so on. And wrong things happen in that hazy area. You understand? And again, we said we're not targeting people, but our responsibility is to make sure these kind of things don't happen, and we build systems that can last, and make sure that the colleagues from the Auditor General get there and they roll their eyes because they've got nothing to look at here. And they're in and out in no time, right? The audit is completed and we're all happy. And I think if we had seen as an example that there is this system, we probably wouldn't even be talking about these contracts. But what you have, it begins at signature level, And then it goes all the way to who signs for invoices. And the impression is, sure, it's a big mess. There could be money flying in all directions. And if you had to ask the chief executive, actually, do you know about these contracts? He might say, I never saw them. I wasn't there. Right? R1 billion later. So anyway, so I'll leave it there. Honorable Madun.
No, thanks, Chair. No, thanks, Chair. I think, I think the control environment, especially the financial control environment, the draft, is really something to worry about. Because really it might happen, Chair, that some of the payments, he really doesn't know about it. That is why I think, in one of when we were speaking to one of the witnesses, I would have asked them about the payments in terms of how their bank works, who has the codes and so on. And the reason I was asking was to establish who releases the payments and so on and so on. Because I at a very early stage, I realized that there's really a problem around the financial control environment. That is just as a comment. But I think Ms. Mabusela or Ms. Pennis, I'm not sure who will help me, but who at that time was K. Sonsende? What was his position?
He was a chief audit executive.
Okay. According to your knowledge professionally, has it happened before that in the office of the CFO you instruct internal audit to withdraw their report?
Through you, Chairperson. Thanks, Honorable Maduna. Chairperson, I think yesterday I did indicate that this issue of Morar was...
No, Ms. Mabusela. Don't go there. I will go there. Don't. I'm asking you, according to your professional opinion, has it happened before that, or is it allowed, according to the internal audit standards, that a CFO instruct internal audit to withdraw their report? It's a straightforward question. Yes, it's allowed. Okay. No, it's not allowed.
No, it's not allowed, Chairperson.
No, thanks. Don't worry. I will ask you. I will give you the space to give me that explanation.
All right.
So, at that time, how is it that out of your engagement, because I'm establishing now that this was actually an internal audit report. Now I'm establishing that now. Now I'm asking, how is it that you were able to instruct the CAE to withdraw an internal audit report? Because I believe that the real reason why internal audit reports directly to audit committee, and you see, if you see the organizational design, usually there are dots when it goes to internal audit, because internal audit does not report to management, and it's not supposed to report to management. So how is it that it ended up you instructing internal audit to withdraw their report? Because the report did not belong to Mora. The report belonged to internal audit.
Thank you very much, Honorable Maduna. Let me apologize for having forgotten what had transpired. But with the document that I requested, then my memory was reignited. So the internal audit, obviously, the chief audit executive did not have enough staff, so he had to go and get Morar. So to correct my cloudy brain from yesterday, this was not done from my office. It was done from the office of the chief audit executive. And the work that the Morar had to do, because as management, we had done the work on the change in accounting policy. We were not asking them for an opinion on the accounting policy. We were asking them to review the work that, in terms of, okay, so we have done the change in accounting policy, so there is work
No,
that
it's-
has come out.
Yeah,
of
it's
them.
fine.
We were asking them.
No, it's
to
fine. Let us be
review.
economic with town. It's fine.
Yes.
But I want to ask you.
So I engaged with the chief audit executive. I'm not sure if Benis, you were in that meeting where we were discussing with. Were you in there? But I recall very well engaging with the chief audit executive on the misalignment between what Morar in terms of the terms of reference, what they were supposed to do and what they had done.
So you are saying
I engaged with him.
No, it's fine. I get that. So you are saying to us, you as a CFO at the time, you had powers to tell internal audit about the scope of work when they are engaging in a particular project in your office.
No. So they
how is
crafted the
so how is
scope
it
of work.
how is it that you were telling them that what Mora is supposed to do or not? Because that is supposed to be solo their decision.
No, the scope of work in this document and the report were misaligned.
No, Ms. Mabusela. I think we'll need to give you the scope of work and their audit memorandum, which they approve, Mr. Sensa, and they approve, the chief internal audit, is aligned with the report. It has two components. One, which it relates to the review of the application of IPSAS 42. Secondly, the review of annual financial statements, of which I'm still going to come to Ms. Benis, because I asked her again and again. I told her even yesterday, it was for the second time. I told her that it has never happened before. I have never heard that where you do a review before you prepare financial statement. Because in my mind, it had to be an exceptional case, that there's something that you were trying to find. Now I have established that internal audit was doing its work because of the material impact that this change, or this accounting, changing of accounting policy would have had in your financial, in your AFS, which is required, by the way. Which is required. It's a standard practice that internal audit, before you change an accounting policy, they need to review for them to provide quality assurance that the work that you did is adequate. Now, Mr. Sonsande is doing that work. I'm asking you, where did you get the powers to instruct internal audit to withdraw their report? This was not a moral report. This was an internal audit report.
Honorable, can I be allowed to read the scope just quickly? All right. So the scope of this assignment with Morar is to assist in developing and applying accounting policies for the social benefit disclosure that are fit for purpose based on the letter received from the Accounting Standard Board.
Don't have to continue. But Mora, in his report, they reply to and tell you that it's not possible.
So the EXCO had taken a decision.
So the EXCO, so the EXCO takes a decision on internal audit work. Is that what you are saying?
No.
Look. Let us put this by design, maybe for everyone to understand. Internal audit in any organization stays alone. It's not part of management. It reports directly to audit committee. The reason why it was designed like that was for it to do its work objective and independently. That is very important. Now, I'm trying to understand here. What I'm trying to understand. Internal audit, according to its work, because you were changing an accounting policy, which was going to have a material impact in the outlook of your financial statements, they correctly did their work, which is to provide quality assurance. Now, when they were providing the quality assurance, they asked Mora to check, to look for this. And if you look at that, they are even giving the copies of from ISB to Mora according to this and their RFQ. Actually, what we are reading from Chair is their internal audit planning memorandum. It's not actually there. Now, They give the scope, but Mora replies to them, which Mora was correct, 110%. That according to the way that draft is designed and how legally the status that it currently have, there is no social benefit scheme. That is why they even went further to say it's not applicable. If you look at their report, they gave you all elements in terms of why they are saying that IPSAS 42 cannot be used in the report that they gave you. Internal audit, not more internal audit. Now, I'm asking you, as management, who gave you the powers to instruct internal audit to withdraw a report?
As I indicated, Honorable, the EXCO had taken, I wouldn't say a decision, should I say a recommendation. We had agreed at EXCO that we are taking a recommendation to the board. So EXCO had agreed on the change in
what is the use of internal audit
policy.
It's fine. What is the use of internal audit?
It's to review the work of the
it's to provide quality assurance and consult on your behalf. Now, when they are doing their work, you are saying they are wrong. That's exactly what the ESCO was saying. Was saying internal audit is wrong. We are continuing to change, even if we are telling us that it's wrong to change.
Okay. In the EXCO, we had Mr. King as a member of the EXCO. He never raised the issue that he is going to request the service provider to do a review on the EXCO decision of going to change the accounting policy. That's why when I rely on this document to look whether the assignment for Morar was requesting them to look at whether the management is correct in changing the accounting policy, or whether they were supposed to review the work that we had done in preparation of change of the accounting policy. And the document that I have here doesn't show that Morar was tasked with reviewing the management or the EXCO decision to recommend the change in accounting policy. Had the chief audit executive, Mr. Madonna, confidently, or even at least, even if it was not confident, had he raised the fact that he wants to review the EXCO decision on changing of the accounting policy, I don't think we would have pushed him to say no. But it wasn't, if you look at our EXCO minutes, you will not find anywhere where the chief audit executive, he doesn't have to refuse and say no, but where he at least indicates that, colleagues, sorry, you can't take this decision. I want to assist you to review it.
No, Ms. Mabusela, I think you are losing me. Let us start like this so that I try and yeah. Usually, internal audit, when you are making a change in accounting policy, which will have a material impact in your annual financial statements, this is in line with any other project that internal audit do, because they usually develop a risk-based plan, which they develop it according to your based on your risk register, strategic risk register that you would have, and then they develop a plan based on the risk that exposures that are there, obviously the inherent vis-a-vis the controls that you have, and so on and so on. Now I'm saying to you, here, when you are changing an accounting policy, the last leg after the work that you and Ms. Penis would have done, then would have to submit what you would have done to internal audit for, obviously, for review and for them to provide a quality assurance. They usually call it consulting services. Not necessarily that they were auditing you, but they would provide you consulting services. And ESCO, because I'm questioning myself, another side of the coin, based on why did ESCO take this decision? Because the ESCO cannot take a decision based only on the report that is prepared by both of you. It needed to have internal audit review report that says we of the opinion that this is correct or not correct. And Mr. King prepared a report that said you cannot change. Because if you look at the scope, that's why I was asking Ms. Penis. I kept on asking again and again, what was the scope of work? The only scope of work you kept on referring me to was the 3.6. And if you see that there are 5 points above, all those 5 points, they relate to the change in accounting policy, nothing else. Because if you look at it, the one that you were reading, they are saying they are not going to say in their notes, check if it's correct to change to IPSAS 42. Obvious, that's not how you write an audit planning memorandum. But they are saying that assist us in developing and applying accounting policies for social benefit disclosure that are fit for purpose, based on the letter received from Accounting Standard Board, which they attached the letter, that we were referring to. They further go on to say to review the recognition measurement disclosure required for claims liability based on the updated policy and provide guidance on the adoption of the policy. You review first if the policy is correct, which policy will be correct for us to implement as a benefit for our benefit disclosures. Secondly, they go on to say you must check for us now, how do we do this? Thirdly, they go on to say taking into account, okay, they explain a particular section in road accident fund which states that and so on. Then they even go further to provide guidance and review the disclosures required in line with the change in the accounting policy. All those things, the Directive 5 that we were reading yesterday, GRAP analysis in compliance with Direct 5 and GRAP standards. They go for this. What internal audit is basically saying here, internal audit is basically saying to this service provider, go and check for us if this IPSAS 42 is applicable to us, is in line with the PFMA, which guides all public, and which is what is used by National Treasurer to prepare financial statements. Are we in line? Now, my question, you see now, this now, Chair, opens another element that I have never ever in my life heard management, ESCO, board or whatever instructing internal audit to withdraw their report. It's for the first time at RAF. I must say that. Chair, I think we can canvass the matter the whole day, because the scope is here in the audit planning memorandum. It was signed by RAF King, Chief Audit Executive of RAF. It was signed by the service provider. They delivered according to the scope. The explanation that we were being given that it was not in the scope was misleading Parliament.
Thank you. I would like to give Ms. Mabusela one more chance, because I do have questions that relate to this myself, and I really want us to be honest with one another, all of us. But please go ahead.
All right, thank you, Chairperson. Chairperson, the scope of this assignment in terms of 3.1, unless if my English is failing me, it reads, to assist in developing and applying accounting policies for the social benefits disclosure that are fit for purpose based on the letter received from the Accounting Standard Board. My understanding is that the minute there's that social benefit, it means that we are talking about the IPSAS that we have implemented.
Sorry, so what will help us, Ms. Mabusela, I'm trying to assist you here and the rest of us here. So it's to string the timeline together, right? So let's leave the substantive matters out for now. Let us now work with timeline, okay? The timeline, so we just need to know when the timeline begins. There is the request for quotation of the 24th of February 2021. That was closing on the 5th of March 2021. Can you recall? Lwazi, can you give them a copy? This copy. Please give it to Ms. Potgieter and give it to Mr. Modiba. Okay. Give to Miss Manyasha shame. You know, she's already like looking left and right, like she's watching Formula One cars drive past, you know, like watching tennis. I don't want her watching tennis. Okay, colleagues, what's going to help? And Honorable Matuna, you'll therefore still be on the floor, in a sense. But I need us to just untangle the timeline. So to any of you, and I think Ms. Potgieter, you were not yet CFO at the time, right? Yeah, but this is for your interest. So 24th February 2021. Can you see that at the top? Is that the RFQ that produces the Mora report subsequently withdrawn?
I have never seen this RFQ at all, Chairperson.
Oh, that's okay.
Yes.
No, if your answer is I don't know, it's fine.
Yes, this document, I've never seen it.
Yes, okay, no, that's fine. There is just a string. So can we then all mark for now this document as the beginning of the process? Because I am not aware of anything done prior to this date that relates to Mora and AFSs and so on. So let us mark this. Then Mora deliver a report. I just need to check that whether we received this from the RAF or from Mora, because then it would solve the problem. This RFQ. So this RFQ, so for everybody's comfort, this, after yesterday's conversation, we asked Mora for the RFQ they responded to. It's this one. Okay? Honorable Maduna, do you have it in front of you?
Actually, Chair, the RFQ is the same as what is in the internal audit planning memo.
No.
Yes,
of
yes,
course.
I did receive.
Yeah, so you've received it. So this is the beginning of the process. So on the 24th, so this RFQ is then signed by, okay, I don't see who signed it, but I'm assuming it's the internal audit function, the chief audit executive or an agent thereof within the organization. So this is the beginning. This RFQ produces a report by Mora, right? That report by Mora is dated the 8th, is the technical opinion. They have dated it the 8th of April. So this RFQ closes on the 5th of March. They take a month and 3 days, which appears to be a reasonable period when you're applying yourself to something so important. They present a technical opinion. It's prepared on the 8th of May, right? And that is the document I asked you, Ms. Mabusela, to read from. Remember when I said point number 4, overall conclusion, that is the report. Okay, this is point B. You, Ms. Mabusela, and Ms. Potgieter, 4 days later, on the 12th of April, meet with Mora. You remember that, where you said to us you had a professional conversation, you had a back and forth as professionals and so on, and you guys prevailed on them, and they agree No, sure. Let me just finish the story. They then agreed to withdraw the document they had submitted on the 8th of April, right? That was your version, and I'm going with your version, not with Mora's, because that specific contention is not so critical for the purposes of timeline. So you meet with them on the 12th, and they agree to write a letter on your version. That letter is this letter that I had asked you to read yesterday. It's written on the 13th of April. Okay. We now have a chain of events. We've got the RFQ issued on the 24th of February, closed on the 5th of March. Mora deliver a report on the 8th of April. 4 days later, you and Ms. Potgieter, I don't know who else was in the meeting, meet with Mora, and Mora on the 13th of April, the next day, withdraw this. Following that, or somewhere thereabouts, there is another RFQ issued, which then occasions PwC's involvement, where they then submit their report to you. Remember that conversation we had about issuing RFQs before a board meeting, when would a decision have been taken, etc., etc. The board meeting was to be on the 28th of April. It also happened to be the date on which the PwC submitted their report. The Audit and Risk Committee meets, to the best of my recollection of PwC's presentation, on the 13th of April. Right. The Audit and Risk Committee, so this accounting policy discussion goes to the Audit and Risk Committee on the 13th or the 14th of April. So we now have a chain of events. Let me go back to it again. First date, 24th of February, RFQ issued. 5th of March 2021, it closes. 8th April, Mora issued their report. 4 days later, 12th of April, you, Ms. Mabusela, and Ms. Potgieter meet Mora. You ask them to withdraw the report, or they agree, whichever version it is. Let's not contest it for now. The next day, or a couple of days later, the ARC meets to consider the change in accounting policy. Right? The board then meets on the 28th, takes a decision, but on the 28th, there is no alternative advice available to the board, because we know that Mora have withdrawn theirs, PwC have not yet submitted, because it is the same day they are submitting their response to the RFQ. Right. That's now the sequence. Forgive me a date or two from my memory. Right. Now we've started to draw out the picture. So Honorable Maduna here is raising an issue of a report that belongs to internal audit, that in a conversation between yourself and Ms. Potgieter, for some reason, they are asked to already withdraw the technical advice they provided, which I asked you to read. I am nearly certain that when the ARC meets the next day or a couple of days later, it does not have benefit of any technical advice. And the document on which the Chief Internal Audit Executive would have relied for that conversation has been withdrawn, in the sense that after that conversation with the two of you, they either agreed to or were asked or volunteered to withdraw. If we take all of these versions to be true, that's what we sit with at the moment, and we're going to take it further. But Honorable Maduna, I don't know if this is helpful. But I would like to ask the colleagues to comment on this timeline and this sequence of events, because it gives rise to a number of governance questions, which Honorable Maduna is able to canvass with you.
You know, Chairperson, how I wish, you know, I could have accounted for this, like when my memory was still strong on the matter. You know, I think it needs to be clear. Like, that's why yesterday I requested documents, because the Murar issue could not, how can I put it? It wasn't together in terms of my recollection. But now that I've got these documents here, let me clarify something. Firstly, I had not seen the RFQ because it would have been from the Chief Audit Executive. So these documents, they trigger in my mind to remember that the first time I met this particular issue, if I'm correct, because obviously if the Chief Audit Executive is doing their work, they are not doing it with me as the CFO. I'm recalling that the first time I met this particular document, because this one I know, was when I was called in the office of Mr. Letswalo, indicating that there's this Moral report from the Chief Audit Executive. So I'm saying it's coming now. And then he also indicated that the work that Morar was supposed to do is obviously not on the change in accounting policy, which I wouldn't leave it to him, because I also had to apply my mind, knowing that that change in accounting policy was done by the management. And when I read the scope, which is this particular 3.1, it indicates there that we are asking them to assist in developing and applying the policy, because now we have selected the standard. So we are asking them to develop and apply the accounting policy for the social benefit disclosure. Though on the RFQ, Mr. Maduna, I don't know if you have seen that the RFQ and they don't read the same, because the RFQ does not have anything. It doesn't say social benefit disclosure. You know, it's just saying applying accounting policies that are fit for purpose. So then I then got hold of the Chief Audit Executive before we had the meeting. Now I'm recalling, and maybe Bernice will clarify. I don't think Bernice was in the meeting, or if she was in the meeting, chances are that she wasn't the one participating strongly in the meeting. I met with the Chief Audit Executive. We discussed this without Morar, and obviously I was trying to seek clarity on understanding why Morar has come up with a technical opinion on the changing of the accounting policy. And in that meeting, both myself and the Chief Audit Executive, with obviously the conversation that we had, he agreed that we go. Now, actually, I remember I'm not even the one who organized the meeting with Morar, because the Honorable Maduna is correct, because this is not my project. It's the project of the Chief Audit Executive. But the Chief Audit Executive did not object or did not bring to my attention that, look, I understand, CFO, you have done the work, but on my side, I have requested Morar to relook at this. So he definitely then agrees that we meet Morar. So my recollection now that these documents are here is that myself and the Chief Audit Executive, we met Morar and we then addressed Morar together, Chairperson. So I think where there's a part that actually even makes me so uncomfortable is that should I have known that the Chief Audit Executive stood by his position, because had he given me the clear indication to say, don't say we did not ask Morar for a technical opinion. We did ask Morar for a technical opinion. I could have said to him, look, Chief Audit Executive, come, let's go to the CEO, because the CEO is perplexed, the word that he uses a lot, by this particular report. So I don't know why he agreed that we go and meet Morar, and both of us addressed Morar, and Morar then agreed to withdraw this document. And thank you very much, Chairperson, for providing me with these documents. I did indicate that at RAF, one would deal with a lot of things in a very short period of time. And having left the RAF in the condition that I was in terms of the anxiety and all, Chairperson, pardon me that my recollection of this was poor. Now at least it's
don't worry.
Coming back.
Don't worry about the recollection. So we are going to assist you.
Yes.
So I need us to have a different conversation. One about how we get to this RFQ. And I need. So when did you become CFO for the first time, Ms. Mabusela?
I got the date from one of the honorables, 2nd of June. 2nd of...
3rd of June 2020.
Yeah.
No, thank you. Replacing Mr. Songelo.
Yes, Chair.
Okay. Who initiated the process of considering a change in accounting policy? Who initiated that? So in other words, the conversation did not exist at the RAF at all, at least in writing or in terms of taking action. There might have been conversations about, we should be a social one. Yeah, that's fine. That's par for the course. I also want to drive on the right-hand side of the road. I discuss that with people from time to time. But the initiation of the process,
obviously,
do you know who initiated that process? Who says for the first time in a meeting, we now need to activate consideration of changing an accounting policy? Because things escalate very fast from there.
Chairperson, I hope I'm understanding. I'm going to attempt to answer. If I'm answering wrong, you'll correct.
Yeah, so let me put it to you this way. Who spoke to you, at least you formally, for the first time about it?
Mr. Letswalo, but not saying we are changing the accounting policy, indicating his concern around the RAF being a social benefit fund or an insurance, and requesting me to go and check, look at whether the standards that are applicable are relevant to the road accident fund. So I would say, Mr. Letswalo, but I can't say he's the one who triggered the change in accounting policy, because it first starts with the issue of the social benefit or insurance.
Okay. Mr. Modiba, you were on the EXCO at the time, is that correct or not yet?
I think I joined the EXCO as a member, full-time invitee, around August or so in 2020.
Of 2020. So when you joined the EXCO, is this conversation live on the EXCO, or is not something that your recollection does not save on the EXCO?
Yeah, it is. It is live. It is live.
Who drives it? I mean, you know, on the EXCO's agenda, every agenda item has an owner. Who was the owner then? And I appreciate that you had a different role.
Yeah, I think my recollection is that Ms. Mabusela would have been given a task to research on the best standard for reporting purposes on refs liabilities. So she would have been the anchor to the process.
Okay, so we're getting somewhere. Does that assist you, Ms. Mabusela, at all in terms of the recollection? I said we would assist with recollection, so don't stress too much about not remembering details.
No, it's correct, Chairperson.
Okay, so we know that from at least now, and I'm not saying it began with Mr. Modiba's recollection, but when he joins the EXCO, somewhere thereabouts, at the very least on his first EXCO meeting after, then this becomes something that is discussed. You are the Chief Financial Officer, and you are tasked with, and you mentioned yesterday that you and Bernice did research and so on. You were doing all sorts of wonderful things, right? So now we've now taken it back a little bit, and we understand your involvement predates that. Are you able to recall at which point the Chief Audit Executive is given the task of sourcing some kind of technical advice? Because I am not certain that he would have just, or she, been sitting somewhere there and then decided, I'm bored today, let me go and seek. Because there's already a process going on. So can you just assist us in that? Do you have any recollection of how we get there?
No, Chairperson, because there hasn't been ever on any EXCO a request of that nature. If the request happened, it would not have been in EXCO, because I was present in all of those EXCO meetings. Thanks.
Okay. So look, Honorable Matuna will come back and deal with whatever other matter. So I think we now know, right, that the sequence of events begins on the 24th of February. It takes us to the 8th of April, when Mora submit their technical opinion, which we read. On the 12th of April, they withdraw that technical opinion, right? The versions differ as to what triggered that, but Mora withdraw that technical opinion, and then soon thereafter there is a PwC. Sorry, soon thereafter there is an ARC. I think if you compare the PwC RFQ and the Mora process, I don't suppose that the Mora report would have served before the ARC, because it had now been withdrawn.
Correct, Chairperson.
Okay. So now, Honorable Maduna, what we canvassed was any prior discussion, and the discussion appears to have already been going on or about August of the previous year in the executive committee. Ms. Mabusela could not recall, at which point the Chief Audit Executive would have become involved. What we are left with is that the audit planning memorandum, review of annual financial statements for the year ended 31 March 2021, happens between the closing of the RFQ and the dispatch of the report by Mora on the 8th of April, because this is dated 31st March 2021. And I don't work in the finance environment. I had undertaken to just string the timeline together. So, Honorable Matuna, we now have a timeline that can be somewhat helpful. The only concern I have is that and this is something we'll discuss with the board, that you would expect an organization that properly considers decisions, that the Chief Audit Executive and the Audit and Risk Committee have a process that assists the ARC to make the right recommendation to the board, the best recommendation to the board. The chair of the ARC, I would assume, becomes the one who owns the discussion in the board meeting about the change in accounting policy. Part of what needs to have occurred, at least had the Mora report not been withdrawn, is that their conclusion that further legal advice was needed, that would also have gone into the pack of the board at least. Assuming it was missed in the ARC, my worry is that the ARC conversation and the Mora discussion, I think it was on the 21st of April, the Audit and Risk Committee. This all happens in short order. It's a very rushed process.
Sorry, Chair.
Please go ahead.
You see, what is very important, Chair, is that the technical opinion was issued on the 8th of April. They withdraw it on the 16th of April. The ARC was on the 25th. So you are correct when you are saying the audit committee never received this opinion. And that is where the problem was. Now, the bigger question that you would ask, we would have to ask, Chair, going forward, how did the CEO get hold of this technical audit opinion if it had not yet been tabled in the audit committee? Because it's not supposed to have it. The project of, and another very key aspect that is very important that we need to establish, the project by Mora and the project by PwC are two different projects. That's what I'm establishing now, from two different departments.
So Ms. Mabusela, let me just ask for the removal of doubt, and then we'll move on. So PwC get commissioned by whom for the work that they did? Who owns that RFQ that results in PwC?
Chairperson, I would prefer to get the RFQ and rely on the document.
Let me ask the question.
Because remember, I had even made a mistake to think.
No, it's okay.
Morar was from my side. So
no, don't stress.
Yes.
Don't stress, Ms. Mabusela. Yes. Let me ask the question differently. Were you the executive responsible for the PwC report? Because it happens while you are still there. You are still the CFO, are you not?
The PwC report, I don't think so. I don't.
When did you leave the RAF?
7 May
2021.
2021.
No. Then the RFQ happens while you are still CFO.
I would assume so. Yes.
Okay. All right.
Yes.
Honorable Matuna, I don't know if
sorry, Chair. You mentioned an August. In your timeline there, you mentioned a month of August.
No, I mentioned April. I might have misspoken.
Oh, sorry.
Yeah.
Because
the latest date in my head, in as far as the accounting policy change, is the 28th of April, and then PwC submit their report on the 20. They submit it in May. So the
Correct.
RFQ closes on the 28th of of April, and then they submit their report in in May sometime. I don't remember off the top of my head. Yes, so I'm sorry if I mentioned August.
And Chairperson, if it relates to PwC and you asking if it's in my office, maybe also Ms. Potgieter can assist. Yeah.
Yeah, Ms. Potgieter, how's your recollection of this whole thing?
So just for the RFQ that results in the appointment of PwC, we did use internal audits panel, but it was within the office of the CFO.
Okay.
It rings a bell, Chairperson.
Okay.
Thanks.
No, that's fine. Honorable Madun.
That's what, Chair, I'm saying. Because even if you look at their report, in terms of the way, there is a difference between the advisory when it's from internal audit and the way in which PwC prepared their report. That's how I established that the two reports were commissioned from two different departments. Now, Chair, I think it further complicates it, and I think what we will now need to have maybe the chief audit executive, because one, I think we need to establish if the more technical opinion, did it get to the ARC? If it did not, it then absolute, it then absorb the ARC itself, because it did not have the advice from internal audit. The question now becomes, so it means then they would have changed an accounting policy which had material impact in their financial statement without an internal audit opinion. It's another issue.
Yeah, no, I agree, Honorable Matuna. So, look, I don't know if there's any value to carrying on with this any longer. I think there's certain additional information that we'll need from other people. Okay, let's leave it here, I think. Are you Honorable Bill and Honorable Matuna?
No, Chair, I think the cover that covered Mzala has also covered
you.
Okay. So I don't know if there's anything for you, honorable members. I only have one last issue, and it's detail, and it could be that I am forgetting from our previous conversation. Ms. Hlamimate, when she was here, she told us that the Media Mix 360 process came about because the chief executive at the time had felt that GCIS was not the right agency to use for media placement. So I'm just giving the background. They then went and tested the market, and GCIS came tops. They were nonetheless instructed to go out on tender. The whole process was issued. We've got all of the documents. It goes through all of the steps. She then says they present to the BAC. You are in the BAC, Ms. Potgieter. The only thing I want to know is whether the issue of the fact that there had been the option to use GCIS, and it was the most cost competitive process, and nonetheless they were instructed to. Was there discussion around whether this is the cheapest option? Because it now becomes the cheapest option in the context of bids rather than cheapest option in terms of, and I asked her a specific question. I said, when the bids came, was GCIS more expensive than some? And she said they were still the most competitive. Are you aware of a discussion at the BAC? So we've got the minutes of the other meetings. Something seems to have occurred off the books, and I need to understand if your recollection of that discussion involves whether this should proceed at all or not. Because from then on it's recommended and then the expenditure begins, and the expenditure has been at a terrific speed.
Chair, I do remember us, and I want to say it's within like the first few months of me starting acting as the CFO, us discussing GCIS, but I must be honest, I cannot recall the cost benefit analysis. At some point there is a recommendation made by the BAC, but the comments that came back from the CEO was not about them not being cost effective. I believe he said something about them not having the capacity and capability of what is required, but I might be.
You don't want to hang yourself on that.
I don't want to hang myself on it.
You're trying to recollect. No, we can.
If I can get access to the minutes and the submissions, I will be able to submit them to the committee. But I don't want to hang myself on something that I'm not 100% sure on. But I do know we had a discussion at the BAC regarding GCIS, and. There were specific comments made by the CEO in that regard based on our recommendation.
Okay, no, that's fine. We will just have a look at the documents that we have, and look. We know you don't control the the BAC. You chair and facilitate the process. Honorable Matun.
No, thanks, Chair. I'm just remembering, so just two questions, final questions. One, I want to check, in line with the RAF, it's Form 1, it's RAF form, yeah, that form. There's just been a lot. Now, I want to check those claims that you usually don't capture because they are missing documents. Do you include them in the, do you have a value of them? I'm asking that because I want to check, do you include some of them or a certain percentage in your provisions? That one. Two, Mr. Modiba, I see in the statement by the minister in when he was announcing those financial statements that you've made a profit after many years. I see that it speaks about economic inflow from investments. Did you have any investments?
No, Honorable, we didn't. I think the issue of investments, when I spoke about it the other time when I was here, I was saying that we have a call account that we put monies in, and that's it. So there was we did not actively get into the investment market. Thanks.
So the same cover that covered Mzala has now covered you. It's a very big cover. It covered Honorable Pilar too. Okay, I think we are done. So I want to thank all of you. I really promise if we have to call any of you, it will be a completely unavoidable reason. The only thing I would want to encourage you to do, and Mr. Modiba, we've got your affidavit. It goes on to the record. We are compelled to consider it in full in considering our report. Ms. Potgieter, similarly with the presentation that you prepared, when we write our report, you will be sent a draft. And the reason we're sending you that draft is so that you may comment on the parts that implicate you that mention you. Let me not say implicate, that mention you, right? And the issues that you might have testified to or made a submission about. the intention with that is that you then get to make representations on that to say, I feel your observation is incomplete because you did not consider 1, 2, 3. Alternatively, I think your conclusion does not take into account the following, right? So that our report is fair. You are also welcome, and I hope I'm not speaking out of turn, so I'll look at Ms. Ibrahim, because at the end of the day, we have to have recommendations that are useful in terms of assisting the Road Accident Fund in its work, right? To the extent, so because you worked there, and if even now, if you've got any recommendations in terms of things that we should consider in our report that would make the Road Accident Fund work efficiently in terms of its operations, technology, cost, etc., we welcome those. You can just transmit them. So as you reflect on our conversations, you are welcome to do that. The last thing I wanted to say is just an observation. So I had a look at your annual report, and one of the things I'm passionate about professionally is organizational development and employee wellness. And I looked at the Road Accident Fund's HR report at COVID time, immediately after COVID, because COVID was stressful for people. And then this year, no, you don't need to have a look at it. We're now having a conversation because I want to make a final comment and then we go. So it used to be that relationship issues were number one in terms of the wellness issues that the RAF dealt with. And I remember during COVID, people were stuck with partners they didn't like, or kids they realized they actually hated, or the kids hated them. Oh, I don't really like my cousin. I thought it was okay, but I'm now stuck with him all day. So I get all of that. But it really was relationship issues, was a range of issues. In this report, mental health is by far the most significant issue at 262. The nearest to that is relationship issues, and then the workplace issues, personal development, etc. As a person who by training is a communications professional, it is always my preference that an organization stays off the headlines. I really want to say I wish for three things for the Road Accident Fund. One, for it to be an institution that facilitates the claims process in as painless a way, if you can afford it, you can achieve it as possible at the lowest possible cost. The second thing that I really wish for is that that mental health issue really disappears into one of the smaller issues, which is an issue of organizational environment, organizational culture, and so on. And I think one of the ways in which that will happen is if you also have permanent leadership. There have been too many actors for too long at the Road Accident Fund. That on its own can create instability. And the final point is that I really am also looking forward, and I'm sure the members are the same, where we only see you once a year when you're presenting your annual financial statements. Those are my three wishes for on behalf of the claimants, the staff at the Road Accident Fund, and also just in terms of the reputation of the Road Accident Fund. I know there is a lot of turmoil in the institution. There has been for quite some time, but I also want to say that personally I wish all of you all of the best in everything you do within the Road Accident Fund and elsewhere. This process has to be rigorous as far as possible. Personally, I don't have bad personal feelings against any of you, and I wish to assure you of that. So when you see me at the mall wearing shorts, please greet. I will not walk past you and not greet. But clearly there are some tough issues that we have to deal with, and I think for the members it is the same. There are some tough issues that we have to deal with, but we will get over. We will get over this, and the Road Accident Fund will be fine. And our friend Mr. Kupega will be back here to wow us at some point in the future with ICMS, and we throw confetti at him. So, and his colleagues. So thank you very much, colleagues. I just want to say we really appreciate you in the sense that you've availed yourself. It's a tough process. It's exhausting. And I admire you for doing that. So thank you very much. I really appreciate it. Honorable members, 10 times more to you because it's been weeks. So I appreciate you too, and the colleagues from Parliament. Thank you. We can adjourn.
Thanks, Chairperson.